The Committee on Criminal Jurisprudence will come to order. The clerk, please call the roll.
Chair Smithy,
Here.
Vice Chair Wu, Representative Bowers, Representative Cook. Here. Representative Jones. Present. Representative Little. Here. Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Verdell. Six.
Thank you, members, and thank you to all of our authors and to our witnesses. To the witnesses, we apologize for the late start. It was beyond our control. We appreciate your patience and your willingness to stay around. The committee is going to try to get you on as quickly as possible. We have imposed a 2-minute time limit on witnesses, and tonight I'm going to have to be very strict on that. I'm not trying to be rude, but we will cut you off at 2 minutes so that we can move on to other witnesses. To our committee members, I would just ask you to be judicious with your questioning in light of the time constraints that we have, and if there's something that can be resolved offline, let's try to do it offline as well. A couple of other things that I need to announce. Number one, we're glad you're here to testify. If you're intending to testify, if you haven't filled out an electronic affirmation out in the kiosk in the hallway, if you would go ahead and fill that out, because we can't let you testify until you actually fill that out. Also, if you do not wish to testify, but you do wish to be shown in the record in support or opposition to a bill, if you will, you can fill that out on your affirmation, and if you don't, there's no need for you to testify if you don't wish to. One other announcement is that House Bill 867 by Representative Jones, which was on the agenda today, has been withdrawn from today's agenda. At her request, it'll be reset at a later date, probably next week. So if you're here for House Bill 867, it will not be heard. I need to do the corrected minutes.
Yes, it's right here.
I've got one housekeeping thing that we need to do. We've got an error in our minutes that we need to correct. The chair moves to correct the minutes for the meeting held on May 20. It's not May 25th. It's March.
I'm sorry.
Okay. For the meeting held on March 25 of 2025, is there objection? The chair hears none, and the motion prevails. The change made is clarified. It's a clarifying correction. Had the just incorrect subcommittee name in the minutes for the bill. The minutes said new offenses and penalty changes. It needs to read new offenses and changed penalties to reflect the accurate name of the appointed subcommittee. Is there any objection to the correction of the minutes? If not, we will correct the minutes. The other housekeeping measure that we need to do is to make several referrals to our subcommittee on new offenses and changed penalties. And those would be the following bills will be referred to that committee. House Bill 2197 by Money, House Bill 3098 by Bell, House Bill 3242 by Moody, House Bill 3425 by Capriglione, and House Bill 4414 by Alders. So those bills will be referred. And so at this time, I think we're ready to, one other thing, we'd scheduled some bills for a vote today, but because of the late hour, I think it's probably best to do a formal meeting tomorrow. I'm sure we'll have some lulls at some point tomorrow. And so hopefully we'll get a place like the Ag Museum or somewhere, and we will make an announcement and hopefully get the House to permit us to meet while the House is in session. So at this time, the chair would recognize Representative Canales. Is
I'm here.
Okay, if you'll come on up. You have no witnesses, so you're really high on our list today.
And I will be brief because I want to eat too. Which bill, Chairman?
Okay, the chair lays out House Bill 1650 and recognizes Representative Canales.
Thank you, Mr. Chairman. Under the current law, bondsmen have 2 years after a final judgment is entered for a bond forfeiture. A special review can allow bondsmen to receive all or part of their surety back, and interested parties claim that under the current law, bondsmen no longer have any incentive to track down absconded defendants. This extends the time period for which a bill of review can be filed. Stand for questions.
Any questions, members? That was a brief layout. Let me ask, is there anyone here to testify for, against, or on House Bill 1650? If not, you're here, so go ahead and close.
Close.
Okay. Thank you, and if there's no objection, the chair will leave House Bill 1650 pending. And now the chair lays out House Bill 3449 and recognizes Representative Canales.
Thank you, Chairman. Two Texas counties are facing serious jail capacities, forcing them to house thousands of inmates outside their counties. And according to the August 2024 Tribune report, inmates are being held in many out-of-county facilities. To fulfill their constitutional duties, court-appointed attorneys have to travel long distances. And what this does is attorneys representing indigent clients are often paid flat fees, for example, $150 to $250. There's a clear cost for court-appointed attorneys to travel to meet with their clients. And so this just seeks to reimburse court-appointed attorneys for their expenses incurred in communications with clients held more than 50 miles from the trial court in an out-of-court facility.
Okay, any questions, members? Mr. Little has a question.
Representative Canales, is that a thing? Like, how far away do you get court appointments?
So in Hidalgo County, people get a court appointment in Hidalgo County. They often have to travel to Brooks County, which is over an hour and a half, could
Oh
be an
my
hour,
gosh.
or to Starr County, an hour, or to Raymondville, an hour. And so it's a real thing.
So is that just because the lack of defense counsel are taking criminal appointments in those
No, it's
counties?
because the jail's overcrowded. For instance, Operation Lone Star has basically flooded us with defendants, more DWIs, more all sorts of more offenses because there's more law enforcement. And so because they don't fit in Hidalgo County, you've got to travel to where they're at. And so currently there's no real reimbursement mechanism for that. And so what this does is try to solve that and allow attorneys to be compensated for their travel time, because right now they aren't.
Thank you for explaining that.
Ms. Jones?
Really quickly, some places don't have a lot of court-appointed lawyers, it's just aren't a lot there. They try to get you to come there, and I have, and you gotta get up really early, and you gotta spend money for gas. And for me, like, I wouldn't do it if I couldn't be reimbursed.
Yeah, it's a real problem in the rural counties. You know, there are just no lawyers, and there are no criminal lawyers, for sure. Any other questions for Mr. Canales? Okay. Anyone here to testify on, for, against, or on House Bill 3449? If not, Mr. Canales, if you want to close.
I close.
Okay. And now if there's no objection, House Bill 3449 will be left pending, and the chair lays out House Bill 3477 and once again recognizes Representative Canales.
This was brought to me by a constituent. Basically, what this allows is an expunction for contempt of court if you haven't had any sort of issues in 40 years. And so traditional criminal offenses, contempt charges often stem from noncompliance or some other civil procedure. What this does is seek to allow somebody to clean their record of a criminal, I'm sorry, not of a criminal, of a contempt of court charge if they've not had any sort of subsequent offense in 40 years.
Okay, and so basically, it would allow a petition to expunge.
To expunge just a contempt of court, not a criminal, basically and so it's on your record. If you've been held in contempt, that goes on your record for life. And so many of those are, having an argument with a judge could get you in contempt of court.
Yeah.
And so this gives you a 40-year span to behave yourself before we allow you to clear it.
Any questions? Yes.
Mr. Canales, have you had any such experience?
I've got a constituent that has, but have I ever been held in contempt? I've come real close.
And I think I know your constituent, but anyway. Any other questions, members? If not, is there anyone here to testify for, against, or on House Bill 3477? If not, Mr. Canales, if you want to close.
I close.
Okay.
Thank you,
very
Chairman.
much. And if there's no objection, the chair will leave House Bill 3477 pending. And let's see, who do we, that else is quick. Mr. Wally, I think you're up, okay. Okay. At this time, the chair would lay out House Bill 3463 and recognize Representative Wally.
Thank you, Chairman Smithy and members. House Bill 3463 is a cleanup bill that seeks to expand the modes of communication for victims of theft of service. Last session, we passed HB 2897 to expand which records victims can use when sending the demand letter. Now we are working to expand how they can send that letter. Many workers fall victim to theft of service when they perform a service for a client, yet receive payment with a check with insufficient funds, commonly known as a hot check. Filing a criminal complaint for the theft of service or for a hot check requires a victim to send a demand letter as an initial step. Right now, the theft of service provision of the Penal Code requires this demand letter to be sent through registered or certified mail or commercial delivery service. This creates an unnecessary hurdle for these victims. Theft of service is a serious concern, and we should make it easier for the victims to seek justice that they deserve. Under the current law, the Texas Penal Code Section 31.04A4 requires proper notice demanding payment to be sent out by victims through registered, again, or certified mail or commercial delivery. So what we're trying to do with this bill is allow victims to send notice through electronic communication, such as an email or a text message. And with that, members, we're glad to answer any questions. We're just trying to make sure we make it easier for the victims of this crime to be able to get paid when they are doing the service and perform, and they're not getting the return
Okay. Any
in their
questions for
dollars.
Mr. Wally? Okay, if not, we've got one witness.
Thank you.
So the chair would call Stephanie Garkanian. And if you'll have to say your name, but I'm showing that you are registered representing the Travis County District Attorney's Office and self, and you are for the bill. Is that correct?
Yes, Chairman.
Okay. And if you'll state your name.
Sure. Good afternoon. My name is Stephanie Garakanian. I'm an assistant district attorney in Travis County with the District Attorney's Office in Travis County, and I'm registering in support of the bill and here on behalf of the office and myself.
Okay. All right. Any questions for Ms. Garakanian? Okay. We appreciate you being here. Mr. Wally did a good job of laying it out, I think.
Great.
Do
So
you have anything you want to add? Or?
I was just going to remind the committee that this is a conversation that started last session. It continued during the interim, and really the intention of this bill is to address the question that Vice Chairman Cook asked during the interim to really help make this an offense that's more accessible to victims of these crimes.
Thank you very much.
Of
Thank you
course.
for being here. Any questions? Thank you again. And so is there anyone else here to testify for, against, or on House Bill 3463? If not, Representative Wally, if you want to close.
Close.
Okay?
Well, wait a
So,
second, I've got a
if there's
question.
No objection, we'll leave House Bill 3463.
Sorry.
I'm sorry.
Sorry.
Mr. Moody?
Mr. Cook worked really hard on this in the interim. Have you invited him to be a joint author on your legislation?
We reached out to his office. We've been working with him.
No, thank you, I appreciate
He,
it.
Okay, thank you. for-
thank you, I close.
You want to-
Smithy.
The record will show that Mr. Wu is present. And so if there's no objection, the chair will leave 3463 pending. Mr. Anchia, let me get you up here real quick, and then. So at this time, the chair would lay out House Bill 2698 and recognize Representative Anchia.
Thank you, Mr. Chairman and Vice Chair Wu, members of the committee. I know everybody on this committee believes in individual liberty. There's no greater grievance against individual liberty and no more offensive overreach of government than to wrongfully incarcerate a person. The government takes your liberty, it must get it right, and this bill helps us get it right. I will note only in my layout, not go through the whole thing, but note that the Innocence Project estimates that there are between 3,000 and 9,000 people incarcerated in Texas prisons due to wrongful convictions. And this number should scare all of us. And the issue is that under current law, obtaining appointed counsel for a writ of habeas corpus is difficult, especially for indigent individuals who must present evidence of actual innocence or a constitutional violation before receiving legal help. Specifically, this bill establishes a process that allows judges to appoint counsel for indigent individuals when there is a potentially meritorious constitutional claim. And they have up to 4 remedies for the, four things must have happened in order for them to have this remedy. 1, there needs to be actual innocence of the offense. 2, guilty of only a lesser offense. 3, conviction or sentencing under a law later found unconstitutional. And 4, conviction or sentencing in violation of the U.S. or Texas Constitution. Members, I urge you to support this bill to continue the progress we've made since passage of the Tim Cole Act back in 2009 that many of you were involved in, and I humbly ask the chair for the opportunity to close.
Certainly. And any questions for Mr. Nchia? Ms. Jones?
You said actual innocence, only lesser conviction, you said two more?
Conviction or sentencing under a law later found unconstitutional.
Okay. And the fourth one?
Conviction or sentencing in violation of the U.S. or Texas Constitution.
Okay, thank you.
Thank you.
Okay. If not, we'll call witnesses.
Thank you, Mr. Chairman.
Chair calls Allen Place.
Mr. Chairman, members, my name is Alan Place, here on behalf of Texas Criminal Defense Lawyers Association in support of this bill. Just a couple of quick notes. This, of course, is a bill for habeas corpus relief, but I do want to know that the current law and the law that Representative Nchia is presenting, this is a unique situation where the state is bringing this motion, okay? And so, number one, that is what triggers it. I think the only thing that probably needs to be looked at is, to our position, is just whether it is a cleanup and basically does clarify about a potentially meritorious claim. Now, the four points in B1 that he just went over with Representative Jones, those are basically a rehashing of current law, so it's not breaking new ground here. But certainly, this bill recognizes that, as he said, this system is not always perfect, but it does give an opportunity in this limited instance to try and get it correct. So that's all we have, unless y'all have any questions about
Any
that.
questions for Mr. Place? Mr. Little?
Mr. Place, I've got some questions because I have a hard time understanding the application of, or the ramifications of the change in language. So this is changing the eligibility for indigent defense from a set of circumstances that's described under 11074B and changing it to a potentially meritorious claim for relief. What is the real effect of that?
Well, if I had a perfect answer, I would tell you. As I read it, the circumstance is many times you have a client in this situation, or basically if I get a client in this situation, to me, this broadens the situation of what I can be able to do, okay? I think that is a little broader than current law.
Well, so under the current law, it looks like it's very well defined. What might it be under Representative Anchia's bill that's more expansive than what's currently written in B?
As I read it, it simply probably just uses broader language in that respect. I think it does give you the circumstance to where I don't think I guess it depends on the judge that is basically going to consider an application. You know, have they come forward and put enough? And the challenge that I have, and I'm much more familiar with the administrative side than the actual writ side, okay? I want to give you that up front. But you also notice later in the same paragraph, it says the court shall appoint an attorney. The current law just says to represent. It also, he adds to investigate the claim.
That was going to be my next question.
Because the heart of the matter is that this is not something that you can just take and go and presume. A good writ is obviously going to take some investigation.
Right.
And candidly, in my experience in working with lawyers in this area, a lot of times there's an investigation and there's just nothing there. Sometimes there is.
Is the purpose of the change to the statute, or at least your understanding of the purpose of Representative Anchia's bill, to give the court a more liberal view of what it can appoint indigent defense counsel for?
I think that is fairly accurate. I think, again, in B1, I don't think you're plowing new ground, basically, in terms of the four areas. But I think that basically at this point, as I read this, is that, number one, this is triggered by the state of Texas coming forward. Okay, so the state has to trigger this to begin with, okay? And so in that scenario, if the state that is coming in, having already obtained a conviction, I think the idea here is that you do want it to be broader if they in fact are bringing the action.
Okay, that answers my question. Thank you.
You bet. Thank you.
Any other questions for Mr. Place? Thank you for being here.
Thank you, Mr. Chairman.
Our next witness, the chair calls Cynthia Garza. And your affirmation reflects that you're Assistant District Attorney with the Dallas Criminal District Attorney, John Crizo's office, and you are for the bill. Is that correct?
That is correct, Chair.
Thank you.
Thank you, Chair Smithy, Vice Chair Wu, committee members. My name is Cynthia Garza. I am representing Dallas County Criminal District Attorney John Crizo. I am the Chief Prosecutor of the Conviction Integrity Unit and have been with the unit since January of 2010. I've worked on the majority of the exonerations that have been come out of Dallas County, and I've been therefore in a position to review hundreds of cases submitted to the unit for review for actual innocence and wrongful conviction claims. So every so often, we come across a case where after reviewing the state's files and relevant litigation history, we believe that the pro se convicted person might have a meritorious claim, but we're unable to fully evaluate whether they actually have a meritorious claim. And this goes to the fact that when we ask the court for an appointment of counsel for an indigent person, to your point, Representative Little, that we, at the way that the current law is written, we have to affirmatively represent that somebody is actually innocent. And sometimes we just can't tell, and we need somebody on the other side, opposing counsel, to work the case, to investigate the case alongside so that we can determine whether or not this is an actual meritorious claim. Simply put, the state cannot bring forth an application for a writ of habeas corpus or represent a defendant. We just simply can't, even when we believe that there has been a wrongful conviction. There needs to be somebody who is representing that person at the trial court level for a writ of habeas corpus. So HB 2698 simply clarifies and maintains the original core narrow scope of the law. That the defendant must be indigent and that the mandatory appointment request must be made by the state in only certain limited circumstances. When the person is or may be actually innocent.
Thank you. Let me see
Okay.
if there's any questions, members. Thank you very much for being here. Members, we also have Scott Ehlers here, who is
Thank you.
here to testify as a resource witness. And you're Scott Ehlers, Executive Director of Texas Indigent Defense Commission, and you're testifying neutral on the bill. Is that correct?
That is correct, Chair Smithy. Thank you. Yeah, I don't know that I have much to add to the other witnesses beyond I just did want you to know that this legislative proposal did go through the Texas Indigent Defense Commission's legislative work group process, and this is a consensus-based process that we have. Our board, our full board approved this measure as well, so it's been fully vetted by all kinds of stakeholders, and to that point, the commission endorsed it, and I think the other witnesses did a great job of explaining what it does. Happy to answer any questions.
I think we understand it addresses a significant problem. So, yes, Ms. Jones.
Just really quickly, I'll say that I actually want to thank Rep. Chia for bringing such a good bill. As a person who does criminal defense, it's really hard, even when your client is locked up, for them to be able to describe like scenes or things like that. And you really do need somebody. The law library is very limited. There are just things they can't do, and they need someone who's a lawyer who knows what they're doing to do a proper investigation. We can actually have ex parte motions to get investigators, forensic experts, a lot of things that we can do that an incarcerated person cannot do, and we're just more likely to find out what the truth is. And I will tell you this, sometimes when you have an investigator, you find out your client actually did it, right? Which actually leads to police and exoneration. So thank you.
Sure.
Any other questions? Thank you, Mr. Ehlers, for being
Thank
here.
you.
Is there anyone else here to testify for, against, or on House Bill 2698? There being no one, recognize Mr. Anchia to close.
Thank you, Mr. Chairman and members of the committee. In my rush to try to get through my layout, Representative Little, I may have gone very, very quickly over a few facts, but this is post-conviction. This is on a motion of either a judge or a prosecutor, and it allows them to, for indigent persons, to appoint the defense counsel and then work in collaboration so they can investigate if there is a belief that the person is actually innocent. We've had that problem substantially in Dallas County. So thanks for your questions. Thank you, members.
Thank you. Anything else?
I close.
So if there's no objection, the chair will leave House Bill 2698 pending. The chair needs to recognize that Ms. Bowers is present. And so, let's see, let me get Mr. Leach. Mr. Leach, you want to come up and, is there any preference which bill you want to lay out first?
Your choice, Mr. Chairman.
Okay, well, the chair will lay out House Bill 2507 and recognize Chairman Leach.
Sure, Mr. Chairman. Vice Chair Wu and members, thank you for allowing me the opportunity to lay out House Bill 2507 before you today. Members, during the 84th legislative session, we passed a law entitling certain people to clear minor, low-level criminal records, but they face unnecessary barriers due to a costly and complex process. This bill is designed to allow the state to utilize technology to fully implement the intent of that legislation that we passed in 2015. The bill directs DPS.
Mr. Leach, before
Yeah,
you go any further.
there's a committee sub.
I'm going to let Mr. Cook lay out the committee sub.
Thank you, Mr. Chairman.
So I didn't realize we had a substitute, but we did. So.
Thank you. So the sub's before you now, correct?
Okay, yes.
Okay. This bill is designed to allow the state to utilize technology to fully implement the intent of the legislation that we passed in 2015. The bill directs DPS to electronically identify eligible records in the statewide database and to provide notice to the applicable clerk of the court on a monthly basis. The substitute before you clarifies that notices will be provided electronically and adds language allowing the Office of Court Administration to have a role in determining exactly what information needs to be shared between DPS and the courts. Importantly, members, the bill does not expand eligibility of non-disclosures. It simply updates our current system, making it more efficient and effective. With that, members, I'm happy to take your questions and would reserve the right to close.
Okay, any questions for Mr. Leach? Ms. Jones?
Specifically, what does it make DPS do?
So the bill directs DPS to electronically identify eligible records. So they're going to go through the records and identify which current records would be eligible for the low-level criminal records to be cleared. And then they must provide notice to the applicable clerk of the court on a monthly basis. So they would review and sign off on the cases and return an order to DPS for those records to be sealed, simply to identify which cases are eligible and to communicate directly with the court clerks.
Okay, thank you.
Thank you.
Anything else? Okay, we have a couple of witnesses, 4 witnesses, I
Thank you,
think.
Chairman.
Chair calls David Hart. And Mr. Hart, you have registered that you're appearing on behalf of yourself and you are for the bill. Is that correct?
That is correct.
Okay. Go ahead, you have 2 minutes.
Chairman Smithy, Vice Chair Wu, and members of the committee, my name is David Hart. I am here on behalf of myself to support House Bill 2507. I'm a business owner and a family man and someone who believes deeply in the values that make Texas strong: personal responsibility, service, and also redemption. I'm not proud of my story and how I started. I made mistakes as a young man, but I've spent the last 2 decades building a different life. I didn't ask for anything to be handed to me, but I did need the chance to rebuild. And I know there's thousands of Texans who have done the work and made the change. There are still carrying records that don't reflect who they are now. To be clear, this bill isn't about shortcuts. It's about recognizing the difference between a life that went off track and one that's been set straight. Automating this record sealing process to those who are eligible gives opportunities to people who might not otherwise have the knowledge or the resources to pursue this relief. Imagine the success and pride they'll have knowing that if they stay the course and stay strong, redemption will be near. Texas is already a leader in business and strength. This bill gives us a chance to lead in hope as well. I thank you all for your time.
Thank you, Mr. Hart. Any questions for Mr. Hart? Yes, go ahead.
Thank you, Mr. Hart. Just want to say, appreciate you coming. We've talked before, and I know My understanding, not just from you, but from others in your community, is you're a very valuable asset in your community. And would this bill affect you at all, or is this just going forward for future people facing this type of thing?
This one doesn't directly affect me, so to speak. With my record, it affects kind of the bigger mission that I have in life. Speaking on behalf of those individuals who I've met with in the county who has kind of seen this journey and the times that I've got to come visit with this committee. It opens the door and gives them an opportunity to do something that a lot of people don't have the knowledge and the resources, right? They're kind of spent whenever they go to find these things. So automating it and giving them an opportunity to clear this gives them a better chance to succeed in life.
Copy that. I don't have any other questions. I just want to say thank you for taking the time to come down here and your efforts to try to help a lot of other people reform. So, yes, sir.
Thank you. I appreciate that.
And I'll repeat it once again, thank you all for hanging on all day. I know that's not the easiest thing to do.
I had some great barbecue while I was waiting, so thank y'all.
Okay, thank you. The chair calls Tara Tucker. And welcome, Ms. Tucker. The record, your affirmation reflects that you are Texas State Director for the Alliance for Safety and Justice, and you're here testifying for the bill. Is that correct?
Correct, and also representing crime survivors for safety and justice.
Okay, so I need to get that on your affirmation. Does the clerk have permission to make that change on your affirmation?
She does, but it should be there. But she does have permission. Okay.
Say that again, okay?
Yeah. So I'm representing Alliance for Safety and Justice and Crime Survivors for Safety and Justice.
Crime Survivors for Safety and Justice. Okay, thank you. You can go ahead.
And we're for the bill.
Okay.
Alliance for Safety and Justice is a multi-state organization that works on public safety solutions that break cycles of crime and improve access to healing and supports for crime survivors. We work alongside crime survivors with almost 15,000 members of Crime Survivors for Safety and Justice in Texas. We also work with people living with past criminal records to reduce barriers to housing and employment. Our survivors agree that increasing access to jobs and stable housings provide the stability needed to care for yourself and your family, which helps us in cycles of crime. This bill creates a streamlined process for DPS in courts to seal records. I want to point out that this applies only to offenses that are already entitled to have their records sealed. So there's already a presumption that's going to happen if they meet the eligibility. So even though the process is automatic, like it's not changing who has access to that. We want to reiterate, it doesn't expand eligibility or access. And we've been working on this bill for multiple sessions. And I just want to say that every time it gets a little bit better. We've been working with DPS and the clerks, and I think we've really identified a process that is going to be efficient. It has the support of both of those entities. And if anybody has any questions,
Okay,
I'd be happy
any
to answer
questions
them.
from Ms. Tucker? Well, we appreciate you being here and waiting and to testify. Thank you. Chair calls Nikki Presley. And Ms. Presley, according to your affirmation, you are the Texas Director for Right on Crime and Texas Public Policy Foundation, and you're here for the bill, correct?
Yes, sir.
Thank you.
Thank you, Chairman and members. My name is Nikki Presley. I represent the Texas Public Policy Foundation, and we are in support of HB 2507. While many individuals are eligible to seal their record, a large population fails to do so. This bill would create a new state-initiated process to receive this OND or Order of Non-Disclosure for those who automatically qualify for one under Section 411.072 Texas Government Code. This bill is strictly process and does not expand who is eligible. It simply removes the burden from the individual of having to initiate the OND process. Of note, I do want to point out that ONDs are different from expunctions, as it does not completely destroy the record. Law enforcement, courts, and over 30 agencies can still see that sealed record. And as Tara mentioned, the bill has passed several times, and we've been working with stakeholders, and I think everyone is satisfied. And that is a flow chart to kind of give you a brief visual of how this process would work.
Thank you very much. Any questions, members? Okay, thank you for being here. Chair calls David Emmerich. And Mr. Emmerich, your affirmation shows that you're Executive Director for Government Relations for J.P. Morgan Chase, and you're also here for the bill.
That's correct. Thank you, Mr. Chairman. I'm Dave Emmerich with J.P. Morgan Chase. Members of the committee, thank you for being here. I'm going to take this from a little different angle. I'm here in support of the bill. Look at this from an employer perspective. J.P. Morgan Chase is one of the largest employers in Texas. We have over 30,000 employees here. Over the last few years, about 10% of the employees we have hired across the country are second chance hires, which is a great thing for us to be able to do. One of the things that we've also been able to do is we've been participating in the Second Chance Business Coalition. We were a founding company of the Second Chance Business Coalition. Over 50 companies of the largest names you'll recognize are part of that. We're a founding member. I serve on the board and executive committee too, the Texas Association of Business, and we've helped create the Texas Employers Coalition, Second Chance Employers Coalition. What we have found is that there is a significant loss over the period of time that somebody has a conviction, over $100,000 of somebody that has been convicted over their lifetime. Somebody that is young, it's almost $500,000 of income to their theft. We look at this as a workforce issue. We look at this as an employment issue. We are one of the highest regulated entities in the entire country. Regular banking. If we can hire folks with criminal records and second chance, almost anybody can do it. We urge your support of the bill. I've cut my testimony very short based on the time today, but this is a great bill. We've worked with Chairman Leach for a number of years on this, and we applaud the work that he's been doing on this. In terms of, we've done some work with you too as well, and we appreciate the work you've done as well. But we would urge a yea vote for this bill.
Okay. Thank you very much, Mr. Emmerich. Any questions? Okay. Thank you for being here. We need to reflect that Mr. Money is present. Anyone else here to testify for, against, or on the substitute to House Bill 2507? If not, Mr. Leach may close.
Thank you, Mr. Chair. As Mr. Emmert mentioned, we've been working on this for a few sessions now. This will be my third session, hopefully, to pass it out of the House, members, and I'd love to have your support on it. With that, Mr. Chair, I'm happy to take any questions, and if not, I close.
Any more questions for Ms. Leach? Ms. Bowers.
Thank you. Thank you, Mr. Chairman. I don't have a question. Just thank you, Mr. Leach, for bringing this piece of legislation, and to the witnesses for staying around all day.
Yeah,
The ones,
thank you.
especially the ones that I know. Thank you.
They were great.
Oh, Ms. Jones?
I too want to thank you for this, and I really want to say thank you to the government relations person for J.P. Morgan Chase. I had no clue that you were hiring second chance. So thank you. In fact, I'd love to one day just find out what your program is, because I got plenty of people I can direct to you. Thank you.
I do wish we had more time, which we clearly don't, but J.P. Morgan Chase they're doing amazing work on second chance hiring, and many companies are following their lead, so thank you for that.
Yeah, we're not giving really any of these bills the justice they
Yeah,
deserve in
I
hearing.
understand.
We apologize for that. It's just kind of circumstances, the way they work out.
They won't mind as long as we get it passed.
Okay,
So.
all right. They would rather pass it than talk about it. Okay. Yes, Mr. Burdell.
Thank you, Chairman. I just have one question, Representative Leach. Just I'm the only lawyer or non-lawyer up here, I think.
Yeah, I've met this guy
there
over
we go. Red
here,
is
and-
here. Sorry,
you're good.
Representative Bowers. This is strictly to nonviolent misdemeanor offenses, right? That's
Right.
what ChatGPT is telling me. So, okay, roger that. So, no, I just want to say I appreciate you for bringing this bill.
Thanks.
I think it's a good bill.
Thanks, Representative. Yes.
All right, any other questions? Okay, thank you, Mr. Leach. So if there is no objection, the chair will withdraw the substitute to House Bill 2507 and leave House Bill 2507 pending. And now the chair would lay out House Bill 4075 and recognize Representative Leach to explain the bill. And there is a substitute, so Mr. Wu, Vice Chair Wu will lay out the committee substitute.
Mr. Chairman, Vice Chair Wu, thank you for the opportunity to lay out House Bill 4075 to you today. A really important piece of legislation for our law enforcement officers across the state of Texas. Members, as you know, peace officers are responsible for enforcing the laws that we pass. They're the only ones authorized and given the duty to use force, if necessary, to enforce those laws. And though law enforcement does not make the law, that's our job, each individual officer incurs the potential criminal liability of enforcing the laws that they swear an oath to uphold. That's personal criminal liability for our law enforcement officers when they're employed as a peace officer and are charged with a crime alleged to have been committed when they're acting under the color of law. This bill, members, seeks to ensure that those law enforcement officers who are already placed at a disadvantage are given a fair chance at their constitutional right to an impartial trial if they are subjected to one related to their official duties as a peace officer. Let me break that down a little further for you. Policing, unfortunately, in our day frequently becomes political, and anytime there is a high-profile incident, for instance, an officer's body cam is usually very, very quickly released prior to any potential trial, in many cases months, if not years before any potential trial, due to the nature of the public interest in the job. Officers are frequently recorded by others, especially when there's big crowds, public events. And because these incidents are highly publicized in the area, the geographical area that the officer works, and sometimes beyond, officers already face a disadvantage where the public view is and can be and often is easily tainted. Further, peace officers also face the unique challenge where they could be judged by those who are constitutionally required to enforce the law against. Most citizens, understandably so, don't see the officer as an individual, but rather see the policing agency, law enforcement agency as a whole. This bill allows our law enforcement officers to select, to change venue, to allow for a jury to be impaneled of those not subject to the officer or the officer's agency's enforcement authority, and no potential voters of the district attorney prosecuting the case. Additionally, the bill only applies if the officer was, as I mentioned, currently employed as a peace officer at the time of the incident and charged with a crime alleged to have been committed when the officer was acting under the color of law. Essentially, this is only on-duty conduct related to official conduct. If an officer is charged with something outside the color of law or in their personal capacity, of course, this exception would not apply. And the sub before you, members, is simply a ledge council draft of the bill that I filed. With that, I'm happy to take any questions, Mr. Chair, and I'd reserve the right to close.
Any questions for Mr. Leach? Mr. Little?
Thank you, Representative Leach. Brilliant bill. This is a great idea. The only question I had when I was reading the bill is, where's the case going? And the reason I posed that is I had the great unfortunate pleasure of representing the Attorney General in his felony securities fraud proceeding that was pending in Collin County. All the judges recused themselves. Judge George Gallagher was appointed by the regional judge, and then the case was sent to Harris County, and it was obviously not an optimal situation to go from Collin County, a place where you live, to a county of the judge's selection anywhere in the state. So I would just encourage you or anyone else who's interested in this bill to consider limiting the scope of that venue change to an adjacent county perhaps, or something reasonable, because there are circumstances in which you can imagine a peace officer having to try a case in a different part of the state that would be maybe good, maybe bad.
Sure. That's a great point. I don't know the answer, but I'm willing and eager to work with you on that answer.
Thank you.
Representative Little, great point.
Now, Ms. Bowers.
Thank you, Mr. Chairman. And Representative Leach, this, as you know, being from North Texas, this may lend itself to the Botham Jean and Amber Geiger case. So I just want to put that out there. I do know that, I know you're in Collin County, but I know Dallas County would not be in support of something like this.
Well, I've thought of that case specifically, and I think, I don't know how many witnesses we have, Chair, but I think we've got a couple witnesses locally. This has certainly been and would be relevant from some instances, not only that case you mentioned from Dallas County, but one from here in Austin, and there are others as well. And my focus and my reason for filing this bill, really the heart behind this bill, is ensuring that law enforcement officer, who, yes, has a constitutional right to a fair trial, impartial jury, that they're afforded that right. And so this would be at the officer's election to change venue. And, that Dallas County case, God, that was that was a really, really difficult case. I know there's strong feelings on both sides of that case.
Yes.
But we want to make sure that the law enforcement officer, whether it's in that case here or wherever else it may be, feels like the jury of their peers has not prejudged the case before they walk into the courtroom. That's my goal here.
Okay, I understand, that's fair. I just definitely wanted to put it out there
Sure.
since I know it could apply. So thank you.
I had thought of that case as well. That's a heartbreaking, difficult one.
Mr. Money has
This is real quick, just to Mr. Little's point. The statute that the chapter that this statute is put into has a change of venue on judge's own motion above this one, that says any county in the same judicial district as a county in which case is pending, or in an adjoining judicial district. So if you look at that, and then it's or any county just not described by subdivision 1 after 10 days notice. If you in addressing his motion, I think that would, or I mean, his suggestion, you can use that prior statute to address it.
Yeah, that's a good thought.
And it would stay in a similar geographic area without being, yeah.
Yeah.
probably reduce the cost to, Ms. Jones, did you?
So how do we know where it lands?
Well, that's kind of what Representative Little and now Representative Money have brought up. We don't. There's the departure spot, but we haven't decided where the landing spot is, and so I think we probably need to work on that in the bill. And whether it's an adjoining or an adjacent county, those conversations can be had, and I'm happy to work with
So the
committee on
defendant
that.
asked for a change of venue because he's charged with something under color of law in his official capacity, and the judge shall, because I think it says shall, or, so the judge gets to pick?
No, well, that's unclear right now in terms of where the landing spot would be. But this is only at the defendant's, on the defendant's motion. Some of the previous drafts of the bill had, it could have been on the judge's own motion or on the prosecutor's motion, and I wasn't real comfortable with that. If a defendant feels, a law enforcement officer feels when they're on trial that they can receive a fair trial in County A, then they could stay in County A. But if they feel at the time and have good reason to believe that they're not going to get a fair trial, then they can leave County A. And as Representative Little brought up, we haven't yet decided to which county they go. I think that's something it's definitely something I'm happy to work on with the committee on.
Mr. Little?
Yeah, thank you, Chairman Smithy. And I'll just add to that. It is, having been involved in one case like this in my career where you're trying to identify a venue where you can get a fair trial, it's actually a very heavy burden for a defendant to carry to prove that you cannot obtain a fair trial. Typically you're trying to do it through adverse publicity, putting on news articles and internet articles and radio shows. Fortunately, I think there was a fair trial, I think, in Amber Geiger's case, and she was convicted. From what I understand, I've not heard anyone complain that she didn't have a fair trial. What your bill evokes immediately, Representative Leach, are the constant trials and attempted trials of police officers and law enforcement officials in this very venue where we stand right now. Correct. And this is not something that can continue.
Correct.
Okay, Ms. Bowers? Mr. Cook after that.
Thank you, Mr. Chairman, and thank you to Representative Little, and certainly to Representative Leach. I do believe that Amber Geiger was given the trial that she was. I don't want to say whether it was fair or not, and I'm trying to get you to understand that it could possibly mean that in a case like that, the trial certainly could be, the venue could be changed, and it should not have been changed in a case like hers. Do we agree on that?
I'm happy to answer your question.
Is he recognized before we get to
You recognize me?
You're recognized to answer the question.
Thank you, Chairman Smithy. I think it's clear that she did get a fair trial. I've not heard anyone complain that she did not. The question that's pending is, I think the bigger question that Bill is trying to answer and that Representative Leach is trying to answer through the bill is it necessarily true that every peace officer
is getting a fair trial or getting fair treatment as a defendant in every county in the state. I think Amber Geiger did. My concern, I think Representative Leach's concern, is not every peace officer is getting a fair shake.
So listen to this then. My sister and my brother-in-law are in law enforcement. I don't know whether you know that or not. So I do see both sides of this. So I'm not just on the side of a mother of a black son or a black woman. I do see law enforcement and the needs of peace officers. So you need to hear me clearly in what I'm saying, that it could mean that a change of venue could change the outcome of the case. So I do see both sides, Representative Little. So this is not it's not a black and white deal here for me. It's not. So you can have your smirk and look however you want to look at me.
Can I jump in?
Yeah,
Am I
please.
recognized?
Yeah.
I don't.
I'm sorry, Mr. Leach. Go
Sure.
ahead.
Sure.
It's been a long
So
day.
coming back to the bill, I actually think you two, for what it's worth, are agreeing more than you're disagreeing.
Most of the time. Thank you.
Well, the point of the bill is to make sure that the trial is about the facts and the law. Okay, and that's what is relevant in a trial, in a criminal trial, especially the facts and the law, and oftentimes it is impossible to escape the politics and the public messaging and the arena that we're in. It is in many cases, when you're there locally within a mile of where something happened, it is truly impossible for the trial to be all about just the facts and the law. In many cases, it's impossible to pick an unbiased jury. And so if a defendant feels in that case, if a police officer feels in that case that, man, this trial's not going to be just about the facts and the law, then they would have the election to move somewhere else. That's what the bill's about.
So I guess we need to get to, if we're in agreement, then maybe we are saying the same thing. Are you recognized? Wait, are you recognized to speak? Is he recognized?
He's recognized.
All right.
I'm confused as to what we're doing here. I'm not here to testify on the bill. I don't appreciate your personal comments. I'm here to listen to Representative Leach's
Yeah, let's
bill
just-
layout. I have some questions about the layout, and I have some observations about it too. I thought that's what I was here to do. Do you agree?
I don't appreciate the way you're
Well,
talking to me.
let's move on to Mr. Cook. Mr. Cook has a question.
I just had a suggestion. It looks like it would be a good way to just handle this like you would a recusal. I mean, just sending it to the presiding judge and let the presiding judge make that determination.
Sure. I think that's
Okay.
that's well said.
Now, Ms. Jones.
So I think that on the flip side of that, there could be concerns about forum shopping. And so like if the defendant wasn't a police officer, so and defendants who aren't police officers, if they don't get that option. So I think that there's a concern about that. There could be a whole group of people that I represent that would be upset about that because they're thinking that police officers are getting special treatment. I also think these are just things that,
I think you bring up a great point, and the way we avoid the forum shopping argument is we figure out that I'm not saying that the defendant gets to pick where they go. That I would not support that. That's not what my bill does. That's forum shopping. I just want to allow the defendant to pick where, if they don't feel like they're going to get a fair trial, then they can go somewhere else, and maybe we leave it to the discretion of the judge in an adjacent county.
I don't know if that fixes it, but that, okay, so the second thing is that there are a whole bunch of people who think that Amber Geiger didn't get sentenced as much as she should have for what she did. I'm telling you, people in my community absolutely believe she got special treatment. Yes, she got convicted, but she also shot a guy in his own apartment that wasn't doing nothing. So
Well, I'm not here to litigate the Amber Geiger
No, I'm not.
case.
No. I'm just. But I think you made a statement that people believe that she got a fair trial. Somebody made that statement, and I want to tell you that there's another side of that coin. I'm just because we want, when we pass bills here, for people to believe they're fair, right? So I'm just telling you some other sides of the coin to look at, and also, it's based on whether the defendant thinks that they can get a fair trial. Now, let me be clear. As a criminal defense lawyer, I have clients all the time who don't think they can get a fair trial, right? They just think they are not going to get a fair trial. I can tell them, I'm going to fight for you. and they just don't think they have a fair trial. And I think that there is a concern that all it takes is you think you can't get a fair trial, that there's no level of proof to be able to, for the most part, invoke the right to a change of venue just based on you don't think you can get a fair trial. So, because I promise you, there's a lot of trials that I have, I don't want the judge. But my client doesn't have the option to get rid of the
So
judge.
I think another added layer of this is, and I hear you, and I don't disagree with anything you've said. Another added layer of this is we want our law enforcement officers to feel confident in the jurisdiction in which they're doing their job. And if there are some jurisdictions, I'm not going to focus on the one we're in specifically, but we know where they are nationally, that have historically been not unfair to law enforcement, but have ruled against law enforcement harshly and repeatedly. And if law enforcement knows that and sees that, they're going to be very, very slow to want to come work in those jurisdictions. I think we're seeing that here, whereas we've seen that in other jurisdictions. And when a law enforcement officer knows that if in fact something happens relating to his color of duty, his conduct on the job, and that he's not going to be afforded a fair trial, or made an example out of for whatever reason, that's a problem when it comes to actually hiring law enforcement in growing areas.
I understand that, but that's one reason why I believe in like a community policing model, because I think there's also a whole bunch of people who believe that they don't get fair shots in this forum.
Hey, look, I've been loud and proud when it comes to criminal justice reform and making sure people get fair trials, and so I'm not going to apologize for that. But this bill specifically is relating to law enforcement.
Okay, thank you.
We've got several witnesses, so if there's nothing else, we'll go ahead and start calling
All right.
witnesses. Chair calls Michael Bullock. And Mr. Bullock, your affirmation shows you're president of the Austin Police Association. You're testifying on behalf of the association and yourself, and you're for the bill, correct?
Correct. Yes, sir. Thank you, Mr. Chairman, committee members, and in particular Chairman Leach for being willing to bring this issue up. I am the president for the Austin Police Association, representing the men and women of the Austin Police Department. Sadly, we are a prime example here in Travis County of why something like this, I believe, is necessary. As the chairman mentioned, we are the physical representation of government. We are charged with the responsibility of enforcing the laws that y'all tell us we need to enforce. And oftentimes that's not popular. We also face intense public scrutiny oftentimes and are judged more in the court of public opinion rather than in a courtroom initially. So it is already a hill to climb for officers when it comes to getting a fair shot at justice when you're charged with something criminally. Oh, all we are asking is indeed, through this bill, we believe that it would be a much more fair process if officers aren't asked to be subjected to, if they believe it necessary, a trial where the individuals that are likely going to be sitting in the jury box that are judging you are the individuals that you are also responsible for enforcing the law against. And we have seen in Travis County in particular, I know that's a repeat story oftentimes, but in Travis County where we've had officers that have been subjected to trials and individuals have placed flyers on the vehicles of juries saying that you must convict this officer, and yet change of venue was not granted. Officers have not been able to move out from where they were charged. And we've had instances where they've been convicted even with experts saying that they were, in fact, acting according to their duties. So this really is coming down to allowing officers access to their constitutional rights where you can get a fair trial.
Thank you, Mr. Bullock. Any questions? We appreciate it. Let me, hold on, I got one more question.
Yes, sir.
And is that whole concept having an effect on the department's ability to hire officers?
Yes, sir, significantly. I've talked to several different recruits that have applied to our department, and they withdrew their application because they see the environment in which we police, and they opted not to come here.
Okay, and you've had some people leave the force, I know.
Yes, sir. We've also had quite a few. In particular, since 2020, roughly, we've had the largest attrition rate we have ever had at APD. In particular, we've had more people leave the profession than join in the last over the last 8 years, almost 7 to 8 years consecutively.
And that's probably true for most police departments in the state, as far as I know.
Yeah, and major urban areas also tend to struggle with that the most, and this is definitely a contributing factor.
All right, thank you for being here. We appreciate it.
Thank you.
We have Kathy Mitchell. Ms. Mitchell here? Okay, we'll show Ms. Mitchell here on behalf of Equity Action and Self against the bill but not testifying, and then Kirsten Budwine. Is Kirsten here? And Ms. Budwine, I show you are with the Texas Civil Rights Project, and you're here against the bill, correct?
Yes, sir.
Thank you.
So my name is Kirsten Budwine. I'm a policy attorney with the Texas Civil Rights Project here in opposition to HB 4075. Under Texas's criminal procedure laws, there are only two ways that a criminal defendant can initiate a change of venue. The first is for the defendant to submit a motion that is supported by 3 affidavits, one by them, the defendant, and at least 2 from a credible residents of the county where the prosecution is commenced. The second way is for the defendant to submit a motion in addition to having the consent of the prosecutor. In both of these instances, a judge may grant the change of venue request and is not required to. HB 4075 allows for criminal defendants who happen to be law enforcement officers to curtail a judge's discretion and the established procedures by requiring that a judge order a change in venue if the law enforcement officer allegedly committed the offense while conducting their duties as a peace officer. This unfairly creates a 2-tiered procedural process where law enforcement officers can escape a jury of their peers while an everyday civilian charged with the same exact offense does not have that same luxury. For these principled reasons, we are opposed to HB 4075. Thank you.
Thank you for being here, Ms. Budwine. Any questions? Mr. Riddell?
All right. Thank you for your time today, for coming. Also appreciate that. Just a quick question. Do you think if a law enforcement officer was in a county that has built a reputation for being anti-law enforcement, that they would be inclined to have a judge that would be fair to them in that county?
I think that says something more about the community's view of law enforcement and the work that needs to be done between law enforcement and the community and building that relationship. Like I said, there shouldn't be a 2-tiered system where somebody charged with the same exact offense does not have this luxury. We're just opposed to that and requiring a judge.
I think it's a great point that you made there. I feel like there are certain counties that have built reputations of not standing up for local law enforcement when they were justified in use of force or something like that. And I just kind of point out that I kind of like that this bill gives that opportunity where you might not be inclined to get a judge that would agree to that, and unfortunately, you very possibly get an unfair trial in a community that's very unfair towards law enforcement. And so I just wanted to ask that question to you about that. I appreciate it.
Yes, sir. And I'll just add this, that, the Sixth Amendment, requires that everyone gets a jury of their peers. So if the law enforcement official committed that offense in that community, they should be responsive to that community, and their community should be able to be on that jury. So that's the way we see it.
All right. Thank you. Appreciate that.
Yes, sir.
Any other questions? Mr. Little?
Thank you, Ms. Budwine. We've gotten to hear from you in this committee before, and it's been enjoyable every time. I'm empathetic to the concerns about a 2-tiered system of justice. How do you respond to the situation where a law enforcement officer is on trial and there are flyers being placed on vehicles telling people to find that person guilty? Do you think that that person can still get a fair trial in that county?
Yeah, I think the same concerns come up in high-profile cases that we see across the state of Texas. You have high-profile cases where people are asking for the death penalty for someone. There's a high-profile case right now in, I'm blanking on I think it's Collin County, where like people are asking for the death penalty for the kid, and so it's.
Yes,
I
ma'am.
think the same concerns are for everyday civilians who go through the same thing.
I've worked in Collin County for the last over 20 years. I happen to know Judge Tucker. She's a very fine judge.
And she's getting death threats for her decision.
And I'm
Yes, sir.
horrified by that. I've known her for a very long time, and it's been very sad and troubling to see how she's been treated publicly by people who don't really fully understand the criminal justice process.
Yes, sir.
Oftentimes, there's a rush to judgment to respond to a crime that horrifies the community, whether it's someone who's been killed by a police officer or just a random act of violence that occurs at a track meet. But you didn't really answer my question. My question was, do you think that someone who's having flyers put on people's cars saying you should find this police officer guilty can get a fair trial in that county? What do you think?
I mean, I feel like I did answer the question by saying that everyday people go through the same exact, go through that same exact issue where there are calls for the death penalty. Like it's the same type of case where you have the public who is pushing for, extreme measures. Like you said, they don't really understand the criminal process. And what I'm saying is let the criminal process play out, just like for any other criminal defendant.
I appreciate your answer, Ms. Budwine.
Yes, sir.
Anything else? We appreciate you being here.
Thank you.
Ms. Budwine. Is there anyone else here to testify for, against, or on House Bill 4075?
Somebody in the back there.
Yes, sir. Have you done an affirmation?
Yes, sir.
What is your name?
My name is Doug O'Connell.
I'm not showing you on here.
Can he register with you? Can he register with you, or does he need to go to the kiosk? Can he register with you, or does he need to go to the kiosk?
I did register at the kiosk.
It's not showing me. What, and just to clarify, what bill? Is it 44075?
I believe so.
Yeah. If you can get him registered, we'll have to stand at ease for just a moment to get you registered. Okay, thanks. Usually takes about 3 minutes.
I'm a criminal defense attorney located here in Austin, Texas. I'm called upon very often to represent peace officers who are accused of criminal offenses. In fact, since December of 2018, I've represented officers on 6 occasions in jury trials here in Travis County. And that includes about a 2-year period where our courthouse was closed down for COVID. And I can attest that when a police officer is indicted, it generates a tremendous amount of media coverage. I will also, it's my observation also that the normal standard for obtaining a change of venue, that being you cannot find 12 jurors in the entire county, is an insurmountable standard, at least in a place like Travis County, where we have a population of over 1 million citizens. That enormous media coverage makes it extremely difficult for a peace officer to obtain a fair trial. And I want to note that in 2 of my cases over the last few years, we have documented instances where there was jury misconduct, where we discovered the jury was doing outside research. And so the more media coverage, the more susceptible the jury may be to doing outside research and being influenced by that media coverage. Finally, if I could, I'd like to address Representative Little's question about where the change of venue ends up. And my understanding of the mechanics of the bill as it currently sits, it would follow the normal procedure, that being going to another county within the judicial district. But here's the important part. In order for this to make...
I need to get you to move on because we're out of time. Let me see if there's any questions. Mr. Little?
I would love for you to finish that thought because it is important to me. It wasn't obvious to me that it was going to fall under the other statute. When I say the other statute, I mean the more traditional venue change. And one of my first, let me just agree with you. It is almost impossible to obtain the venue change that you're talking about from my own one experience, much less your many, okay? The second concern I have, though, is the transfer operates to transfer either in that judicial district or to any other adjacent judicial district, right?
That's not my understanding. There is one provision where under the different procedure where the judge unilaterally decides or the judge finds that there's a dangerous combination. If the judge finds that, then the case can be transferred anywhere statewide.
Okay, please forgive my ignorance about that. The problem with it is that I think most people don't understand these judicial districts are huge. And if you're a defendant in, let's just say, Williamson County or whatever, you didn't feel like you could get a venue change, you could be hundreds and hundreds of miles away from your family trying this case. You as defense counsel are going to have to travel and stay somewhere too. Seems very burdensome. What's the solution?
Well, I think the solution and the critical point is have a mechanism that gets it out of the media market. So for example, if you have a issue here in Austin, Texas, well, that extends all the way up to Bell County and the northern reaches of San Antonio. And before that media market moves to the San Antonio media market, where the story is less appealing. And so the remedy has to be, if this were to work, it has to be move the case, have the ability to move the case out of the media market from where the alleged offense happened.
Okay, thank you.
Any other questions? Okay, thank you for being here.
Thank you.
Mr. O'Connell. We also have Nick Hudson. And Mr. Hudson, I show you here on behalf of the American Civil Liberties Union of Texas testifying against the bill.
Yes, sir.
And also, we have a duplicate affirmation as a non-testifier, and so do we have permission to delete that?
Yes, sir. Thank you.
Thank you, sir.
My understanding, Representative, you asked about a case where there were flyers passed out and what happens in that type of case. What happened in that particular case here in Travis County is that a mistrial was declared, and then they impaneled a new grand jury. They actually impaneled 3 juries of 100 people each. I have been through voir dire process here in Travis County. I take that process very seriously. I can guarantee if I was on a jury, even though I work for an organization that often is in opposition to bills like this, I would guarantee you that I would take that process seriously. And I have to say, I find this entire conversation about our juries in Texas not being able to fairly handle these types of cases to be a little upsetting. The idea that we would set up a separate system of justice for police officers, our ask is that, our ask as an organization, if you get an automatic change of venue because you want one, that should apply to everybody, or it should apply to nobody. So,
Mr. Little?
Mr. Hudson, I don't understand the decision tree at the ACLU. I would think this ACLU would be for this, trying to protect the civil liberties of peace officers who are trying to obtain a fair trial in a county where they're being subjected to a torrent of negative media. I mean, help it, make it make sense.
We care about equality of justice under the law, and what this bill does is it sets up a separate system of justice if you're a member of law enforcement. Our only ask is that you apply the same process of decision-making about whether you get a separate venue. Make it apply to everybody who requests it, or make it apply to make the ordinary process apply. And I think that that is a fair and just process. And as you talked about the specific example you brought up, there was an appropriate outcome in that particular case. I'll also mention, in Travis County, the county that we've heard a lot of conversation about, there has only been one conviction of a police officer in this county. And so I am not sure that there's quite the problem that has been characterized. I understand the concerns about ensuring a fair trial, and we care deeply about that. But I think that there are checks and balances throughout the voir dire process and other parts of it.
Thank you.
Thank you.
Ms. Jones?
I would also say that's true as well, because in voir dire, you ask if you, first of all, you try to figure out biases, right? You ask questions to get biases, and then you even ask, well, can you be fair, right? And so, as I said before, only in recent history, probably like within the last 10 years, have I seen officers get convicted for killing unarmed black people. And I think that there are a number of people who would say that when you're perp walked, which happens to ordinary citizens, that there's negative media about that. And one of the reasons that I chose to be a criminal defense lawyer is because as a kid, before I was ever a lawyer, I just saw that, at least in the neighborhood that I'm from, that the police weren't there being friendly. They were harassing people. Like I said, my nephew, who's is taking college visits right now, who's a Dean's List student, was accosted by the police in the neighborhood park, and his mom is a physician and his dad has a good job as well. And the police last year or year before presumed that he was committing a crime, even though he wasn't. So I think that different people can look at the same thing and come away with different realities, for lack of a better word. And then I'll end with this, that as we watch the criminal justice reform of Chairman Leach about people who are wrongfully convicted, there are plenty of people who are wrongfully convicted, so much so that there needs to be an innocence project. And I don't remember who came up here and said that there's anywhere from 6,000 to 9,000 wrongfully convicted people. Those people didn't get a fair shot either, and the barriers are so hard to undo those wrongful convictions or those actually innocent people. So I just do believe that everyone should be treated fairly and equally.
Any other questions, members? Okay. Thank you for being here.
Thank you.
Anyone else here to testify for, against, or on House Bill 4075? If not, Mr. Leach, you want to close?
Mr. Chair, I'm happy to take questions. If not, I close.
Any questions? Okay. Mr. Moody?
I don't have a question. Just a comment. And Chairman Leach, we obviously worked together on a number of issues. So I know your heart. And I don't have a suggestion on amendments to your bill. I just think the underpinnings of it are what make me sad. The most productive law enforcement agencies and those who do well in their communities is that they view themselves as a part of the community. Like I heard today testimony say, I'm doing this against the community that I serve. And this language that there's like this barrier between law enforcement and the community they serve. And I know this is not what your bill is trying to do, but the underpinnings of it are continuing to separate that we believe that the process under the law now, that juries can't be fair and impartial because someone is a law enforcement officer. And I think that's the part that there's nothing we can do to fix that other than to start to repair the relationships between those that serve the community and the community they're serving. And there's nothing that we can write in law to do that. I remember being down in Uvalde and seeing a community that didn't trust law enforcement at all and still won't for a very long time because of what happened there. How do we foster that relationship back? Because you should be tried before a jury of your own peers, unless there is something outside, something outside something. We try notorious cases in the home counties all the time. And so I think the part that really brings me down about this is that it enshrines in law that there is some presumption that the community that is supposed to be served by law enforcement is somehow going to be default unfair, and not impartial to those officers if they're brought before them to stand trial. I get where you're coming from. I certainly understand the concern, but that's the part that really gets me. Is I want to start. We need to start having the conversation about how we build those bridges back, not how we continue to enshrine the division between those that serve and the community that they're serving. And I certainly get why we're here and what this bill does, and it's a policy decision for us to make if we want to give this option to certain defendants. But I don't know. I just felt I needed to say that in the midst of this conversation. So I appreciate you very much.
Well, as I so often say to you, Speaker Moody, I agree with everything you just said. I don't know what the solution is. I do believe that this bill there's a reason I filed it, because I believe it's the right policy. But I share your sentiment and look forward to talking with you more about that.
Any other questions for Mr. Leach? We appreciate you.
Thank you, Chairman.
Being here.
Thank
If
you,
there's
members.
no objection, the chair will withdraw the substitute and leave House Bill 4075 pending at this time. Mr. Capriglione, you ready on yours? At this time, the chair would lay out House Bill 2348 and recognize Representative Capriglione.
Thank you, Mr. Chairman and members. Today I'm here to speak to you about House Bill 2348, which strengthens protections for elderly and disabled individuals who may serve as victims or key witnesses in criminal cases by allowing their depositions to be video recorded and used in court. As you know, elderly and disabled Texans often face serious challenges when it comes to participating in courtroom proceedings, whether it's due to health issues, limited mobility, or the stress of testifying in person. And while current law allows for depositions in some of these cases, there's no clear mechanism to ensure that those statements can be preserved in a meaningful way. House Bill 2348 helps address this by
Hold
giving...
on, let me stop you. Well, I think
Sorry,
we've
there
got
is a committee substitute. Yes,
there is a
I apologize.
substitute. So I'll get Mr. Money to lay out the substitute.
Great.
Go ahead. I'm sorry to interrupt you.
No, I should have mentioned that. House Bill 2348 helps address this by giving courts the ability to video record depositions from witnesses who are 65 or older or who have a disability. That way, their testimony can be captured not just in words, but in tone, demeanor, and body language, helping judges and juries better understand the full context of what the witness is saying. It also provides a clear path for those recordings to be used in court, including requirements for authenticating the video to ensure it meets evidentiary standards. happy to answer any questions.
Okay, any questions? Sorry, Ms. Jones.
Is this a deposition that you're talking about, or you're just talking about a video?
This is a video of a deposition.
But there are video depositions, so I'm confused about. But I mean, the depositions by video I have, they're there, like, so,
No, this is allows, okay? This would allows is if, let's say, there's an elderly person or disabled person who's a key witness, maybe the victim in a trial, that is not, because of mobility issues, able to leave their home, let's say. And so what this bill does is says the judge may order the state to go and have a deposition of that individual done in video. That way the person doesn't have to come to the court.
Sure.
you know what, let me let you move on, because I just need to wrap my head around what you're suggesting, because
Well,
Let me get Mr. Little.
Thank you. Thank you, Chairman Smithy. So I think this will address Representative Jones' question. So in civil procedure, unlike criminal procedure, we have the ability to take depositions and also record them by video. So you've got a stenographer and a videotape. So you're taking the deposition. It seems to me that the purpose of your bill is to permit depositions to take place for either to preserve someone's testimony who is old and infirm, or be able to present someone's testimony at trial who can't physically get to the trial. Is that,
that's
am I
right, and to
stating
be
that
able
right?
to present it in
Yeah.
put it into court.
So I'm glad I understood it. Now, I have a caveat or a concern about your bill is typically when you take a deposition of someone, you've got the other side there to confront that witness. And I had to read it fast, but it's not readily obvious to me that if Representative Jones is defending someone in a criminal trial and the prosecutors wish to take the videotape deposition of a victim or a witness who is infirm or might die old in the hospital, that Ms. Jones can be there to ask questions of that witness at the same time.
So the right to confrontation can still be preserved through cross-examination during the deposition itself with all parties present and represented.
That's good news. That wasn't super obvious to me from your bill. So if that were in it, I'd feel a lot better.
Sure.
But I believe that was the intent. It just wasn't super obvious to me there. This is I've had to do it one time. It's
Sure.
pretty common in civil practice. You're doing it to preserve someone's testimony. I had a very old client who was infirm, and I'm trying to preserve it. So I understand. Thank you for explaining.
We need to note on the record that Mr. Louderback is present, and Ms. Jones has another question.
I just want to make sure that the defendant has a right to be there, right? Because even though I'm the defendant's lawyer, there are things the defendant might know about this person, the defendant might know this person is lying or not. And so it's important that there be something where the defendant is present. What I don't want to have happen, based on how your bill is written, is that you think, or this bill says that because I represent my client, I'm there, my client is therefore there. So I would imagine there might be difficulties logistically getting someone who's incarcerated, if they can't afford bond, to go to wherever that infirm person is, because a right to confrontation means a right to confrontation. So if your bill, and I didn't see where your bill said that my client got to be there, but my client has to be there.
Right.
Because I cannot effectively cross-examine anybody if the person that's being accused isn't there to tell me like stuff I just may not know.
That part.
Sure. Well, again, what this bill does is allows what's already allowed in terms of those depositions for it to have the judge be able to order that to be here. But there is a resource witness that would be able to talk about more in detail and how these actions occur.
But in criminal cases, most times there's not depositions, right? I mean, I practice criminal and civil. So most times there's not depositions in criminal cases. All I'm saying is that if they are, trust me, there are witnesses who, if I can get them on the record, because they might not be around during trial for whatever reason, I don't have a problem with that. I just need to make sure that my client, and there needs to be a mechanism where the judge, where they can bench warrant the accused to wherever the deposition is, but then I even foresee problems with that, because maybe if you're a victim, then maybe you don't want the defendant to know where you are,
Yeah, and we
right,
have
or where
someone
you live. And
from-
so,
right.
so, but
I hear you.
I will work with you offline to
Okay.
try to fix it, because
I
I
don't
might
think it
like
needs
that
fixing,
too.
but yeah, we'll definitely have a resource witness here to talk about it.
Okay.
so.
We
All
got a
right.
couple of witnesses.
Okay.
Reserve the right to close.
Any other questions? If not, the chair would call Alicia Patterson. And Ms. Patterson, we appreciate you being here. Your affirmation shows that you're the Assistant District Attorney in Dallas County and the Office of District Attorney John Creusot, and you are here in favor of House Bill 2348, correct?
Yes, thank you so much. And thank you, Representative Smithy, committee members, and also Representative Capriglione. I am speaking in favor of the committee substitute. My name is Alicia Patterson, and I'm here representing Dallas County District Attorney John Creusot in support of House Bill 2348. I'm the Chief Prosecutor of the Elder Abuse Unit at the Dallas County DA's office. We prosecute crimes committed against the elderly or disabled victims, including financial fraud and exploitation, physical abuse and neglect, and other violent offenses. While I prosecute a variety of these crimes, the common thread throughout these offenses is that the victims are among the most vulnerable in our community. These victims are often targeted because of their age or disability, and just like every other victim, they deserve an opportunity to have their voice heard in court. Unfortunately, due to their age or to their disability, it may be impossible for that person to actually testify live in front of a judge or jury. That's why depositions are an important tool in ensuring that crimes committed against the elderly and disabled can be prosecuted and justice can be sought. Depositions not only allow the state to memorialize testimony prior to trial, but they also allow the defendant and the defense attorney an opportunity to cross-examine the witness. The way this is done is very similar to a civil trial. The deposition is transcribed and also video recorded. However, the language currently used in the law doesn't state that the video recording of the deposition can be played for a jury. Instead, it says that testimony can be read into evidence. While some judges interpret that as the video can be played for a jury, not all do. That is entirely within the discretion of the judge, and that depends on their interpretation of the statute. This issue was addressed by the legislature when Article 39.026 was enacted, but that legislation is specific to healthcare fraud cases. We're simply asking for that language to be inserted into Article 39.025, which addresses every other type of crime.
Okay, thank you.
And I welcome any other questions that you may have.
Any questions, for Ms. Patterson? Mr. Little?
Thank you, Chairman Smithy. Ms. Patterson, I'm sorry, I was asking questions of Representative Capriglione earlier. I did not have the code open. Apparently, we've got a pretty robust rule already at 39025 governing the defendant's appearance and his counsel's appearance, and I just was not aware of that, so I opened it up. It sounds like that environment has already been created. This is, to put it in my own words, a cleanup bill to make sure you can use the video at trial.
Yes, Your Honor. I'm sorry. I'm used to being in court.
I know. Me too. I did that exact same thing the other day. It's very embarrassing. I'm sorry.
Yes, sir.
So
This is merely updating and cleaning up and making sure that it's not up for judicial interpretation, that it's actually in the law.
thank you. This is very simple. Thanks.
Ms. Jones?
I may not need to ask the question. Let me
Okay.
read this.
All right. Well, we've got another witness, so you can ask.
Yeah, let me just read this. and-
Okay.
And sir, if I may, in the handout that I've provided for you, there is
Okay.
one discrepancy. On page 5, the language has been updated in the committee substitute to reflect all the deposition code sections. That's 39.02, 39.025, and 39.026. And I'm sorry, I just made the packets before we got that committee substitute, so I left the original ones in.
And Chair Smithy, what I'm not certain of is if this is a committee sub, is what I'm not certain.
Does it have 3 references to code?
I'm sorry, what?
Does
Are
it
there-
have 3 references to code?
I think that's the original bill you have. Yeah. So, Why don't you, we'll get you a substitute and then you can, okay? Okay. Mr. Money, did you have something?
So, like Mr. Little, I'm not very familiar with the Code of Criminal Procedure, and is this this statute regarding the video recording seems like it's anyone is allowed to do the recording as long as they authenticate the recording, correct?
Yes, and typically it's someone from the DA's office. Usually we have an investigator, or larger DA offices may have someone who's actually in charge of video recordings. And so anyone who can testify to the authenticity of the video.
Okay. And, okay, thank you.
Okay, Ms. Jones?
So when it comes to authenticity, so generally if it's a business, they have a business records affidavit where they'll attest. If it's the DA's office, the defense is, I'm just asking, the defense is supposed to trust that what you do in the deposition, would there be like a deposition, a court reporting company that does this?
Well, yes, so depositions are transcribed, and
I understand.
they are,
I'm a lawyer. I understand that. What I'm asking is, if the person is, if what Rep. Fidel says is true, money, Lord have mercy. If what Rep. Money says is true, and the DA's office can do the deposition, which is what I think you just said, so then we'd have to get a business records affidavit from the DA's office attesting to the authenticity and accuracy of the deposition. That concerns me.
well, we could also just put the investigator on the stand to testify to it. But remember, the defendant and the defense attorney are entitled to be present at the deposition.
No. And exactly, that was my concern before. But what I'm saying is, so if you get a court reporting company and a videographer to come, then they can do the business records affidavit so that you can publish it to the jury. That's what you want to happen, right?
We could do that, or we could call them as a live witness.
Well, I mean, I know that I'm not worried about the live witness part. I love that too. But I'm just worried about making sure, it's just when a court reporter does a deposition, when you read the beginning of the deposition, it does everything it's supposed to do to show this authentic, right? And I just want to make sure that same thing happens with this case. That's
Yes,
all.
we're not changing
Okay.
anything about
Okay.
how they're authenticated. It's just showing that a videotaped recording, as opposed to a prosecutor essentially reading a transcript for a jury, that the videotaped can be played.
Okay, so that's the only change in the law,
That
is
is
that
the
you can
change.
publish it as opposed to read it, for the most part.
Yes, ma'am.
Okay, thank you.
Okay, any other questions? Okay, we appreciate you being here, Ms. Patterson.
Thank you so
very
much.
We have Alan Place. And Mr. Place, I show you on your affirmation as being here to testify on behalf of the Texas Criminal Defense Lawyers Association, neutral on the bill. Is that correct?
That's correct, Mr. Chairman. Allen Place, Texas Criminal Defense Lawyers Association. First of all, I do want to state the law is thorough already in terms of taking a deposition. I've never been involved in one, and they're very rare, but the law does allow for that. I don't know, I haven't seen the sub, and I can only talk off of B2, but the language on B2 on the original bill, I think if this is the sub, the concern that we have is just the way the language is. And I want to say up front, if in fact these, for elderly or disabled individuals, we're going to certainly be fine if they're handled similar to a civil situation. But that's not how I read B2. I think it's just a language issue. For example, what it basically says is that the video recording, if the court finds that it would unnecessarily prolong the trial, the court may allow a party to offer the entire video into evidence to go back to the jury room. That's just not my understanding of how things work or should work. I think that the state would offer whatever they wanted to of a deposition, you know, and again, as the previous witness said, the state and the defendant both have to be there, and there's accommodations made if the defendant is incarcerated. But sending the video back to the jury without playing it, if it's going to prolong the trial, it's going to prolong the deliberation. So I think it's just the language there that I haven't been able to get my head around.
Okay. Maybe you can visit with the author
Certainly.
on that. Ms. Jones has a question.
I want to make sure I get this on the record. So I have a problem if the deposition just gets published before the jury, because what if there's hearsay within the deposition, right? Like what if what the witness says isn't authentic, is not reliable? I think we have to, or at least me as a lawyer, I know that I'd go through and challenge
Certainly.
everything if it wasn't reliable. So if
Yeah,
it didn't
and
follow the rules of evidence, even if it's within the deposition, then I want it taken out, I want it redacted. And so I would have a problem with that.
Correct. The state may offer some, the defendant may offer some. In some cases, you may have an agreement to watch the entire video deposition in front of a jury. But I think it's just misplaced to say that you would send, without watching it, sending the video into the jury room when it hadn't been admitted with all other objections. I think that's an unintended consequence of this language.
Mr. Little?
Thank you, Chairman Smithy. So, Alan, I didn't read it that way at all, and I may be misreading it. Typically, the way this will happen in a civil trial is you'll have you have the known galaxy of what that witness can talk about. It's in the form of the video deposition, and a judge will typically order one side of the case to designate their experts, the defendant designate their excerpts, and then the court will rule on any objections on hearsay and things like that before it ever gets shown to the jury. But it's treated as the testimony of a witness.
Sure.
In the course of a trial. I didn't read the bill and go, somebody's going to put this depo on a jump drive and hand it to the jury and say, have at it after the trial's over. I didn't read. Yeah, I'm looking at the sub. What do you see? I'm sorry. Representative Cook may have some insight to it, so point it out to me so I don't miss it.
Basically, B2, as I read it, it says, if the court finds the video recording of the deposition is properly authenticated and that requiring the jury to view the entire recording would unnecessarily prolong the trial, the court may allow a party to offer the entire video recording into evidence without requiring the jury to view the entire video recording during the trial. I understand. It says the subsection doesn't preclude the attorney representing the state, the defendant, or the defendant's attorney from offering it evidence and playing for the jury a portion. That I get. It's just if you have the first section, you're able. I'm subject to being wrong. I am on a regular basis, but that's just the way I see it.
Mr. Place, I think this is the perfect reason why we have 11 people on a committee, because we can read the same piece of information and see different things. So I did not pick up on what you and Representative Cook did. So kudos to you.
That's the only, and I think that can be addressed. I really do.
Yeah. Any other questions?
Thank you, Mr. Chairman.
Okay, thanks. Is there anyone else here to testify for, against, or on House Bill 2348? If not, the chair recognizes Representative Capriglione to close.
Well, I've discovered what it's like to have 9 attorneys on one committee. So happy to work with everybody and anybody on making sure that the language reads the way that it's said. So with that, any other questions?
Mr. Moody?
I just wanted to welcome you to the Committee on Government Inefficiency.
Right. We'll talk about it tomorrow at mine. All right. Yeah.
Mr. Cook?
Yep.
Without offending the bill author, is there a particular district attorney that you're working with on this bill? Is it the Dallas?
With the Dallas District Attorney's Office, yes. And happy to go and change the words to be able to go and, I guess, highlight the last sentence, which says that this subsection does not preclude the attorney representing the state, the defendant, or the defendant's attorney from offering into evidence and playing for the jury a portion of the video recorded deposition.
I think that's the way it should be done, which is what Representative Little was describing. That's what's normally, you kind of got it as the default being, you can throw the whole kitchen sink in instead of just, marking the portions of the deposition that should be offered.
The only thing I would say is, the way I read it, but again, I could be wrong, but it does say you can, anybody can basically play some or all of it.
Right, but you may have a 3-hour deposition and 20 minutes of it's relevant, or admissible.
Mm-hmm.
And it's not a good idea to throw a 3-hour,
Sure.
tape back in the jury room without any court rulings or anything like that.
Right.
So,
Ms. Jones?
You know, what I was gonna say is, like, regular deponents, they don't know the law. And so they'll just talk. And it may or may not be relevant. And it may or may not be reliable. And so there's got to be a mechanism, and I'll look, and I'm happy to work with you, because I absolutely believe that infirm people should be able to have their day in court.
Good, I'm glad.
So-
Because that's the point of this bill, is to go and say that rather than not take the deposition of someone who's elderly or disabled, to not let them play a party, to force them to maybe even delay the court proceedings, okay? Because it is difficult to get them to the court
Oh,
or
no.
to put them in a situation
I
where
think
they
we're
may
on the
not do
same
it.
page.
Okay.
I just need to make sure
Yep.
that evidence that should not be admitted because of authenticity and reliability
Sure.
isn't admitted. We can fix that. I believe
Okay.
we can fix that. And
All right,
I
good
think
deal.
I'm team Capriglione
All right,
on this
awesome.
bill.
Good deal. You heard that here first. All right. Any other questions?
If there's no other questions, the chair will withdraw. If there's no objection, the chair will withdraw the substitute to House Bill 2348 and leave
Thank you.
House Bill
Thank you, thank you.
2348 pending at this time. Let's see. Ms. Perez, are you ready? You've just got one witness. Let me get you up here.
I will be quick.
Okay, the chair lays out House Bill 3111, and I believe and recognizes Representative Perez, and I think there is a substitute.
Yes,
on this.
yes, sir, there
So
is.
Mr. Wu lays out the substitute, and go ahead.
Thank you, Chairman Smithy, Vice Chair Wu, and members of the committee. Thank you for allowing me to lay out House Bill 3111 before you today. House Bill 3111 pertains to skimmers, which are defined in the Business and Commerce Code as a wire or electronic device that is capable of unlawfully intercepting electronic communications or data to perpetuate fraud. These devices are manufactured for the sole purpose of stealing payment card information, often found at gas pumps, ATMs, and point-of-sale terminals. Current law requires a search warrant for a cellular telephone or other wireless communication device, but other wireless communication device is not specifically defined, creating a gray area regarding skimmers and leaving this language subject to interpretation. This ambiguity within current law is preventing law enforcement from acting swiftly to search skimmers for victim information. House Bill 3111 clarifies that a skimmer is not a wireless communications device. This language will remove the ambiguity within current law, reduce the potential harm to victims, and streamline investigations. The committee substitute expands the exemption to all devices manufactured for the purpose of illicitly obtaining payment card information, whether they are defined as skimmers by the industry or not. With us here today, we have Adam Colby, who is the Director and Chief Investigator of the Texas Financial Crimes Intelligence Center, to speak on the bill and answer any questions you may have. And with that, Mr. Chairman, I respectfully request the right to close.
Any questions for Ms. Perez? Okay, we'll call. Chair calls Adam Colby. Mr. Colby, I show that your affirmation shows that you're the director of the FCIC, which is the
Texas Financial Crimes Intelligence Center.
Financial Crimes Intelligence Center, and that you are neutral on the bill, correct?
Yes, sir.
Okay, thank you, sir.
I'll skip over a lot of what Representative Perez said to us. Good evening. I'm going to talk to you about why the skimmer shouldn't be part of this. So this proposed amendment seeks the exemption for the skimmers, which are devices that are manufactured for the criminal purpose of stealing payment card information and personal identifying information of the victims. A skimmer is a device that is designed to solely be capable of intercepting and recording victim payment card information and victim PII. This information is typically found within the contents of a payment card's magnetic stripe. Skimmers are devices built by criminal organizations and are not available for purchase in legal markets. They're commonly attached to retail fueling pumps, ATMs, and point-of-sale terminals in retail stores. These devices are not capable of containing photographs or personal communications created by the defendant. Again, the sole purpose of this device is to steal card numbers and PII, typically found on the card's magnetic stripe. In other words, a potential defendant or suspect has no standing in this. Numerous court cases have affirmed that there is no expectation of privacy on a payment card's magnetic stripe, which is the information targeted by a skimmer. These cases include United States v. Bay from the 6th U.S. Circuit Court of Appeals and United States v. Delisle from the 8th U.S. Circuit Court of Appeals. As skimming devices only contain information stolen from a magnetic stripe, a losing my voice. A warrantless search of a skimming device is not a Fourth Amendment search. As Article 18 does not define other electronic communication device, the proposed exclusion is necessary in the interest of justice. When considering the purpose of a skimming device and the fact that what we're looking for here is the card numbers and personal information that has been stolen so we can be sure that those numbers are not in play, the fact that it does not contain any personal information stored by a defendant, it becomes impractical and unreasonable to require a search warrant for this. Consider that as defined by Texas Penal Code 16.0T, the manufacture, distribution, or possession of this type of device in of itself is a criminal offense. Because of the lack of definition of the electronic device in Article 18, several district attorneys are now asking for this as a CYA.
Okay, thank you. Any questions, members? Ms. Jones?
If I have what you believe is a skimmer, you believe it is not a violation of the Fourth Amendment to be free from unreasonable search and seizure for you to take what you believe is a skimmer from me and search it. Is that what you're asking?
Well, you're going on the premise that I don't know or possibly may be wrong as to what a skimmer is and what a skimmer is capable of, and that's not the case. What I'm telling you is that a skimmer is not capable of storing any of your personal information that you may find on a phone, a computer, or a tablet, which was the reason why the Supreme Court decided that we had to go back and start doing these searches.
Well, you want to give me the case site again? Because I can go look at that too, because I think that if I have something on my person, that the Fourth Amendment prohibits you without a search warrant from coming to get what's on my person to search it, even if you believe that it's illegal. And even if it actually is illegal, you have to give sufficient probable cause before you can violate. I mean, and then that's not a violation of the Constitution. But if you give me the site, I'm happy to look at it.
Yes, ma'am. And we may be talking about the same thing, just coming at it from different angles. Because
Okay.
I agree with you in much of what you're saying. United States versus Bay, B-A-H, 6th U.S. Circuit Court of Appeals. United States versus Delisle, D-E capital L.
Wait, 6 U.S. Circuit Court of Appeals?
Yes, ma'am. And the other case I cited was United States versus Delisle, D-E capital L apostrophe I-S-L-E from the 8th U.S. Circuit Court of Appeals.
D-E capital L?
Apostrophe I-S-L-E.
And the site, I need a site at the beginning, like where it is, and a page number at the end. Do you have all that?
I do not have that in front of me, ma'am.
Okay, I'll
Maybe he
figure
can
it
get that for you or something.
out. Yeah, can you get that for me, please?
I can work on that.
Thank you, I appreciate you.
Mr. Williams?
Help me understand this just a little bit. So I want to try to provide a scenario and just tell me if I'm doing something wrong.
Sure.
Right? Police conduct an investigation. They discover a ring of people who are doing skimmers, right? They end up pulling somebody over that they think is in this ring, right? For a valid reason, they pull them over for traffic violation, and they have on their person a device, right? And this device contains something inside that could be incriminating, correct? Potentially incriminating.
Correct, sir.
Right, because if they had a skimmer and there was nothing inside of it, would that be a crime?
Yes, sir, it would.
Just having the skimmer alone?
Under Penal Code 16.02.
Okay. So the very possession of the skimmer itself would actually be an arrestable offense.
Yes, sir.
And so then you would have the ability and to search contents, right?
Correct.
If it was a phone, like a locked phone, you would need a search warrant for that,
That is correct.
okay? But let's say if somebody had on their person a cigar box, and the cigar box can just be opened and you can look inside, do you need a search warrant for, like, opening the cigar box?
Depends on the situation in which the cigar box came into the possession of
It was
law
on the
enforcement.
person that was being arrested.
Yes, because typically a cigar box is going to be opened up to see if there's contraband in it.
And so are you saying that because this item, this skimmer, that can, under current technologies, cannot hold basically anything else other than the numbers that have been skimmed, because that's what they're designed to do, because they can't hold that, then this courts are going to treat it like it's a cigar box, that you can just pop it open, see what's inside, and there's no need to go get a warrant for it.
That's correct, sir.
Okay.
Any other questions? Okay. Appreciate you being here, Ms. Colby.
Thank you, sir.
Anyone else here to testify on, for, or against House Bill 3111? If not, Ms. Perez, you ready to close?
Mr. Chairman, members of the committee, thank you for your time. I would greatly appreciate your favorable consideration. And with that, Mr. Chairman, I close.
Okay. So if there's no objection, the chair will withdraw the substitute to House Bill 3111 and leave 3111 pending at this time. Thank you. Mr. Metcalf, are you ready? Mr. Metcalf? The chair
Sorry, Your Honor.
That's all right. The chair lays out House Bill 2594. There is a substitute, and Ms. Jones will lay out the substitute, and Chair recognizes Mr. Metcalf to explain.
Thank you, Mr. Chairman. Members, thank y'all for having me tonight. Committee substitute House Bill 2594 updates our venue statutes to ensure prosecutors can go after theft involving intangible personal property like digital funds or cryptocurrency in the county where the victim lives or where the defendant is caught or extradited. This bill ensures victims of cybercrime, fraud, and deceptive online theft are no longer left behind because of outdated rules about where a crime occurred. Specifically, Committee Substitute House Bill 2594 amends Article 13A.251 of the Code of Criminal Procedure to allow prosecution for theft of intangible property, personal property in the county where the victim resides, county where the defendant is apprehended, or county to which the defendant is extradited. Amends Article 13A.501 to mirror these changes for organized criminal activity cases, aligns Texas law with other venue states already in place for fraudulent use of identifying information, credit, debit card abuse, computer crimes, financial data theft. Thank you, Mr. Chair, members. I do believe you have a resource witness to
Do you have a
testify
couple
as
of
well.
witnesses? Any questions, members? Ms. Jones?
Quick question, where the defendant is arrested, where did you say the victim resides? You gave 3.
Repeat your question. Sorry, not hearing you.
You said it allows you to try, proper venue is where the defendant is arrested is 1.
Where the victim resides,
Where-
where the defendant is apprehended, or the county to which a defendant is extradited.
Okay,
That's
thank
in
you.
that's 13A.251.
Members, any other questions? All right. Replo.
I just want to say, I've been involved in some civil cases with clients that had these kinds of things going on, or clients that came to me with this, and this has always been an obstacle for police to get involved. They don't know where the crime occurred, and they don't know even when this has always been a problem. And so, thank you for addressing that.
Thank you,
That's all I got.
Representative Money. Thank you, Mr. Chairman and members. I reserve my right to close.
Member, if there are no other questions, we'll call our first witness.
Thank you, Mr. Chairman.
First up is Michael Gutzman. Mr. Gutzman, I hope I pronounced your name right, and I have you as representing the Montgomery County District Attorney's Office?
That's
You have it, Montgomery County District Attorney, that's fine, and representing yourself as well, is that correct?
Yes, sir, that's correct.
And you are for the bill?
I am.
Okay, please go ahead.
I'd like to thank you, Vice Chair, members of the committee. My name's Michael Gutzman. I'm the Chief of the Major Crime Section with the Montgomery County District Attorney's Office. I was formerly a prosecutor with the Harris County District Attorney's Office, and I'm board certified in criminal law. Traditional venue rules were designed for physical crimes, not borderless digital offenses. Texas prosecutors face limitations when charging cases involving theft of intangible personal property, such as funds from financial institutions and virtual assets like cryptocurrency. These limitations stem in part from unnecessarily narrow venue statutes that often prevent prosecution in the county where the victim resides. Both virtual assets and funds held by financial institutions exist in a non-physical form, making it infeasible or at times practically impossible to prosecute a case in the county where the property was stolen or through or into a county where the property was removed. These proposed amendments to the theft and organized criminal activity venue statutes aim to empower Texas prosecutors to more capably serve victims of cybercrime, deceptive forms of theft, and fraud. Additionally, the proposed amendment also provides consistency with our existing legal framework by aligning the theft and organized criminal activity venue statutes with other statutes for similar offenses such as fraudulent use or possession of identifying information, credit card or debit card abuse, computer crimes, and unauthorized acquisition or transfer of certain financial information. I'm happy to answer any questions that the committee might have.
Members, are there any questions? All right. Thank you very much.
Thank you.
Appreciate your time. Next up is Doug McConnell.
I believe I signed up in error.
You're going to have to come up now. I'm sorry, we're gonna, is your name, just confirm, your name is Doug McConnell, you're representing, what? Doug O'Connell, I can't read, I'm sorry. Representing yourself, and you're for the bill, is that right? And you can just say like, yes, and then I don't want to testify.
Well, no, give
Oh.
permission. You did not ask for it. I don't think you wanted to testify.
Okay, would you allow us to change your registration so that you're shown as not testifying, but for the bill?
Mr. Vice Chair, if I may.
What? Oh,
I
I'm sorry,
signed up-
you're signed up completely wrong on the.
Absolutely.
I'm sorry, I didn't understand. May we have your permission to delete you from this
Yes,
bill?
please.
Thank you very much.
Thank you.
Did not understand that. Thank you. I got it. Thank you. Okay. Is there anyone else here to testify on, for, or against House Bill 2594? If not, seeing none, we'll call up Mr. Metcalf to close.
Thank you, Mr. Chairman, members. I respectfully ask for your favorable consideration, and I close.
Thank you very much. Members, any questions? Right. Thank you very much.
Thank you, members.
Next, I'm sorry. This time, Chair will withdraw the sub. It has been a long day. Thank you. And we'll leave it pending. We'll leave House Bill 2594 pending. Okay. Next up, Chair calls up House Bill 5525. Mr. Pursuit. Okay.
Thank you, Mr. Chairman, members of the committee, for the opportunity to lay out House Bill 525. Pretty simple bill. Under current law, you can subpoena an out-of-county witness in a criminal case if it's a misdemeanor with confinement in jail or a felony. But currently, you cannot do that if it is a fine-only offense. This bill simply amends it to say, in a misdemeanor case that's a fine-only offense, you can subpoena a peace officer residing outside the county in order to testify. Basically, what my county brought to my attention was there's several instances where a DPS officer was relocated to another area of the state, and then they couldn't subpoena them to testify to the violations that they had written, and so they just had to be dismissed. So that's an issue with making sure that we're having justice served whenever our peace officers move. So happy to answer any questions.
Thank you. Members, any questions? Rep. Jones.
Now, I'm sorry, you were talking fast. Now, officer is transferred to some other part.
Sure.
So this doesn't have a distance restriction, is that what
No,
you're
anywhere in
saying?
the state.
Seriously?
Yes.
Do you have to pay for it?
The county does. They get a payment, I think it is compensated in the same manner as felony cases. which is on second to last sentence of Article 2416. So they're paid.
So question, law enforcement agencies, are they okay with this, like snagging their?
I
I'm just
haven't
asking.
heard of any opposition from DPS or otherwise. I mean, my view is simply this: you write the ticket, you ought to be able to testify for it. So, fair enough.
Red Bunny.
And I suppose if they didn't want to pay the price to bring him in,
Then the
they-
prosecution would make that decision.
can make that decision.
We'll dismiss this case. We don't want to pay the cost to bring the
but
witness.
at least gives them the opportunity if they want.
Yes.
Great.
It's all about discretion for the prosecutor.
Members? Any
Y'all
other
have
questions?
exhausted my knowledge of criminal law.
Thank you very much. We'll call our first. Oh, here we go. It popped up. All right, chair calls Richard Hayes.
Wait a minute.
Are you on this? Oh, junior. Well, it's not.
There's not, it doesn't say junior on there.
I don't believe I'm registered on this one.
This is points of orders for everybody's bill. Sorry, they're all dead. Can we have permission to delete you from this record?
Absolutely.
Thank you very much. And you are Mr. Richard Hayes.
That is correct. Not Representative Richard Hayes.
Would you like to be? Okay, is there anyone here testify on, for, against House Bill 525? Seeing none, recognize Representative Vasu to close.
I close. Thank you.
Thank you very much. Members, are there any questions? Seeing none, Chair at this time will leave House Bill 525 pending, and we'll call up House Bill 2761 by Representative Johnson. And Representative Johnson, you have the floor. Do you have a substitute?
I do not.
Okay. Please proceed.
Thank you, Chairman, members. Thanks for the opportunity to lay out House Bill 2761. I know it's been a long day, and it's going to be a long night for you all. I had the privilege of being appointed in 2007 to represent a 13-year-old little girl who was charged with prostitution. It took 3 years to get that case to the Texas Supreme Court, where they said that child was the victim. She was not the offender. She could not engage in prostitution, and we should go after the people selling her. Fast forward to my days as your chief human trafficking prosecutor, and a gentleman sold his 4-year-old daughter after he put her to sleep. Inexplicably, the Court of Criminal Appeals determined that because that child could not consent to sex, he could not only not be convicted, they reversed and remanded on an attempted. And so this bill makes it very clear that in Texas law, if you are selling a child, you do not get a get-out-of-jail-free card because the state of Texas does not want that child to engage in sex with an adult for a fee. And so this language says that a child or disabled individual lacks the mental capacity and that they do not need to complete the act of prostitution in order to go after a perpetrator of one that traffics or continuously traffics a child or disabled individual into prostitution. Mr. Little, thank you for joining me on this bill. I appreciate that it is a cleanup, but we do not want any other defendant to benefit from a misunderstanding of the law and to make it very clear that perpetrators will be held to the highest account in Texas.
Members,
love
are there any
that.
questions? Okay. Seeing none, sorry. We'll call.
Reserve the right to close. I will tell you there were a number of witnesses that were here this morning. Somebody from the Harris County DA's office, a mother whose child was trafficked and killed, and an organization, all of which have signed on in support of this bill. And I would appreciate your favorable consideration getting this passed and signed as quickly as possible so perpetrators are not taking advantage of a court ruling out of the Court of Criminal Appeals.
Thank you very much, and apologies to all the witnesses who came
No problem.
today and had to wait around for 8 hours. We'll call up our first witness, Rhonda Kirkendall. I hope I did that right. Okay. We're going to show her as for the bill but not testifying. Are there any other witnesses on, for, or against House Bill 2761? Seeing none, recognize Reps. Johnson to close.
Thank you. I close.
Members, are there any questions? Seeing none, Chair will now withdraw, leave the bill pending, and thank you. Thank you very much. Okay. What? Chair calls up House Bill 1604 by Busey, and Rep. Busey, please proceed. Do you have a substitute?
No.
Okay, thank you. Please proceed.
All right, thank you, Mr. Chairman and members. This is a bill we had last session. Everyone that's returning supported this bill last session. We didn't get it out late in the process in the Senate. Let me tell you what we're doing here. First, let me thank you all for allowing me the privilege to lay out House Bill 1604, which makes sure that initial court appearances under Article 15.17, known commonly as magistration or bell hearings, are open to the public. Simply put, this bill is about transparency, accountability, and fairness, fundamental Texas values that form the foundation of our legal system. In Texas, court proceedings are supposed to be publicly accessible. Access to public hearings is meant to ensure equal treatment for defendants, legal transparency, and judicial accountability. Magistration is a pivotal moment in our criminal justice system. For the defendant, the right to presumption of innocence and liberty are at stake. For taxpayers, defendants can be sent to jail at taxpayer expense. And for the community, this is the moment that decides who stays in prison and who is released back into the outside world. Just last year, the Fifth Circuit ruled against Caldwell County, which had a policy of categorically excluding the press and the public. Other counties in Texas have had a similar practice. This is not good for the defendant, the prosecution, or the public. We do have, I think, one person testifying today to talk about how this is happening in the real world. If you see in the bill, we're really just adding that you must do this for proceedings under Article 15.17. All trials and courts are supposed to be present. It's just not happening consistently across state. We just want to make sure it is. With that, I'd be happy to answer any questions. Like I said, we have one witness that's seen this mistake not being implemented, so that's why we want to clarify.
Members, are there any questions?
Yes, Chair.
Rep. Little.
Thank you, Chairman. Representative Busey, I was reading your bill and trying to understand, because I'm not involved in this process. I never have been. What is it that we're trying to get into the public that we can't, and why do we want it in the public?
We just want bail hearings to be public. I mean, right now, most people believe that the whole trial process should be public. As outlined in the law here, trials in all courts shall be public, but not all of the magistration hearings are. Sometimes it's practical reasons. It takes place in a small room, in a jail. So that's why we have modernization options in here as well. But it's just to make sure it's public. And I think we'll hear from our witness about why lawyers want it, why witnesses, and also I just think for transparency purposes, to meet the standards of what we believe the law to be, we want it to be done. And it is being done that way most of the time. It's just not being done consistently everywhere.
Is there, are you aware of like a specific case or instance in which you?
Yeah, I know my witness can speak more to it, but I actually do have some. Fifth Circuit Court had to rule here. Give me 1 second, I'm sorry, sir. I have so much information here. Fifth Circuit rules press and public access on Texas magistration. November 18, 2024, an opinion authored by Judge Vedder. Fifth Circuit panel made up of judges. I'll skip some of this. Temporarily enjoining Caldwell County, who was not doing it. They had a general policy that they would not make them public. We have another one. I can give you some more.
No, that's okay.
Okay.
That's kind of what I was looking for. It's interesting to me. I'm ignorant as to who's doing it and not doing it. So thank you for explaining that.
There's been about a handful that I know of, and I think my witness will probably be able to speak to more.
Thank you.
Yep. Thank you, sir.
Rep. Jones.
Sir.
And I can help you out. So magistration generally is secret, right? People are arrested. Their families don't know where they are. You don't know what happened. They disappear for however long. And I just think it's now, like, for example, in Harris County, they now have, like, videos where you can see stuff. But generally, I mean, I literally have looked for a client. I knew they were arrested, but couldn't find them for, like, 72 hours. I'm trying to, like, bail them out, can't find them. And so that's when they're, like, I should say, like, the most alone. It's before they have a lawyer most times. And only recently in Harris County have they even given people in magistration lawyers. In some places, they don't give people in magistration lawyers. So that's why sometimes you'll have like super high bails, because they're just there by themselves, and everybody's got a lawyer but them and the judge. And the judge generally just listens to what the prosecution says.
Yeah, I think at the core, we just want consistency across the strait and transparency in the process. All right. Mr. Chairman, I reserve the right to close. Thank you, sir.
Thank you. Members, if there are no other questions, we'll call our first witness. Kristen Budwine. Okay. Kirsten, dude. If you would, if you can diagram the pronunciation for everything.
That's good public school education.
Thank you, Kristen. Kirsten.
Kirsten, it's all good. You'll have it by the end of the night. My name is Kristen Budwine again, a policy attorney with the Texas Civil Rights Project. I live in
I'm sorry, let me just confirm. You're Kirsten Budwine, Texas Civil Rights Project, representing Texas Civil Rights Project, and you're for the bill, is that correct?
Yes, sir.
Thank you very much. Please proceed.
I literally just have one sentence. It's especially crucial for the public. Well, I'll start with this. The Texas Constitution is clear. All courts shall be open. It is especially crucial for the public to have access to bail hearings where an individual's liberty is being determined. For these reasons, we fully support this bill.
What was the last thing?
We fully support this bill.
Good. Members, any questions? Thank you very much.
Thank you.
Nick Hudson. Mr. Hudson, I show you as representing the American Civil Liberties Union of Texas, and you are for the bill, is that correct?
Yes, sir.
Okay. Please proceed.
We first found out this was such a widespread issue because DAI was testifying before a Senate Finance Committee hearing in July of 2022, and she talked about how some of the criminal law hearing officers in Harris County were conducting these hearings behind closed doors. And we got up and said, well, we agree that that's a problem because, as Ms. Budwine said, really important decisions that affect public safety, that affect people's lives are being made in these hearings. I know that Representative Busey has been working with the Sheriff's Association, other folks to get to an agreed-to version. I will say we had some interns call through. One of our interns, Viviana Collymore, called through. We really were looking at who was on the committees at the time because we wanted to talk to y'all about. This was in June of last year, and we identified out of about 47 counties they called through, 42 responded, and 24 of those reported no public access in any kind of way, no virtual access, no public access to these types of hearings. I'll also just say, I think that this is sort of a cleanup bill because the Article 1.24 of the Texas Code of Criminal Procedure says already that the proceedings and trials in all courts shall be public. I don't even, as you can see, it's sort of just a little addition to Section 1 of the bill. I'll just say I'm happy to share the list of counties where there was no public access reported. Since then, there was a Fifth Circuit ruling that affirmed the public's right to access these hearings, and happy to be a resource if I can be.
Which were first? Thank you. Members, any questions? Thank you very much.
Thank you.
Are there any other witnesses to testify on, for, or against House Bill 1604? Okay. With seeing none, call up Representative Busey to close.
Thank you, Mr. Chairman and members. Again, this is a simple cleanup. We think this should be the way it's already interpreted under the law, but we want to make sure that it's being done consistently and transparently for everyone. If there's
Members,
no further questions, I close.
Are there any questions? Seeing none. Thank you very much. And at this time, House Bill 1604 will be left pending.
Thank you, Mr. Chairman.
Thank you. Next up is House Bill 1418. And Representative Shansline, you may have the floor. Do you have a sub or anything?
I do not have a sub.
Thank you. Please proceed.
Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to present House Bill 1418. House Bill 1418 aims to strengthen the integrity of our criminal justice system by placing necessary guardrails around the use of in-custody informant testimony. The intent of this bill is simple: to prevent wrongful convictions based on unreliable, incentivized testimony from jailhouse informants. We've seen too many cases across the country and here in Texas where convictions were later overturned due to false testimony from individuals who had everything to gain and nothing to lose by fabricating statements. This bill does not eliminate the use of in-custody informants, but it ensures that their testimony is corroborated by independent evidence before it's admitted in court. This bill requires that any testimony provided by a person who is in custody with a defendant must be independently verified before it can be used against them at trial. It also mandates disclosure of any benefits offered in exchange for the testimony. The goal is not to make prosecutions harder, but to make convictions more trustworthy. Members, this bill last session passed out of the House and did not make it all the way through in the Senate. We have a couple of witnesses, I believe, and I'm happy to answer any questions. I would also like to reserve my right to close.
Members, do you have any questions? And that, with that, seeing none, we will call our first witness.
Thank you.
Thank you. Kirsten Budwine. And Ms. Budwine, I have you representing the Texas Civil Rights Project, and you are for the bill. Is that correct?
Yes, sir.
Thank you. Please proceed.
So again, Kirsten Budwine, a policy attorney with the Texas Civil Rights Project, here in support of HB 1418. Although I do not practice criminal law, I support any legislation that can help reduce the number of wrongful convictions in our state. According to the Innocence Project, at least 13 people in Texas have been exonerated in cases involving jailhouse informants. You've heard the tragic story of John Noley. Well, you haven't heard the story, but the story of John Noley was laid out in the bill. The bill is named after him. I'd like to highlight another story, Benjamin Spencer. Just last year, Mr. Spencer was exonerated after spending 34 years in TDCJ. His conviction was based in part on false testimony from a jailhouse informant. Mr. Spencer is one of the top 60 longest serving inmates or incarcerated individuals to be declared innocent of the crime, according to data kept by the National Registry of Exonerations. It took the Dallas District Attorney, John Creuzot, stepping up after 4 previous DAs failed to act, and a defense attorney who spent over 2 decades tirelessly working to untangle the web of lies that led to Mr. Spencer's wrongful conviction. This bill introduces safeguards to protect innocent Texans from the dangers of unreliable jailhouse informant testimony. When we hear horrific stories from crime victims, it shocks our conscience. We ask how one human could do that to another, and then we act. We advocate, we legislate, and we do everything we can to prevent another tragedy. We should feel the same urgency here. No one should become a victim of the system like Mr. Noley or Mr. Spencer. We all have a role to play in ensuring justice works for everyone. For these reasons, we support this bill. Thank you.
Thank you. Members, are there any questions? Let me just ask you real quick. So this bill, the provision would basically be like very similar or mirror the co-conspirator testimony rule, or you don't practice criminal?
Don't. Yes, sir, I don't.
Never mind. Thank you. Appreciate it. Members, any other questions? All right. Thank you so much. Next up is Allen Place. And Mr. Place, I have you representing the Texas Criminal Defense Lawyers Association, and you are for the bill. Is that correct?
That's correct.
Thank you. Please proceed.
Thank you. Just a couple of notes that this bill addresses what we believe has been a chronic problem, which is unreliable in custody testimony. But the bill addresses it in terms of a vetting procedure. It doesn't just say shall or not use or whatever. What it does is it's very thoughtful in basically how it sets it up. After the definitions, it goes into a notice procedure to both sides, obviously. Then there's a hearing, and then at the end of that hearing, there's a balancing test that the court would have in terms of whether you're going to use the evidence or not. The other part of the bill, it has a number of detailed considerations of things that the court is to look at in determining that what leads to that, to the balancing test. And so I think if you read that, I think there's 6 or 8 of those that basically just address what you're looking for. And so what it does, it basically, the court is vetting under the guidelines that y'all give them, whether or not to admit this type of testimony. And so we think it's a bill that addresses a real problem. We think it does so in a thoughtful and effective way. I'll take any questions.
Thank you very much. Rep. Little.
Thank you, Chairman Wu. Mr. Place?
Yes, sir.
I'm struggling with the interplay between this bill and what currently exists at 38075.
Okay.
So 38075 calls for corroboration of, the header is corroboration of certain testimony required, and it actually does address the situation of a jailhouse snitch directly in 38075. And so this bill intends or purports to create a new section 38075-1, and I see those two sections as being in conflict. And because 38075 already has I'll call it a rubric or a process for how we use jailhouse snitch testimony, and 38075-1 appears to create a new rubric for the same testimony. So not replacing 38075, just laid next to it. Now, let me just start there. Have you given that any consideration, or am I misreading this?
No, I think this is clearly an extrapolation, goes into more detail. I think that's, I'd have to give it some thought about whether I would see it in conflict. I don't think so, but that's a legitimate question that I'd want to dig into more.
Okay, my next question for you is this. It appears to me that Section 3 of the bill creates a pretrial so it's entitled pretrial admissibility hearing. It is what it creates. But it's designed so the judge filters out before the trial whether any of this information is going to be used. Is that right?
That's my understanding, yes, sir.
Are there similar areas in criminal law where we have a similar process for pretrial determinations on admissibility of testimony?
Well, if you have a motion to suppress, that's clearly, pretrial, and that would be handled. And so when you got to a trial, both sides would be, they'd be understanding whether or not a particular piece of evidence, could be used, kind of thing. And I think that the notice provision, I highlighted that because I think it gives both sides knowledge ahead of trial that this is what the judge has ruled, and they're going to accommodate, both sides are going to accommodate their case to that ruling.
Okay. And Section 4 calls for discovery of certain information related to deals made with that witness, am I right?
Yes.
Okay. Isn't that already required to be disclosed under the Michael Morton Act, or am I wrong about that?
I think that's correct. I think to me that's a clarification in case there's any question, but I would think that it would already be.
Okay.
Should
Okay.
be.
And I'm sorry, I'm going to ask you another question.
That's fine.
About Section 6, the jury instruction. So, because I don't practice this, I want to know, it calls for a court instruction based on, the court is invading the province of the jury and telling the jury whether to disregard that evidence based on a couple of things, whether the court, saying the jury should disregard the testimony unless the jury determines, one, that the benefit wasn't unduly affecting the testimony, and two, that the testimony was truthful. Am I reading that right?
If it is admitted, that is correct, yes.
Okay.
If the testimony is admitted, that is correct.
And my question to you is that a common jury instruction for a judge in a criminal case to say, here are the circumstances under which you should disregard a witness's testimony?
Well, there's a general admonition of all witnesses to a jury that they are, as you know, even in a civil case, they're the ultimate decider, they're the finder of fact, and so you have a broad one. I'm sure if I thought about it, and tomorrow morning I might come up with something quicker, but right now I know there's a number of charges that you're going to have, and they're going to come off of this. What I would say is this: if it is admitted under this situation, it basically allows the jury to come in, and if they don't find these things, they can disregard it. Now, whether or not they're going to disregard it, to me, it's already out there. I think that's a challenge, I think, for the defense, basically, if it's already out there and to be entered. But it does give an argument to the defense that if they believe these two things exist, they're able to disregard that testimony.
So I think my biggest residual question is that
this is really a question for an expert like you or someone who practices this area a lot, is if this bill were passed into law, is it in conflict with 075? Would the proposed 0751 be in conflict with 075? I read them to be overlaying the same subject matter and therefore saying different things about the same subject matter and in conflict. If I had been asked to draft it, I probably would have replaced 38075, but I will leave that to someone who works in this area a little bit more. So
There's an overlap, there's no question. I think in this world, specificity, if you have a statute that addresses a certain situation, it's going to be the one that is going to be required to be used over something more vague.
Sure.
So I'm not saying that's the exact analogy you would use here, but I would think that would be close to that. And so
Okay.
I would say if this bill were to move, it is something that other section, if it appears clearly to be in conflict, then, you know, he may have some further drafting to do at some point.
okay, thank you.
Certainly.
Okay, any other questions, members? Okay, thank you, Mr. Place, for being here. The chair calls Amanda Marzullo. And your affirmation is that you are senior counsel for Austin Community Law Center and also testifying on behalf of yourself and you're for the bill, correct?
That is correct. All right. Thank you, Chairman Smithy. And as you probably remember, the Tim Cole Exoneration Review Commission identified informant testimony as a main driver of wrong convictions in our state.
Yeah.
So this is a really important bill. And Representative Little, to your point about 38075, that bill was really targeted for, so that bill passed in 2009. It was our first session, Representative Moody. And it was really targeted towards cases where people were convicted solely on the basis of informant testimony. So the cooperation there is to make sure that there is additional evidence in the case. This bill is figuring out and providing a rubric to determine whether or not the evidence should be admitted. And if it is, it's giving a framework for the jury to weigh it. And the reason why those things are really important is that, you know, we're headquartered in Austin here at our law center, but we practice throughout the state. And I'd say that we appear in front of a lot of judges who have a civil background like yours and are not familiar with jailhouse informants and all of the issues that they come with. And they don't have time to research it either. So having a framework that's evidence-based, that's based on the incentives that might influence someone's testimony, goes a long distance. Also giving the jury a framework to decide, hey, is the incentive so great that could influence their testimony, and then decide whether or not it's truthful. That's a normal, I'd submit a normal question to be asking in the context of these cases. Because informant testimony comes up in high-profile cases, often murder cases, and the incentives can be quite strange.
Let me see if there's any questions. Ms. Jones?
I was just going to say, I actually do, I mean, it's hard for someone who's not a lawyer sometimes to grasp, like, accomplice testimony all by itself is as a matter of law, like you're innocent or you're not guilty, right? Some people can't understand that concept because there's tremendous incentives to lie. And so I don't think that a special instruction for in-custody defendants is a bad thing. Because, again, I'll say this again, and I'm certain you know this, accomplished testimony alone is, you just can't find somebody guilty if that's all you have. And so for the jury to have to determine that the testimony is truthful, right? And to know, because a lot of times they literally don't tell us what the informant got for their testimony. Like, they'll skirt it, and this requires that. We'd like to know what they got. like if you were facing, if the first offer that you got was life in prison, and if you testified truthfully, in air quotes, then we'll offer you 15 or 20. That is substantial, and I think a jury needs to know those types of things.
Yeah,
and I don't think that they're similarly situated to like non-custodial testimony. I
Yeah.
just think they're different, fundamentally.
And just to add to your point, it's often the case where, in the informant's case, they leave that pending. So it's an open question about what they're getting in exchange for their testimony, and that's actually something that the prosecution can hold over their heads.
And I was gonna get to that. So it depends on how truthful you testify, i.e., did you help me get a conviction? People will say anything to get out, and if the prosecution doesn't like how the informant testified, then they can yank it. So I think that's a super incentive for the in custody witness to be as creative as they can be.
Exactly.
And I'll just leave it at that.
Mr. Little?
Ms. Marzullo, I think your testimony is actually very helpful to me. When Representative Schatzline was laying out the bill, he mentioned the word corroboration, but I don't think his bill is about the corroboration of that testimony at all. It's actually, you've got 38075, which deals with the requirement to corroborate it, and his proposed 380751, which is a rubric to determine whether it's admissible in the first place.
Yeah.
So that was actually very helpful. Light bulb came on. I got it. Thank you.
Okay, great.
Okay, thank you very much for being here. The chair calls J. Dan Gum.
He had to leave.
Okay, so we'll show Mr. J. Dan Gum in favor of the bill on behalf of forgiven felons and self, and he for the bill but not testifying. Is there anyone else here to testify on, for, or against House Bill 1418? If not, the chair recognizes Mr. Schatzline to close.
Thank you, Mr. Chairman and members, and Representative Little. I want to work with you to make sure this language is right, because I want to ensure that what we're not doing is muddying up any waters that are going to make it to where convictions can't take place that are legitimate. And so I'm incredibly dedicated to working with each of you to get this language right. Our heart in this bill is really just to ensure that when it comes to jailhouse informants, we have enough transparency in that process to not get wrongful convictions. And so I ask for your favorable consideration on this bill, especially if we need to talk through language, and I'm very willing to work with you on that. And with that, I close.
Thank you, Mr. Schatzline. Any question? If not, the chair will leave House Bill 1418 pending.
Thank you.
Thank you. Is Mr. Hopper, are you here? Okay, come on up if you would. The chair lays out House Bill 2333 and recognizes Representative Hopper.
Chair Smithy, Vice Chair Wu, and members, thank you very much for listening to my layout for HB 2333. This bill changes Texas Penal Code, Section 12.01, by extending the statute of limitations for felony election offenses from 3 years to 5. This would allow more time for prosecutors and investigators to bring a case to trial and would bring state law in line with already existing federal statutes, which is 5 years for election offenses. Election fraud is a unique crime that is one of the very few criminal offenses where the vast majority of violations all occur within the same time period around elections. As this committee is well aware, the statute of limitations dictates how much time can pass in order for a criminal indictment to be brought, and the clock begins when the offense is committed. A voter may not even become aware that their vote has been stolen until the next election years later. In case of mass vote harvesting, investigators could potentially have to collect hundreds of statements and thousands of documents to bring a single case. This puts investigators and prosecutors under a heavy time crunch, which forces them to prioritize cases rather than investigating all of them. Representation in our government is one of the bedrock principles of America and Texas, and part of that is ensuring integrity in our elections. One of the most important ways we can do this as legislators is maintaining the integrity of our electoral process and ensuring that our constituents feel represented by who they elect, and this keeps us as elected officials accountable to our voters.
I look forward to answering any questions y'all may have, and thank you very much, Chairman.
Okay, any questions for Mr. Hopper? Okay, yes, Mr. Burdell.
So if your bill is just changing it, statute of limitations from 2 years to 3 years, it's that simple?
3 to 5.
3 to 5. Okay, roger that. I appreciate it.
Okay, we got a couple of witnesses, so we'll call. The chair calls Lori Gallagher. Is Gallagher here? We will show Ms. Gallagher registering on behalf of herself and as a member of the Williamson County Republican Election Integrity Committee. Okay. I'm sorry, Lori Gallagher testifying on behalf of herself for the bill, but she's not testifying. We then have Fran Rhodes. Okay, Ms. Rhodes will show as for the bill on behalf of True Texas Project and self, but not testifying. And Lucy Trainer. Okay. Ms. Trainer, we have you on your affirmation as being testifying on behalf of yourself, and you're for the bill, correct?
Yes, sir.
Thank you.
Chairman, members of the committee, thank you for the opportunity to testify today in support of House Bill 2333. My name is Lucy Trainer, and I proudly serve on the SRAC for SD 25. For the past several years, I've been actively engaged in protecting the integrity of our elections, both professionally and as a volunteer, working closely with voters, candidates, and election administrators. Currently, the statute of limitations under federal election law is 5 years. This bill brings Texas law in line with this federal standard, recognizing that the current time frame is insufficient, particularly when considering the unique nature of election-related crimes. After an election, many key records and materials are tied up in statutory audits, recounts, potential contests, which delay the ability of law enforcement to access critical evidence. Investigators often cannot begin the work in earnest until well after Election Day has passed. So by extending the statute of limitations, this bill provides the breathing room necessary for proper, thorough investigations without putting undue pressure on our candidates, election administrators, or the election process itself, and ensures that law enforcement doesn't have to rush investigations or risk missing evidence because of tight deadlines. Furthermore, this bill allows greater collaboration between state and federal authorities, many of whom are already working together on cases involving mail fraud, wire fraud, and even civil rights violations that intersect with election law. Nearly every serious election-related crime has a federal component. Extending that time frame for prosecution allows for deeper cooperation and coordination, leading to stronger, more effective enforcement. This bill, I don't believe it's about politics at all. It's about preserving the integrity of our elections, protecting voters, and ensuring that no one undermines the trust we place in our democratic institutions. I respectfully urge this committee to support HB 2333 out of committee and onto the House floor. Thank you for your time, members, and for your service to Texas.
Thank you, Ms. Trainer. Any
Yes, sir.
questions? Appreciate you being here. Is there anyone else here to testify for, against, or on House Bill 2333?
Yes, sir.
Okay. Have you signed an affirmation?
I believe so. I
What
believe
is
I
your
was
name?
signed in whenever I got in.
What is your name?
My name is Aubrey Campbell.
I don't show one for you.
Okay.
We're
I
gonna
was
have,
invited by the representative. I'm not sure if there was something else that was additionally needed.
That's okay. We'll get you signed in. Can you get her signed in? We'll just have to stand at ease for a couple of minutes then, okay?
No problem.
Thank you. On yours, okay. I'm just telling you. Okay. Yeah.
So did you hear what I told the big boss?
Well, she's the big boss. I'm
Did
just
you
a
tell
little
what
boss.
I said? Did you?
And the committee will come back to order. And before you begin, I need to announce that House Bill 4933, which was on the posting for tonight, will not be heard this evening at the author's request, but will be reset at a later date. So if you're here for House Bill 4933, it will not be heard tonight. Okay, at this time, the chair recognizes Aubrey Campbell. And your affirmation shows that you are here on behalf of EFI, TBRT, and self, and you're for the bill.
Yes, I'm testifying in favor of the bill. I'm here on behalf of my own organization, Taking Back the Republic, tbtr.us, and with EFI, the Election Fairness Institute. I didn't type it all out because I didn't want to waste everybody's time.
Okay.
As has already been done. But I'm here today because countless investigations into election crimes have been sabotaged or otherwise collapsed before completion due to delays in access to what are supposed to be public records. Often investigators like myself and my team members are only provided with records that verify concerns over violation of election laws after the statute of limitations has expired, rendering the evidence useless and your laws unenforceable. Your laws are currently unenforceable. The reason so few election-related crimes are prosecuted is not due to a lack of evidence. It's because of the delayed release of public information in the narrow time frame to act on the very election where undue influence or improper practices have been alleged or documented. Reports like the latest from my group, TBTR Strategies, outlining the potential existence of an unlawful relational database linking ballots to voters, suggest possible election law violations on a massive scale. These claims can only be verified or debunked by accessing voting system software currently considered proprietary by voting system vendors. Gaining that access through courts or legislation is a slow and time-consuming process, as we see. But it remains the only path to any remedy for concerned voters. Extending the statute of limitations from 3 to 5 years would allow thorough investigations to be completed before the window to prosecute closes. And for that reason, I'd like for you guys to go ahead and, if you would, get behind extending the statute of limitations for election-related crimes from 3 years to 5, as I'm currently in the middle of an investigation that can no longer be prosecuted, regardless as to whether or not my findings are proven true in a court of law.
Okay, thank you very
Thank
much.
you.
Let me see if hold on, let's see if there's any questions for Ms. Campbell? Okay, we appreciate you being
Thank
here. Anyone else here to testify for, against, or on House Bill 2333? If not, Representative Hopper, do you wish to close?
Thank you, Chairman. I respectfully ask for favorable consideration of this bill, and I appreciate your time, and I close.
Okay, thank you very much. If there's no objection, the chair will leave House Bill 2333 pending for now. And let's see, Ms. Jones, are you ready on yours?
Yes, I was born ready.
Okay.
Yes, I am.
Okay, she has no witnesses. Yeah, I know. Yep. You want to go ahead and do yours? Yeah. You can do it up here or down there, either one. You can do it up here if you want to.
I'll stay right there.
Okay.
Good evening, Mr. Chair and members. I'm here to lay out HB 413, the You Already Served Your Time bill, a powerful, necessary step forward in the Texas criminal justice reform. HB 413 guarantees that no Texan is jailed pre-trial longer than the maximum sentence they could receive if convicted. If the most someone can get is 180 days in jail, they shouldn't be locked up for 2 or 3 years waiting for their day in court. This bill requires that a defendant be released on a pretrial bond once they've been jailed for the maximum range of punishment allowed by law. That's not just wrong, it's unconstitutional. This bill restores basic fairness and due process. Low-income Texans, people who can't afford bail, are often punished before trial, serving more time than they'd ever face if actually convicted. Defendants wait months, even years, behind bars for low-level charges that might carry little to no jail time if resolved. Texas is spending public money to hold people longer than the law allows us to punish them. HB 413 makes a narrow exception for defendants undergoing mental health evaluations or court-ordered commitments. It builds on Article 17.151 of the Code of Criminal Procedure, which already allows for release when trial delays occur. HB 413 strengthens that protection by tying pretrial detention to the maximum punishment allowed under the law and mandating release on a pretrial bond once that limit is reached. Harris County Jail holds over 10,000 detainees, many for low-level nonviolent charges. Across Texas, 3 out of 4 people in county jails are simply waiting on their trial, not convicted of anything. Some of those people are serving more time than they would if they were convicted and sentenced to the maximum. There's no fiscal impact. In reality, this bill would likely save taxpayer money by reducing unnecessary incarceration. It ends the wasteful practice of holding people longer than their possible sentence. It reinforces that pretrial detention is not for punishment and should not be a part of that. It helps protect the safety and dignity of both detainees and jail staff. Last session, this bill passed the House floor and was set for a Senate vote on the final day, but died waiting to be voted on. Last session, Senator Joan Huffman personally reached out to me and said she wanted to carry this bill in the Senate, and she did. This session, she is again committed to carry the bill when it reaches the Senate because it's right and it's just. This bill has bipartisan support, and Right on Crime has dropped a card in support. That support is meaningful and bipartisan and speaks to how necessary this reform truly is. Mr. Chair, some of my JAs are Pat Curry, Brent Money, Briscoe Kane, and Joe Moody. And let's see. I yield now for questions, and I don't think there are any resource witnesses, if any, but I reserve the right to close.
Okay. And one of your co-authors is joining you, Pat, Ms.
Yes.
Curry. And any questions, members? Okay. If none, and is there anyone here to testify for, against, or on House Bill 413? If not, you want to close, Ms. Jones? You want Mr. Curry to close? What do you think? You want to close?
Don't let him ruin it. Okay, well, this is kind of strange. I think she did a great job, but I will say this, that I support this bill. It happened to a family member of mine, and I have a little bit of experience in this. So I don't have a lot of experience in most of what y'all do, but I do have some personal experience with this. So with that, I'll be happy to answer a question, but this is Representative Jones' bill.
Okay.
And I close.
Okay. Thank you all very much. Okay, and if there's no objection, the chair will leave House Bill 413 pending. And so the chair would lay out House Bill 200 and recognize Representative Buckley.
Good evening, Chairman Smithy and members of the committee, and thank you for the opportunity to lay out committee substitute for a House Bill 200, a very, very important bill to me,
Hold on,
to my constituents.
There is a substitute, so let me get
okay.
Mr. Money to lay out the committee substitute.
Yeah.
Okay. Go ahead, I'm sorry.
Okay. We're good?
Go ahead.
All right. House Bill 200 is extremely important to many people in my life, and it is a bill that in a subject matter that I never thought I would consider taking up as a legislator. In Texas, children as young as 14 can be sentenced to spend 40 years in prison before they're even considered for parole. 40 years without anyone evaluating whether they've grown or changed. Most of these sentences were handed down during the tough on crime era of the 1990s, and many of those sentenced are now in their 40s. HB 200, also known as the Second Look Bill, reforms this system. It recognizes what the U.S. Supreme Court has affirmed. Young people are less culpable than adults due to their age, and they have a greater capacity for change. But let's be clear, any parent knows this well. Right now, once a youth is placed in the Texas Department of Criminal Justice, they're treated like an adult for parole purposes, with few exceptions. While juries are instructed that parole is possible, they're also told not to speculate on how it might apply. The process largely ignores the developmental differences between youths and adults. This bill changes that. It allows people who were convicted of serious crimes before the age of 18 to be considered for parole after serving 20 actual years, without counting good time credits.
It requires the parole board to consider age as a mitigating factor, accept expert mental health evaluations, and hear from those who know the inmate's growth and maturity. Members, most importantly, this does not guarantee release. It simply provides a chance for review. Those convicted of mass shooting-related aggravated assaults are excluded from eligibility. The bill creates a new section, 508.1541 in the Government Code, applying only to those under 18 at the time of the offense. The current adult parole rules under section 508.145 remain unchanged for those 18 or older. This law will apply to anyone sentenced or incarcerated on or after the bill's effective date, regardless of when the crime was committed. Texas holds justice and fairness as core values. While we believe in consequences, we also believe in redemption. A 16-year-old sentenced to 40 years may not see the possibility of freedom until age 56. That's not justice, that's life without hope. More than 1,200 Texans were sentenced as teens to decades in prison. Neuroscience confirms that adolescent brains, especially areas responsible for impulse control and decision-making, are still developing. Most young people who commit crimes outgrow criminal behavior as they mature. This bill reflects those realities. It offers a second chance to those who've changed, matured, and demonstrated rehabilitation. It balances public safety with the belief in human transformation. And it's fiscally responsible. A life sentence costs the state around $2.5 million compared to roughly $625,000 for 20 years of incarceration. This is not about opening prison doors, it's about opening a door of hope for those who've earned it. The committee substitute removes a drafting error in the bill that resulted in the addition of an affirmative finding requirement that was not intended to be included in the bill. The substitute will remove Section 2 and Section 3 from the bill introduced, which then requires the subsequent sections to be renumbered. In addition, the committee substitute adds exclusions for offenders who murdered a peace officer or a fireman who is acting in the lawful discharge of an official duty, and for offenders who murder more than one person. This returns the languages to the original intent of the drafters and the exclusions first introduced in the 87th legislative session. With that, members, I'm happy to take your questions. I do believe I have several witnesses, and I reserve my right to close.
Any questions for Mr. Buckley? Mr. Little?
Representative Buckley, how many people are we talking about in real life? Is it 5? Is it 50? Is it 500? I don't have a sense of the scale.
I believe there were about 1,200 that were sentenced throughout, mainly through the 90s. That is, we have a witness that can speak to those that are still incarcerated and can talk about, the scale of what we're dealing with.
Okay, thanks.
Yeah.
Mr. Moody?
No, and I'm trying to play within the confines, so I know we're supposed to ask you questions. Sure. But there was a really good question by Mr. Little over here that I'm just going to talk to you about. Mm-hmm. There is a discrepancy in some of the data from TDCJ. You'll hear numbers as low as 475 that this would apply to. Some numbers as high as what you stated. But we are working to get that. I know you're working to get that exact number, and I anticipate that you will have it and this committee will have it sometime tomorrow.
Okay, absolutely. Anything else for Mr. Buckley? Okay. Well, busy tomorrow.
I'll make sure to find you on the floor. You can be there, right?
You'll know where to find me.
So, anyone you want to call as a first witness, particularly? I've got a
Larry Robinson, maybe.
Great, thanks. Chair calls Larry Robinson. Show the screen. Mr. Robinson, your affirmation shows you're testifying on behalf of yourself and that you are for the bill, correct?
Absolutely, yes,
Okay,
sir. I have been for this bill for, since 2016. That's how long I've been working on this bill. So I am since you gave me 2 minutes, that's really gonna cut my time of what I really need to say.
Well,
But,
somebody may throw you a lifeline, let you talk a
all
little
right, there you
longer.
go, appreciate that. Anyway, I am a combat veteran of 24 years. And because of my numerous deployments and my military service, I lost my son. He was abused, neglected, and abandoned, okay? And I have blamed myself for the last 30 years because of his confinement. And it's something I think about every day. Jason's mother, I was stationed in Germany, and please forgive me for my maybe inconsistency, but I'm a little tired, of course, which I'm sure we all are. I was stationed in Germany, and Jason was 4 years old. His mom left the family, and here I was, a single parent in Germany, still having to do military service, of course, field problems, things of that nature. We know that being a parent is already tough, but being a single parent in the military was very hard. Leaving my 2 sons with strangers sometimes. Sometimes it wound up being good, sometimes it was bad. But anyway, about a year later, deployed back to the United States, stationed Fort Hood. Their mother called me up and said, hey, I would like to see the boys. And of course, I said, sure. And at that time, we decided to try to make the marriage work again. A few months later, I received a call from Department of the Army, and I had got selected for Special Forces. And I had 2 weeks to report to Fort Bragg, and couldn't take my family.
Let me just add, anybody having objection to letting Mr. Robinson have just a few more minutes? He's got a
thanks.
very compelling story, and
All right.
we don't want to cut you off. So.
And so, thank you, appreciate that. So, I, of course, deployed to Fort Bragg, and me and Jason were very close. And so he didn't take it he took it bad, you know. He started while I was deployed, he had a lot of issues at school, behavioral problems. It was bad. And my mission took about maybe 3.5 years, and during that time, I came home probably a total of about 3 months. That was it. And after that mission was over, I came back to Fort Hood, and I told my kids, my wife, hey, Dad's here to stay, not going anywhere. Well, Dad misspoke, because 2 months later, after being gone for 3.5 years, Iraqi war broke out. So I was gone again. Unfortunately, my wife then said, hey, I can't do this no more. And she left the family again. So here I was, 2 kids, having to deploy. Reached out to some family members, and my dad was the only one that was going to be able to take care of them. Well, during the course, Elizabeth Henneke, she was my son's attorney. During the investigation, she found out that my dad was beating or abusing my son. And so Jason had a lot of trauma in his life. Like I said, he abused alcohol, he did drugs. There was mental issues there that I did not know of because of my deployment. That's just things that I did not see. And so let me tell you who he is though now, because it's amazing. And if you read his letter, you will see the maturity, how he has changed. Because we know that we have data that after 20 years, juveniles age out of crime. He has gotten his GED. He's finished all the courses pretty much in prison. He's got 2 college degrees. He's got a paralegal degree. He's got HVAC certification, which he uses to work on equipment there in the prison. And right now he's working as a boiler technician. And he has never joined one single gang, and no serious offenses against him whatsoever. It's amazing. I don't think I could have stayed in prison for 30 years and not done something. but this just shows his mentality. And he's the kind of person that we would like to see about giving a second chance to. And so I would appreciate you passing this bill and giving him and others like him a second chance. I'll take any questions.
Let me ask, how old is Jason now?
He is 46. He was 16 when he went in. And again, he will not see parole until he is 56. And the thing about that is he may be set off for another 2 or 5 years. So it's, again, let's just say it's no guarantee.
Any questions, members? Ms. Jones?
I just want to say thank you. I've had the same thing in my family. I have a cousin who got locked up. And when he finally did parole out, has never been in trouble and is like the perfect citizen.
Right.
But if you look at what he did, people would think that he didn't deserve redemption. And like you said in there, for him to have been there for that long,
Right.
trouble finds you. It's real easy to do bad. It's
Right.
harder to do. And you have to work hard to not get in trouble when you are in prison. So that tells me that he has incredible character.
Takes after his dad.
Okay, makes sense to me. So thank you. And I think this is a good bill.
Yes, ma'am.
And I think we need to revisit how, as my grandmother used to say, we're not the worst thing we've ever done, nor are we the best thing we've ever done.
Right.
Thank you.
And we all, I think, appreciate your service as well.
Oh, thank you.
Mr. Verdell?
Mr. Robinson, I just want to say thank you for coming here and standing up for your son today. Appreciate that.
Oh, I'll keep doing that. I'll keep doing that.
Well, he's lucky to have you for a father, so,
I think so, too.
yeah.
All right. Thank you. Appreciate it.
Well, let me ask you, is this picture here, this photograph, is that Mr. Cook in the picture and Mr.?
It sure is.
Buckley?
That's
Okay.
my man right here, and my
Okay.
other one right here. This is my my district rep, so, yeah.
Okay.
So, yes, I just want to talk a little bit about, I mean, I know you had limited time, and so
Yes,
I know
sir.
you didn't get into the details of the crime, but, and I want to just get into that just a little bit. So, Jason was 16 when this happened, correct?
Correct.
Okay. And he was convicted under a theory
Law
of
of parties.
Law of parties.
Yes, sir.
And so can you, just from your perspective, can you tell the committee kind of what that means from your understanding?
Well, my understanding is that the individual that did the killing,
Was not Jason, correct?
no, it was not Jason. In fact, Jason didn't even want to go. He had called his stepmother. I got remarried, and he did not want to go through with it. But when he called her and said, "Hey, can you come and pick me up from school?" she said no. So, peer pressure, he decided to go along with it. But because of in fact, it was my sergeant major.
So just slow down just a minute. We're going to take some time on this, okay?
Okay.
So talk about the day at school. What happened? Take it from the school forward.
Okay, so he was at school, and my sergeant major's son is the one that killed the individual. I think he had been smoking pot, and that the whole thing was they had watched this movie called Blood In and Blood Out, and they got this idea to rob a pawn shop, and so that's what happened. They robbed a pawn shop, but because of I think the law had changed the year before the crime. If you were just a getaway driver, you would get the same punishment as the individual that did the killing.
And so in this particular situation, they left school, went to a pawn shop?
Went to the pawn shop, yes, sir.
And then just go ahead and tell the committee what happened after that.
So they went to the pawn shop. Again, they just, back in the 90s, being in a gang was glamorized. And they were just a bunch of neighborhood kids that called themselves a gang. So they decided to, again, after watching the movie, they went from school, and they had drove a couple of times. I mean, it was something they really wasn't going to do. It was kind of like talked about. But anyway, when they finally decided to do it, went from school, went to the pawn shop. My sergeant major's son, like I said, I think he tied the guy up or something like that. And again, Jason was there, but my sergeant major's son is the one that killed the individual, and Jason, he was horrified because he wasn't expecting that to happen.
So was Jason outside initially, sitting in the car?
Initially, I think he was inside, and he went outside to throw up. That's what happened. He went outside.
And so the gentleman's, do you know the gentleman's name that actually killed the?
I forgot his name, but again, he was my sergeant major's son, so yeah.
So,
yeah.
let's just say the shooter.
Yes,
All right,
okay.
All right, so where is the shooter at today?
He's in another facility, right.
Okay. And was he released at any, has he been released at any time?
No, no, sir. He'll never get out. He'll never get out.
And so was there a third person involved?
There were quite a few kids involved. So some of the kids that were involved, if you will, turns, I guess, state evidence. And so nothing happened to them. In fact, I'm in contact with one of the young men now. And yeah, there were some things that he said that I probably shouldn't say, but yeah.
Okay. And so again, just to sum up what the bill does, is this just puts Jason in front of the Board of Pardons and Parole, correct?
Yes, sir. It just puts him in front. Like I said, it's not a guarantee of him being released. And I will tell you that some of the kids that have, second lookers, if you will, that have come up for parole have been set off for another 2 years, or like I said, 5 years. So again, it's just a look. I think a lot of folks get mixed up and they think that it's a get out of jail free card, which it's not. It's just a look. So it's up to the parole board to make that decision, which in Texas, we have one of the hardest parole boards in the country. So it's not going to be an easy task.
Well, thanks for being here, and thanks for fighting a good fight.
Yes, sir. Thank you.
Thank you for being here.
All right.
Okay. The chair calls Shannon Jaquette. I'm sorry. Go ahead. Okay. Come on. Yes. And your affirmation shows that you are here on behalf of yourself and that you're for the bill.
I'm
correct?
actually here on behalf of the Texas Catholic Conference of Bishops.
Okay. Oh, good. I'm
If
sorry.
yeah.
So let me repeat that. You're here testifying on behalf of the Texas Catholic Conference of Bishops for the bill, correct?
Yes.
Okay.
My name is Shannon Jaquette, and I am the Policy and Education Analyst at the Texas Catholic Conference of Bishops, testifying in support of HB 200. The Texas bishops support criminal justice reform that provides for compassionate treatment of prisoners, responds to the needs of victims of crime, and encourages rehabilitation and forgiveness for those reentering society. HB 200 reduces the amount of time an inmate sentenced for a felony offense committed before the age of 18 must serve before becoming eligible for parole. It also requires additional parole considerations, including the diminished culpability of juveniles, the hallmark features of youth, and the greater capacity of juveniles for change. Research in psychology and neuroscience provide evidence that the brain is not fully developed until early adulthood, which should be a major consideration for not only the computation of parole eligibility dates, but the granting of parole itself. HB 200 is a significant reform that contributes to a system of restorative justice. The passage of this bill will provide hope to the incarcerated by providing a meaningful opportunity for release and increasing the likelihood of positive transformations. We thank Representative Buckley for filing this legislation and ask you to support HB 200.
Okay. Thank you. Any questions for Ms. Jaquette? Appreciate you being here. The chair calls Nikki Presley. And Ms. Presley, your affirmation shows that you're the Texas Director for Right on Crime and the testifying also on behalf of Texas Public Policy Foundation.
Yes, sir.
For the bill, correct?
Yes.
Okay, thanks.
For the record, my name is Nikki Presley. I represent the Texas Public Policy Foundation, and we are in support of House Bill 200. I want to thank you all for the opportunity to speak today and for being here tonight. I know it's been a long day. Texas has some of the harshest parole eligibility guidelines for juvenile offenders and fails to provide these individuals with a meaningful opportunity to reenter society. The majority of states have adjusted parole eligibility to better suit what research says about an adolescent's ability to mature and be meaningful contributors to society. And other states have shown great success with extremely low recidivism for these second lookers, as we call them. Considering what we know about juveniles having a greater capacity for change as their impulse control goes up and sensation seeking goes down, most young people are likely to be rehabilitated long before their parole eligibility date. Additionally, the parole board is made up of 7 men and women appointed by the governor. While they're tasked with a difficult decision, the board uses research-based parole guidelines and tools to assess an individual's likelihood for successful reentry and also analyzing the potential risk to society. I'm confident the parole board will continue to be judicious when determining the likeliness an individual will successfully reenter their community while also ensuring Texans are kept safe. To be clear, the goal is not to provide an escape from punishment, and this change does not mandate the automatic early release of a single individual. Rather, it only allows earlier consideration for certain defendants who have demonstrated maturity and rehabilitation since the sentence was placed on them as a juvenile. Thank you for your time, and I'm happy to answer questions.
Any questions for Ms. Presley? Thank you for being here. The chair calls Elizabeth Henneke. Ms. Henneke, I show that your affirmation is testifying on behalf of the Lone Star Justice Alliance for the bill, correct?
Yes, Your Honor. Your Honor. You bring lawyers up here, we say honor, Your Honor. Hi, my name is Elizabeth Henneke. I'm the CEO of the Lone Star Justice Alliance. We are a nonprofit legal organization that represents children between the ages of 10 and up to young adulthood 24 in legal cases. So I know many of you. The Second Look bill comes out of a series of Supreme Court cases that began in 2005, when the Supreme Court decided to eliminate the death penalty for children under the age of 18. It set maturity at the age of 18 as a constitutional matter. They've then taken up almost 6 cases in the intervening 20 years. So we have 2005 eliminating the death penalty. Then you have 2011, where they said youth is different with respect to collecting statements. And then the key case in this arena, which is Miller versus Alabama, in 2012, when the Supreme Court determined that, and it was Kagan writing, determined that, sorry y'all, I'm nervous, I don't know why. I think Larry made me nervous. So we have, the Supreme Court determined that mandatory life without parole was unconstitutional, determining that the 8th Amendment recognized what all of you do, which is that kids are different from adults, and that actually entitles them to constitutional protections. And just a few years later, 4 years later, in 2016, the Supreme Court again took up the issue and determined that Miller was retroactive. And I want to make sure to make that clear, because one of the key provisions and controversies around this bill that has kept us here for 8 years is that it's retroactive to kids that were convicted in the 90s. The reason is because the Supreme Court has determined that this provision of the 8th Amendment is retroactive. I think I'm out of time.
Well, you've got till it goes red.
Okay, great. So this is a retroactive provision. Most of y'all are lawyers, so you know how rare that is to have a retroactive piece of law. And then they took up the issue again. Can I finish?
Finish your sentence.
Perfect. 2021, and in Jones versus Mississippi, Kavanaugh, writing for the majority, affirmed 42 times that Miller is good law and that it is up to the states, y'all, to determine how to implement the full Miller provisions.
Okay. Any questions, members? Okay. Mr. Cook or Mr. Moody?
I know part of the bill we focuses on the review taking place in front of the parole board. And we talk about the hallmarks of youth. And I know that Dr. Buckley talked about this in his layout, but right now as it stands, youth of the offender is actually a factor that works against these individuals, is it not?
Correct. And in fact, kids who commit, for instance, capital murder are less likely than an adult by more than 2 times to get released. So if you are an adult offender who commits a capital murder, you're going to be released at about 10% rate. Some say 8% depending on the time frame and how you define it. But what we know about kids is less than 17 people have ever been released that were convicted of capital murder, which equates to about 4.6% who have come up.
And so, and that's the part I wanted to highlight in the bill. The language that's used there comes straight from the United States Supreme Court case when they talk about the hallmarks of youth. This is not language that was pulled out of thin air about how we evaluate youth and the offenses. Can you talk about how congruous those portions are, the bill and what the Supreme Court ruled in Miller?
Correct. So in Miller, it set forth 4 predominant factors that they should consider that they found were biologically and constitutionally required to consider. So these hallmark features of youth include age and the associating physiological components that impact you, impulsivity, for instance. 2, susceptibility to peer pressure. You heard the story of Jason, who's at school. What Larry, if you don't mind, I'll fill in a little bit. What Larry didn't fill in is that Larry had been deployed at the time that his son was living at home and was kicked out by his stepmother. So he had moved in with his master sergeant to stay with him while he was out. And the master sergeant's kid said, let's go, let's do a pawn shop holdup. So the peer pressure is constitutionally relevant. You also have capacity for rehabilitation. Kids' brains are malleable, and therefore they have a great capacity for rehabilitation. And then finally, the 4th one is there, and it's late at night, and I'm gonna blank on it. It's their social history. It's their environment for which they cannot extricate themselves because they're children. My apologies. And just to be clear, Speaker Moody, we do know that in Jones versus Mississippi, Kavanaugh writing says this type of legislation he endorses as a potential way for the states to cure problems with these 8th Amendment violations. So he puts forward 7 different options. I've always believed that this is the one that is the least intrusive on victims' families who thought that their cases were complete and therefore had hoped that their cases were complete. I think doing it through a parole board, especially in Texas, where that parole board is appointed by Governor Abbott, is the most likely to be the least intrusive way to cure the constitutional deformity while at the same time not rehashing a new trial for victims.
Okay, any other questions, members? Okay, Mr. Cook?
I'd asked a couple questions earlier about law parties. Can you give us any information in that regard?
Yes, sir. One of the things that we know, so our organization has talked to 770 youth who are involved in this, thanks to a partnership with the University of Texas School of Law. What we know is that if a kid is a primary shooter, they can understand, and Sheriff, you probably know this too, they'll plea, right? They understand that they're the primary and they're going to accept a plea. And in looking at about 770 cases, at least what they told us is that most of them are law parties cases, meaning that they refused to plea because they didn't understand that they were equally culpable for those who were the primary shooters. So they refused to plea and ended up with the mandatory maximum sentences of life. We do know of several cases in which the shooter, for instance, is already released. So there's one case out of San Antonio that's a perfect example, similar to Jason. It was a convenience store case in which they both randomly went in to steal candy. That's actually not a made-up fact. These 15-year-olds went in to steal candy, and then one of the older neighborhood kids came in after and shot a store clerk. The 2 16-year-olds are still in prison. The older kid has been released for almost 12 years. And so there's these inequities that are occurred in the law, and we just are asking the parole board to take a look at them and to consider them.
Yeah, just for what it's worth, I think, those individuals that you just described, it should be an automatic, appearance before the parole. Like, in the situation you're talking about, did the person that's been out for 12 years, have they been out because their sentence ended or because the parole board let them out?
Both, actually. I know of multiple instances. In the one I'm talking about from Bexar County in particular, he actually maxed out his time, and he's already out because he pled to 9 years.
Yeah. But in either scenario, that's a failed system.
Correct.
Number one. Number two, if the person that's the juvenile at the time should have an automatic appearance before they should be automatically eligible. If the state of Texas is making a decision that a shooter should be dismissed from prison, either whether that's by fulfilling his sentence or by the board of pardon and parole letting that person out, then by default, the person that was convicted based on a law party's theory should obviously be considered for release as well. So.
And thank you, Chair. And I think just your question, if I may just answer your question that you asked, Larry, that's one of those things about being a lawyer. You sometimes get to know the facts crazy well. In his case, the actual person who killed the pawn shop owner, while he is still in prison, he will come up for parole before Jason will. And the other third party who played a larger role, Jason essentially sat, while he was inside the pawn shop, he sat lookout So all accounts, undisputed evidence is that he sat there and looked at the outside and never really knew what was going on. The other person that played a larger role has been released.
Yeah, so maybe that's that. I knew there was a story there.
That's
so
where it
thanks,
was.
Yeah, thanks for clarifying
Sure.
it. But again, that's a failed system. If someone, if that's an undisputed fact, and I'm sure
Yeah.
it is. I mean, I'm sure that you've looked at the transcript and things like that. So assuming that's undisputed facts, I mean that's a failed system that a law that was made back in the mid-'90s, I believe 1995, if I remember correctly, that would preclude Jason from being eligible if the state of Texas has made a decision based upon a review to let someone be dismissed. So anyway, thanks for your work in this regard.
Thank you for being
Sorry.
here. Appreciate
I'm
it.
sorry, Mr. Chairman.
Oh, I'm
I
sorry. Yeah, Ms.
had
Moody.
one more question, or a few. You mentioned during your testimony, this is something that has been a part of the legislative conversation for
8 years?
8 years.
Speaker.
I know there was a question about population that's impacted by a bill like this. Over those 8 years, has that impacted population increased or decreased?
It has largely stayed steady.
Mm-hmm.
These are mostly 90s cases. We're talking about during the era of the super predator.
So have we added, I guess the question is better put, in that time, has the state added a significant population that would be impacted by this bill?
No.
Thank you.
Anyone else? Okay. Thank you for being here. We appreciate
Can I add one? Can you ask me one question?
Okay,
Just a
quickly.
minute? I will say we have lost several. So during the 8 years in which this bill has been pending, we've had to bury many second lookers. One of the things our organization does is we keep a rock for every second looker with the idea that we always know where they are. One of the worst events that I have to do is when I go take the rock out of the vase because we've had to bury another one. So I urge you to act with due haste because these kids are getting old. I mean, you heard Jason is 47, not 46, but these kids are getting old and we are starting to see deaths happen.
No, I appreciate your testimony, and when Dr. Buckley comes back up, I'm going to talk about those 8 years and why we are where we are. So thank you.
Appreciate it, and I appreciate all of your leaderships. I feel like this is the panel of leaders. I appreciate you all.
Thank you very much. And remember, for the witnesses, we have 9 witnesses left. We had no witnesses against the bill. Everybody's for the bill. So if somebody's already said what you have to say, just say ditto or I agree with what's been said. So the chair calls Charlie Maloof. Okay, the affirmation shows Mr. Maloof testifying for Texas Cure and Self, and he in favor of House Bill 200. Chair calls Pamela Rivera.
Are we going to register him as not testifying?
Yeah, the prior Charlie Maloof, he's for the bill but not testifying.
Okay.
Okay, and then Ms. Rivera, or is it Dr. Rivera? Okay, Dr. Rivera, your affirmation shows you are testifying. You are here on behalf of the 10th District of the AME Church and Self, and you're for the bill, correct?
Correct.
Okay, thank you.
Good evening. Thank you for the opportunity to just share my thoughts. I am Reverend Dr. Pamela Rivera, an itinerant elder in the African Methodist Episcopal Church. I serve as a presiding elder of the Austin Capital District. I am a resident of Travis County, but my ministerial responsibilities cover Travis County, Williamson, Bastrop, Hayes, Lee, Washington, and Midland. I'm also here on behalf of myself and my family, of which we experienced a horrific tragedy when 2 juveniles took the life of my great-nephew. As a member of the clergy who teaches and preaches compassion and forgiveness, I was horrified. And as a mother, I was horrified at the thought of children as young as 14 convicted of a serious crime having to spend at least 40 years in prison before they're even up for parole. And there are many things that have been said, and so I will make my comments short. The incarceration of a child without hope for release sooner than 40 years, to me, is a mental and emotional cruelty that suppresses remorse and transformation. As a mother, a person of faith, I have witnessed the incredible ability of God to transform people to become anew and choose a new path. I would say that when my great-nephew was, life was taken, as we said in the trial, we witnessed two individuals. One was remorseful, the other was not, but we forgave them both. And I think this is a time for forgiveness and a second chance. But we have all sinned and come short of the glory of God. I hope you support this bill.
Thank you very much. Doctor, any questions? Thank you for being here. The chair calls Michael Waters. And Dr. Waters, it shows that you're here also on behalf of the Abundant Life AME Church and self, and you're for the bill, correct? Thank you.
That's correct. Mr. Chairman, Mr. Vice Chairman, and distinguished members of this committee, good evening. Again, my name is Michael Waters. I am a pastor in seventh generation Texan. Nearly 5 decades ago, a former U.S. Vice President offered these profound words: "The moral test of government is how that government treats those who are in the dawn of life, the children." It is painfully clear that we are failing this moral test as our children in our carceral system in Texas. Although the United States Supreme Court has ruled that children should not be treated as adults, in Texas they frequently are. In Texas, convicted children are presently forced to serve 40 years in prison without an opportunity to even be considered for parole. Not the guarantee of parole, just the consideration thereof, a second look. And the fact that the average life expectancy of a child sentenced to such extreme sentences is just 56 years old means that these sentences are practically death sentences. And giving death sentences to children is not a good look for Texas. Are we so cruel as Texans to hold children in perpetual contempt? So cruel as to not even consider the possibility that a child has changed course, that their 13, 14, or 15-year-old selves are worlds apart from their 33, 34, and 35-year-old selves? Are we to give no consideration that after decades of good behavior, despite obtaining degrees and receiving formal commendations for their leadership while incarcerated, that they have changed for the better and deserve an opportunity to appear before the parole board and state their case? Let's be clear. HB 200 is not a get-out-of-jail-free card. It is an opportunity to be heard. And an opportunity to be heard is not too much to ask for children. This is Holy Week, and Christians all across Texas will celebrate that God granted humankind a second look. We will celebrate this week the possibility that redemption, that even our worst mistakes do not make us expendable. I pray that we find the courage to look upon our children with the same compassion that God has looked upon each one of us. And certainly God has had mercy on our souls.
Thank you, Doctor. Any questions? Appreciate you being here. We have Tyler Clark.
Nothing new.
Okay. Okay. So we'll show Tyler Clark here on behalf of Epicenter Ministries and self for the bill but not testifying. And then Timothy Proctor. Your affirmation shows you here on behalf of yourself and Epicenter Ministries and for the bill, correct?
That's correct.
Okay.
Honorable many members of this committee, my name is Timothy Proctor. I am here today as an example of what a second chance can mean for formerly incarcerated youthful offenders such as myself. I served 27 years on a 50-year sentence for a crime committed as a 17-year-old. Confused as to what being a man really means. While in prison, I grew up and I learned what I truly valued in life: I began to be driven by those values that include freedom, relationships, family, career, and self-esteem. I obtained 2 associate's degrees, completed cognitive intervention, Bridges to Life, Voyager, and the ability to self-reflect on my past behaviors. Most importantly, I realized God was in control and began to let His Spirit lead me in the ways I should carry myself. It was this last transformation that helped me truly realize change in my life that would bring a peace that freed me from all the previous behaviors that resulted in suffering for myself and others. This transformation happened by a process we know as growing older and maturing. I am now a chief engineer at the most prestigious multi-use shopping center in Houston, the River Oaks District. I started out as a building engineer. I'm now over 6 of them. I work with property management, security, and yes, even HPD to ensure a safe and enjoyable shopping experience for thousands each day. I'm also over 7 construction renovations, all core equipment, including whatever the day may bring. I'm very proud to say I'm one of the core cogs that make up my property. Most importantly, I'm a family man, engaged to a college professor of 30 years. We have a great but challenging relationship that we foster together. I've been very supportive of my family, delivering a eulogy at my nephew's funeral, holding my mom's head on her deathbed. And I've also helped 3 men make the transition from inside, helping with spiritual, emotional, and career support. Things like telling them to hang in there, creating resumes, Indeed profiles, while leading as an example. I am happy to lead any programs in the Houston area to help these second lookers make the transitions as I have done. Thank you and God bless.
Thank you. Let me see if there's any questions. Yeah, hold on, come back. Can you mind coming back, Mr. Proctor?
I don't have a question. I just want to tell you, thank you for that you turned your tragedy into, or even like probably bad decision, into testimony. And I know that there are a lot of people that will listen to you because you've been there and done that. And so you're probably the best person to speak to these kids that they can grow out of being a knucklehead and grow into being a man and a family man at that. Thank you.
You got a good story.
Thank you.
Thank you for being here. Chair calls Jacob Reyna. Mr. Reyna, this show that you're here on behalf of yourself and Epicenter Ministries, and you're for the bill, correct?
That is correct,
Thank you.
Chairman. Thank you so much, Chairman, Vice Chair, and members of this committee. My name is Jacob Reyna, and House Bill 200, I am firmly in support of it, as up to as recently as 3 years ago, this would have directly impacted my life. June of 1996, 3 months after my 17th birthday, under the influence of peer pressure, drugs, alcohol, and not really knowing how to handle life itself, I made the stupidest decision I've ever made in my life, which was to commit the offense of robbery against multiple individuals. I was promptly arrested and given a bail of $250,000, which ensured that I would not be able to make it out. I confessed to my crimes, and a year later, I was given the punishment for my crimes, which was a total of 240 years in the Texas Department of Criminal Justice. It was all ran concurrent under one 50-year sentence, which would ensure that I would be eligible for parole after 25 calendar years. Not given parole, simply be eligible for it. That was a very difficult pill for me to swallow. I was forced to confront the consequences of my decisions, the pain that I caused my victims, the shame that I brought to my family, as well as the very real possibility that I would never make it out of that place alive. And so I had to live with that reality day in and day out for several years. A strange thing began to occur, though, in that time. I began to look and to think about things differently. I began to consider life differently. I began to look at things where I wasn't the center of the universe anymore, which was a radical change for me. The most important thing that affected my life in that time was that I had an authentic encounter with my Lord and Savior, Jesus Christ. And that changed the entire trajectory of the remainder of my sentence as well as my time afterwards. I did the 25 years by the grace of God. He saw me through it. He let me have favor. My last few years in, I was shown extreme favor where I was at, and I made my first parole by the grace of God. I was released July 2nd of 2022, and I've been free since then. But he taught me so much in that time that I was in that is now applicable in my life out here. Things like peace, like patience, which is especially applicable dealing with I-35 traffic day in and day out. But I will say this, my wife and I are youth pastors at our church now. We're involved in ministry opportunities. I'm working with the same job that I've been employed with for the last 2 years here in Round Rock. I will say this, my story, as unique as it is not the exception. Well, I'm not the only one. There are several others who
We
are given the
appreciate you
opportunity.
being here. Let me see if there's any questions, members? Thanks for coming here today.
My pleasure.
And
Thank you for the
we're
opportunity.
proud of you, too. Alicia Castillo will show, Alicia Castillo, we show you as here on behalf of the Texas Civil Rights Project testifying for the bill, correct?
That's correct.
Thank you.
Thank you. Alicia, Texas Civil Rights Project for the bill. Just we'll add a couple of things. Number one, I'm still getting familiar with the committee sub that I just heard in the layout, but our perspective is that because of just the basic incredible nature of this legislation that doesn't change based on the nature of the crime, we feel that there's no need for additional carve-outs in the bill, so would just recommend removing those if possible. Then also just want to note that when the Supreme Court decided that Graham v. Florida case in 2010, Texas chose the harshest alternative to a life without parole sentence at 40 years. There was no other state that went that harsh. I'll also add that the United States Sentencing Commission defines a de facto life sentence as 40 years. So we're still breaking with the goal of that Supreme Court decision by choosing 40 years and keeping it at 40 years. So not only would this align with constitutional standards, but also address practical concerns in the department right now as TDCJ is facing staffing shortages, these compromise safety and efficiency in our prison system. It's really important to make sure that we have safe release valves for those who have been rehabilitated, and we can alleviate the overcrowding and reduce strain on the prison system in Texas with bills like this. Thank you.
Thank you. Any questions? We like everybody else, we appreciate you waiting around and being here. The chair calls Justin Payne. Let me just say, it's sad that we're hearing this bill at 10:30 at night. It's a bill that deserved to be heard earlier in the day, and we apologize to all the witnesses. Once again, I've said this before, but to make y'all sit here and wait all day, we're sorry. And, it's late, and we don't absorb things as well late as we do early, but so I'm sorry it worked out this way, but it's something we didn't have any control over. So thank y'all for sticking with us. I'm sorry, go ahead. I'm showing you as Justin Payne, and you're here on behalf of the Word of Life Christian Faith Center in Buda, Texas, and also yourself, and you're for House Bill 200.
Yes, thank you, Chair and distinguished members of the committee. Thank you for the opportunity to speak today on House Bill 200. My name is Pastor Justin Payne of Word of Life Christian Faith Center. I was supposed to have Bible study tonight. This is the start of an amazing Holy Week. But then I got the call about this bill, read the understanding, had the conversations, and I had to stop what we were doing in order to submit to the state of Texas. That Proverbs chapter 17, verse 9 says, "Love prospers when a fault is forgiven, but dwelling on it separates close friends." It's something about the friendship of Texas. Tejas is supposed to be a friendship. It's supposed to be the understanding of that we are to build in relationships, build in the part of reconciliation. During that, this is the Holy Week. We celebrate in the Christian faith, and I like to submit to Texas that 67% of Texans identify with the Christian faith. That this is a state that should identify with reconciliation, restoration, and even the restoration of our children. When we have laws in place that create a place that children are the largest culprits and the largest population of crime and or sentences that last for longer than the offenders of even a couple months, that you can be 18 and get out sooner than you do at 17 for even the same offense. There's something that we need to be addressed and reconciled with that. Our society is something that we can always improve on. Do not always assume that the past is what we always stay in. If our God is always never changing, the one that should be changing is us. The more we learn about ourselves, the more we're revealed in about the nature of who we are and revealed in our Creator. He is the same yesterday, today, and forever. But at the same time, we are coming closer together in this time, in this season. I thank you for your time, and I thank you for this consideration.
Pastor, thank you. Any questions? Mr. Little?
The good book always does.
I'm coming to your church. You quit on time, you know? That's good.
Buda, Texas.
We do appreciate you being here.
Thank you very much.
Ruben, Brazil? And showing that, Mr. Brazil, you're testifying that you're on behalf of the North Houston District of the AME Church and yourself, and you're for the bill, correct?
Yes, sir.
Yes, sir.
So, good evening, everyone. My name is Ruben Brazil, North Houston District of the AME Church. Let me just say, it's no secret that the prison system is the #1 industry here in Texas. I don't know about you, but that's disturbing. It's embarrassing that Texas spends more money on incarceration than it does on education. And we're continuing to open more. It makes no sense to keep children locked up for 40 years before they can ever be looked at for parole. And generally, in the best of circumstances, they will be 57, 58 years old. Now, I know sometimes really bad things have happened, but how can we pretend that we are rehabilitating children when by the time they get out, they're trying to get an entry-level job when most people their age are retiring? So they can't find a job worth anything, which means they can't take care of themselves, so they can't contribute meaningfully to society, so they commit other crimes and get sent back to prison. It's a recipe for high recidivism rates and costs a great deal to taxpayers, when if they could at least just get a look at parole 20 years earlier, at age 37, 38, they could have a real chance of working, leading a meaningful life, and becoming a productive member of society. Not to mention the fact that it would reduce the cost of housing and caring for the inmates, which would save a great deal of money. Plus they would be contributing to the state tax revenue, as well as the overall GDP of Texas. We want the 10 Commandments in all classrooms, one of which says, "Thou shalt not steal." But we are stealing the very lives of those children under the current law. Let's live by the word of God that we say we follow. Amen? Amen.
Well, thank you for being here. Any questions? Thank you, sir.
Thank you.
So, anyone else here to testify for, against, or on House Bill 200? If not, Mr. Buckley, you want to close?
Mr. Chairman, members of the committee, first of all, I want to thank all the great witnesses that spoke with such sincerity. A father, skilled attorneys, making the arguments that I can't make, and then our faith leaders that really understand sort of, why we're here on this earth, I think, and one of those things is to try to fix things when they're just not right. And I think that what House Bill 200 does is it tries to fix something that's not right. I don't think it was concocted by folks with bad intentions. I think that what has happened is that science and progress has caught up, and we understand that the youthful offenders, need to have a fair shot after doing significant time, after proving that they've grown and that they've changed, to have the opportunity to go before a parole board and then let them decide what real justice looks like. And so it's an honor to be before you. This is a subject matter I don't get into often, but it's been great being here with you. I'd be happy to answer any more questions before I close.
Any questions for Mr. Buckley? Ms. Jones?
I just want to say thank you for bringing the bill.
Mr. Moody?
Probably not questions, more than just context for everybody, because I know that it was mentioned that this is something that's 8 years being discussed. I know Mr. Robinson's been here each one of those times. In 2019, a bill similar to this came forward. There was an issue, a very tragic issue out of Santa Fe that implicated the shooter in that case and how it tied to this bill. Offered to take all that stuff out of there, talked to Dr. Bond, and he said, this is very sensitive. I know you'll take it out of there. I know you fix it, but my community's suffering right now, and I'd rather just let this be. And there the bill stayed in committee out of respect for that community. In 2021, we came back, and we fixed that. And that was never part of this bill again. And we started anew, and that bill got to the governor's desk. And part of that language in the veto message, the governor stated that we should be commended for aiming to provide opportunities for the young offender population. And that the governor looked forward to working with the House to accomplish that goal. There was a very specific jury instruction issue, and then I guess that's what happens when you have a judge for a governor, that he said caused complications, and that was the reason for the veto. You see that fix in HB 200 today. In 2023, while no version of this bill ever has mandated parole, it has always been eligibility, a look, a chance. Inexplicably, there was confusion about that in the Senate, and there it stopped. I know, because I see you in this picture with Jason, that it won't matter how many times this takes to get this done, that you'll be in that fight. I know Mr. Robinson's going to be here until the last breath leaves his body. But for Jason, the time for him to benefit from this, to be given his second chance, is slowly running out every time these kinds of things happen. I'm really grateful for the work you've done on this, because this isn't what you signed up for. I'm sure of it, and it's probably not what you expected to do when you met with Jason and his father. But I'm grateful for the work that you're doing on it, and I hope that this time we finally get it across the finish line, not just for Jason, but those others that are like him, the stories that we didn't hear tonight. So thank you.
Thank you, Speaker Moody. Members, I humbly ask for your favorable consideration, and with that, I close.
Okay, if there's no objection, the chair will withdraw the substitute to House Bill 200, and we'll leave House Bill 200 pending for now. Is Ms. Garcia Hernandez?
Nope.
Oh, didn't see her. We're down to committee members. Mr. Verdell, he's not. Okay.
Strike his name.
Mr. Little, you ready on yours? Yeah. Okay. The chair would lay out House Bill 3362 and recognize Representative Little.
Thank you, Mr. Chairman. Thank you, members of the committee. This is not a simple bill. And ideally, we would not be starting this at 10:50 at night, because this is a complex topic and it's one that's going to require some nuance, and I'm sure there will be a lot of opinions about it. This is a grand jury proceedings reform bill. And I'm going to propose that we make some pretty significant changes to the grand jury process in Texas that are designed to bring transparency that we have not had yet in this state. To give you a brief overview of the bill, we're going to make some changes to Article 20A of the Code of Criminal Procedure. We're going to require, in the state of Texas, grand jury proceedings to be recorded. We're going to make sure that testimony presented by witnesses in front of a grand jury are recorded in front of a stenographer or by use of an electronic device capable of recording sound. We're not going to ask anyone to record the deliberations of a grand jury or anything that they're talking about, but if we have witnesses testifying in front of a grand jury, those should be recorded. They're statements that those witnesses should be impeached on. They should have that defendants should have the opportunity to see. You guys may have heard the old adage, you can indict a ham sandwich, and I think that right there is the problem. You truly can indict a ham sandwich. Unfortunately, a lot of the ham sandwiches in this state have looked like Governor Rick Perry or Kay Bailey Hutchison or Robert Chodey or Jason Nassour or Daniel Perry here in Austin. There are a lot of people that are being indicted based upon things that happen behind closed doors. And we ought to have an opportunity to see what those things are that are being presented. We're going to ask this committee to consider making a change to Section 20A.205 dealing with discovery of materials that are presented to a grand jury. We're not asking the legislature to vote on changes to the grand jury process that will invade the work product privilege of prosecutors or require disclosure of their discussions with various witnesses or victims. We will leave that to them. However, if there are offense reports, designated documents or papers arising from the alleged offense, written or recorded statements of the accused or suspected person or a witness that arise from the alleged offense, if there are books, accounts, letters, photographs, videos, other objects, a defendant ought to have an opportunity to see those things and have discovery of them. The idea behind this bill is to give defendants an opportunity to at least understand the circumstances that led to their indictment or led to the review of these matters by a grand jury. If you've ever represented someone who's been indicted, and you're wondering how a grand jury got to where they could get to the point where they could indict your client, now you won't have to wonder about that any longer. You'll at least have access to the same materials and testimony and evidence that the grand jury has to formulate a basis on which to indict your client, the defendant. This represents a significant change that would bring increased transparency and reform to the grand jury process in Texas, and I think it's an important one. Oftentimes, there are repeated attempts to indict individual defendants. There are presentations that are made to untrained grand jurors that work great injustice to the accused from time to time. This is something that should worry us as practitioners of the law, it should worry us as a legislature. We should give defendants the opportunity to see what's been leveled against them at the grand jury, and I don't think that that will impair or meaningfully impact a prosecutor's either right or ability to do what he or she is tasked with doing on behalf of the state of Texas. I'd like to have the opportunity to close. I'd like you to favorably consider what it is that we're presenting here and think through this very challenging topic with me as we approach the 11 o'clock hour.
Any questions?
Just got one. Oh, thank you, Mr. Chairman. I've just really one question. This will require a stenographic recording. It says or electronic device capable of recording sound, and then it says deliberations of the grand jury may not be recorded.
Yes.
I've never been in a grand jury, and maybe some of our other witnesses can talk to this, but do the deliberations generally happen separately in the way that somebody had to be sitting there with a button to turn on and off as they go? I understand what I think you're trying to accomplish here, but I do think that there's something sacrosanct about the grand jury deliberations that you agree with here. I'm just wondering in practice
sir.
how onerous that's going to be.
Yes, sir, I do. I think, first of all, I think it varies from place to place, but I think in many places, you'll see that the grand jury process is more informal and more deliberative as the prosecution and the grand jury essentially work together in real time on the project. I think as far as grand jury deliberations are concerned, and the grand jury decides we want to deliberate about this, turn off the recorder, court reporter, stop typing. Then you preserve whatever it is that's being discussed from the record and prevent it from being disclosed to a potential defendant.
So this is So just to clarify, this is not saying that the, nothing a grand juror says would not be recorded. It's just only when they're deliberating amongst themselves,
No, I-
because the grand jury can ask questions of the witness themselves, correct?
That's my understanding as well. I don't think that would constitute a deliberation.
Okay, I'm just, asking for clarification.
That's a fair question.
Okay, any other questions, members? Okay, we'll go ahead and call witnesses,
Thank you.
and certainly reserve the right to close.
Thank you, Chairman.
Chair calls Richard Hayes. Mr. Hayes, we show you your affirmation as speaking on behalf of Gun Owners of America and yourself for the bill, correct?
That is correct, Chairman. Thank you, Chairman, members. I won't cover kind of all the technical aspects that was discussed in layout by Representative Little, but there is an issue that comes up with affirmative defenses, especially self-defense, defense of others, defense of property, all these different contexts. And that is, these self-defense cases are all or nothing. A lot of them hinge on grand jury proceedings. And I think it's very important this early access to evidence really helps, the prosecutors control the narrative in these grand jury rooms. I was a former felony prosecutor. I indicted hundreds and hundreds of cases. I mean, that's true. The prosecutor controls the narrative. Where we have exculpatory mitigating evidence or even justification claims, there's nothing stopping a prosecutor. And I don't know many folks that do this, but I have seen it happen where the narrative of self-defense is completely suppressed. And I think it gives self-defenders an important opportunity to kind of correct that record. And for that reason, Gun Owners of America supports this bill.
Okay. Any questions, members? Ms. Jones?
One quick one. Do you think it's fair that the only people in the grand jury proceedings are the prosecutors and that the defendant has no right for him or herself or the lawyer to be in the grand jury proceedings?
I do not believe that is fair. I think there should be a level playing field. I mean, currently, defense attorneys will oftentimes submit grand jury packets. Sometimes those get shown to grand jurors. Sometimes they don't.
And Mr. Burdell?
Mr. Hayes, thank you for being here. I am still working through this bill, so I'm trying to figure out some things. I just want to say that I did serve on a grand jury. I'll probably never be invited back on it, but I asked too many questions. But I did notice that there was often only the presentation from the prosecution side, and you never got to hear anything from the defense side on that. But I appreciate you being here. Thank you.
Thank you.
Thank you very much. Anything else? Okay. Oh, yes. Mr. Money?
Do you think that there will be, I've never served on a grand jury, will there be a chilling effect on the grand jury with the idea that that what they're saying and how they're communicating is not just being recorded, but will later be discovered by the by the defendant?
I don't think so. As I read this bill, I still think it keeps sensitive information protected. I have seen that happen, though, in small counties. Folks know who's on the grand jury. They know when folks get indicted, and those are the scenarios where I see that coming up in more frequently. But I don't see that being as a major problem. But that's the current state of the law.
Another question. I should have thought of this when Mr. Little was up there. If you want to answer it later, you can. But if this is recording, could it be recorded in such a way that it just says grand juror and asks the question and not naming? I mean, the people who are grand jurors, I know they're not. In small towns, sometimes people know. Sometimes they brag about it at church or whatever.
Sure.
But generally what happens in there is private. Is there a way to maintain the anonymity of the people who are asking the questions in a way?
I imagine there would be, just like we do with a regular jury panel or a veneer panel. People are identified based on their juror number. Typically, the only person that you see is truly identified as the foreperson because they have to sign their name on things. That's my experience.
Okay.
Mr. Burdell?
Hey, I just have a follow-up question. Representative Jones pointed out something to me, so I'm just asking for my understanding. Is it the law that the defense doesn't get to mention have anything mentioned on their behalf in that grand jury?
So the defense doesn't have a right to access to the grand jury room at all. What you'll see, though, I mean, a lot of prosecutors are very forthcoming, honest, want to, get a just result, and they'll allow the submission of materials. Or I've had clients make themselves available to the grand jury. I've asked the prosecutor in good faith, hey, will you notify the grand jury that my client is making themselves available to testify before you? I'll say most of the time that gets communicated to the grand jury. Sometimes they request material. Grand juries can ask whatever they want.
Okay.
But, it just depends.
I think I'm the only non-lawyer besides Mr. Louderback up here right now, so.
Yes, Ms. Jones?
So it's just been my experience that I never suggest to my client that they make themselves available to the grand jury because I can't be there with them in the grand jury room to advise them. And the only lawyer there is the prosecutor.
Yep.
And that's fundamentally not fair because the prosecutor's job, if they're trying to get an indictment, is they think they did something. And in my regular life, if somebody comes up to me accusing me of something, they think I did something, I'm not about to talk to them. Right? And so, and you have a Fifth Amendment right to remain silent. And I think you should use it because the grand jury process as it is now is 1,000% swayed in favor of the prosecution. And all I ever do is do a grand jury packet. And I still am very rare with that.
Yep.
Super rare with that. So in any case, I just think that as a lawyer with my fiduciary duty to my client, that what lawyer is going to let their client who's not a lawyer sit with a lawyer and let the lawyer have their way with them and you literally can't be there to protect them. That just, I don't want to lose my law license.
What I would say is, 99 out of 100 clients, I would never make them available. In that very rare circumstance, maybe it's a police officer with a lot of preparation, how to stop questioning, exit the room, speak to your attorney. I mean, there are a lot of logistics involved, but it is not a typical scenario.
Okay. Any other questions? Okay, thank you for being here.
Thank you.
Chair calls Kyle Caruth. Now, Mr. Caruth, we've got you testifying on behalf of yourself for the bill, but I think I've got two affirmations here. Does the clerk have permission to delete one of those?
That's fine.
Okay,
Yes.
great.
Thank you.
Go ahead.
Well, thank you, Chairman and committee. I appreciate you having me up here this evening, and I'll try to keep this brief as well. I am here to testify in favor of HB 3362, and Representative Little, I really appreciate everything that you've done working on this. I will say that I have been through this process, my own. Some of you have heard a portion of my story before, but to very briefly wrap that up, I was involved in a self-defense situation on my farm where I ended up shooting an individual. And I was never arrested. I was never charged. There was a grand jury that was convened to review the facts of the case and to determine if there was any wrongdoing on my part whatsoever. Through this process, the family, the new wife of a month and a half of the man that had assaulted me and threatened to kill me and tried, immediately started putting pressure on the Attorney General's office to bring murder charges against me. And the Attorney General did, in fact, convene a special grand jury there in Lubbock and reviewed evidence for 3 full days in a grand jury, in a special grand jury. Following that, the jurors went back and deliberated for about 15 minutes and came back and unanimously no-billed me on all potential charges. And from my understanding, there were upwards of 17 potential charges ranging from murder 1 down to simple assault, down to negligent discharge of a firearm, and was no-billed on all counts. I did not get a hold of any of the information coming out of the grand jury until years later. There was a civil suit that followed, of course, and throughout the time, my reputation was tarnished and demolished because, as all of y'all know, as most of you are attorneys, you know, you tell your client first thing, do not talk. And so here I am, being quiet. Meanwhile, the woman that's suing me, who testified before the grand jury, is leaking information out of the grand jury to the public as well. It took 3 years, 3.5 years, before we got finished with the civil trial at all. But in that process,
If you could kind of wrap it up.
Absolutely,
We
yes,
got a
sir.
number of more witnesses.
absolutely, yes, sir. And I intend on testifying for yours too. So I will simply say that had I had the information coming out of that grand jury, I could have defended myself more vigorously, and I'll tell you more about it.
Okay.
Thank you very
Any
much.
questions, member? Thank you for being here. Chair calls Ross Jackson. And Mr. Jackson, you have testified you have registered on behalf of Texas Public Policy Foundation for the bill, correct?
Yes, sir.
Okay.
Thank you, Chair. My name is Ross Jackson. I'm a policy analyst representing the Texas Public Policy Foundation this evening, and I'm testifying in support. I want to thank Rep. Little for bringing this important legislation forward. There's much needed to reform the grand jury system here in Texas. I won't go into too much details because he did a great job laying it out. I just wanted to say that though grand juries in our state have historically been an integral insurant of due process from overzealous prosecution, they have heavily been tilted in the favor of the state and do not provide adequate protections for accused individuals. We, the Texas Public Policy Foundation, are supporters of transparency, better access to counsel for witnesses and the accused, and proper checks on the power of the state. This bill would require all statements made by the grand jury and prosecutor, including the examination and testimony, to be recorded. We're very supportive of that. We're also supportive of the state providing copies of evidence to the defense counsel. We believe this bill is a positive step towards promoting transparency, affording due process rights, and ensuring victim and witness privacy. Thank you for listening to my testimony today.
Thank you, Mr. Jackson. Any questions? Thank you for being. Chair calls Ray Hunt. And Mr. Hunt, you're registered as Executive Director testifying on behalf of the Houston Police Officers Union and yourself, and you're for the bill.
That's correct. I want to first thank Representative Little for bringing back up 3362. Pardon me, I've been here 15 and a half hours today in this building, so I'll be as brief as I possibly can.
We appreciate you
But I
doing
want to say
that.
this, that it's probably rare for y'all to have a police officer testifying for a loosened grand jury bill. And I think you're going to have two of us here today doing this. And I'm doing this because, as Representative Jones said, we didn't have police officers indicted for years in Harris County, and then we had a bunch of police officers indicted. However, we only had one police officer convicted, and that's because he was guilty. The other police officers were indicted simply because they were collateral damage from a vindictive DA by the name of Kim Ogg in Harris County, who indicted these persons simply because she believed that they had something to do with the wrongdoing of the one cop that was a bad guy. These persons were just indicted, but their lives were ruined for 5 years. One of them's marriage was ruined. All of them were financially ruined because the chief made them resign, but said, if you're found not guilty or get dismissed, I'll bring you back. And that was truthful. That is happening now because they were all dismissed. They were dismissed twice. The first time they were dismissed was from a judge who heard all the evidence and said, I'm dismissing this. The DA at the time, Kim Ogg, who had already lost 75% to 25% in the primary to another Democrat, went back and re-indicted them again because, as you said, anybody can indict a ham sandwich. We all chuckle about that or take it as gospel. We should be outraged by that. An indictment ruins people's lives for a short time. Look at this guy. He got ruined for several years. People don't forget that. This at least starts to level the playing field. This at least gets us the information quicker that we might be able to present to a judge and get that indictment stopped quicker than normal. So I'm asking you to please support this bill. It's very important to the 19 police officers here in Travis County that got indicted. Almost all of them have been wiped away now. One of them was drug across the Senate floor about 2 weeks ago because he had an indictment but was completely cleared by 3 senators, 1 from Travis County and 2 from Harris County. This is what's happened around here with an indictment. We're using it as a political tool, and it's wrong. And I'd encourage you to please support this bill. Probably won't make it out this session, but I hope it at least gets a lot of attention that says we got to do something about our grand jury system. Thank you all very much.
Thank you, Mr. Hunt. Any questions? Okay. Oh, Ms. Jones has a question.
I knew she would.
Who knew we'd be on the same side?
I can't believe it either.
So, when you talk about the grand jury And the grand jury, for people who don't know, if you get no bill, it's over. It's like the first door you have to walk through for the government to oppress you. And do you think that having the information earlier, like prior to, I guess, grand jury deliberations rather than later, could stop a lot of wrongful prosecutions before they ever get started?
Absolutely, because if it's a situation where you're going to get it in advance, and that's what his discovery allows for, that you get it beforehand, your packet that you talked about, our attorneys can put together a better packet to respond to each of those things that are in there. We had a situation in Fort Bend County where a Houston police officer was indicted, and the medical examiner said on audio that when she found out that he got an attorney, well, I'm just going to write it up as asphyxiation, let him prove differently. We didn't know anything about that until trial. That's why it took that jury 5 minutes to come back with a not guilty verdict. Yes, it's very important that we get that information beforehand or at least quickly afterwards so that we can start preparing for a defense because, like you say, anybody can get indicted. And his case, if they only deliberated 5 minutes, it's because the person that presented his case believed it and didn't want him to get indicted. But when the prosecutor goes in there and wants an indictment, they're going to get one 99% of the time, and you know that.
True story. Do you believe this to be true? That if you know you're shielded from anybody knowing who you are, anybody knowing what you say, basically under the cloak of darkness, do you think that creates an environment where people will always tell the truth?
Somebody made a comment about a chilling effect. I hope it does have a chilling effect. I hope it has a chilling effect that you tell the truth in there on every single thing that you say. And if you know that you're being recorded, you're going to tell the truth because you know that someone can come back and find out the difference and bring it up against you.
I think that'll chill some people, but there's some people who, when their lips are moving, they lying.
That's true.
And then I was going to ask one more thing. Do you believe that the Constitution's guarantee that you can confront the accusers against you, do you believe that the Constitution excludes the grand jury, or you should have that constitutional right during the grand jury?
Of course I believe that you have it during the grand jury, and I found out that grand juries have been around in the United States since about 1650. And the whole time for 1650, it first started out that they wanted the grand juries and they wanted to be secretive because they didn't want to embarrass somebody if they got no billed. We have DAs that run on a platform of, I'm going to indict this one or I'm going to indict this one. They're not trying to keep anything secretive. It's all out there in public. They like to a DA who hates the cops loves to go out there and say, I indicted a cop today. They do love to do that. And Kim Ogg loved to do that. Fortunately, we got a new DA in Harris County who is also a Democratic DA who saw the facts, the same ones that Kim saw, and immediately dismissed those charges when he was elected. Interesting.
Very. So, I'm glad we're on the same side. God bless America.
Okay.
Hell may have frozen over.
Any other questions, members? Okay, thank you. David Botsford? Mr. Botsford, show you on your affirmation as being here on behalf of yourself, and you're for the bill, correct?
That is correct, Chairman. David Botsford, Austin, Texas. I've been practicing criminal law 47 years. State system throughout Texas, all four corners, federal system, almost all four coasts and between. I have seen so much abuse of the grand jury system. I've represented Governor Perry in the grand jury process here in Austin. That was a tragedy. A tragedy. It ruined his potential election as president of the United States. There was no legal basis for it. The prosecutor did not give the packet that I prepared for the grand jury to the grand jurors. It contained 3 legal opinions, myself, Professor George Dix from UT, and George McCall-Sechrist from Houston, saying that the 4 areas that the special prosecutor was allowed to investigate, 4 different crimes, none of them applied to the conduct. And of course, the conduct was ridiculous. It was all based on Governor Perry's, one of his spokesperson, his press people, made a statement to the press. That article was published and it was misleading, but that's what sprung that investigation. Okay, it was a real tragedy. More importantly, you know, Governor Perry, he can survive that. It wrecks people's lives. I've had 2 clients who were sentenced to death. I didn't represent them at that time. I represented them after they had received the death penalty. Both of those clients were ultimately given new trials or judgment of acquittals after we discovered that there was evidence, exculpatory evidence, available to the prosecutor that the prosecutors did not give to the grand jurors. I've also testified before grand jurors, and let me answer one question. Yes, in federal system, when a grand juror, because they're all transcribed in the federal system, when a grand juror asks a question, it just says grand juror. Okay, the deliberations, the prosecutor leaves, and the court reporter leaves. So secrecy on the deliberations is essential. I appreciate your time. Open to any questions.
Thank you, Mr. Botsford. Any questions? Mr. Little?
David, I don't know who got you here at 11 o'clock at night on a whatever day it is, but using the word preeminent to describe you would be putting it mildly, and I thank you for being willing to show up.
It is my pleasure and honor. I appreciate you sponsoring this bill. I know there's another bill from the chair, and I'm in support of both of them. I probably shouldn't say that, but thank you. We need reform for the citizens. If a grand jury is supposed to provide a fair method for consideration of a person who's going to be charged with a felony offense, as our Texas Constitution provides, why not make the prosecutor give that information up so we can do our jobs and protect innocent people from being unjustly accused, whether it's political or the prosecutor's own animus against the individual.
Okay, thank you very much.
Thank you very much.
The chair calls Amanda Marzullo. We'll show Ms. Marzullo as registering for the bill on behalf of the Austin Community Law Center and self, but not testifying. The chair calls Lisa Moffitt. And Ms. Moffitt, we show you testifying on your affirmation as on behalf of yourself for the bill, correct?
Yes, sir. Hello, everyone. Thank you for being here so late, working so late. I thought only nurses did that. I am a critical care nurse specialist and a hospital administrator, and I am here tonight in favor of HB 3362. I'm going to make a 15-year story very short for you guys because you've all had more than enough. My husband in 2010 was accused by his ex-wife of molesting his children. Investigation happened. He took polygraphs. He took sexual deviant tests, all these other things, and it was dropped by Denton County and by the CPS people. So we rocked on with our lives, but it scared us to death. But we thought someday he'll get back together with his kids because none of that happened. It was malice on the point of the ex-wife. Almost a decade later, on September 30th, 2019, 6 police officers busted in our door. No Miranda rights, no warrant was shown. Took my husband, arrested him. We had no idea anything was going on. Anything was amiss. I had to call the first attorney that helped us to find out what was even going on. Well, someone had went to a grand jury, and they said the girls now are older, said they had repressed memories, jealous of our life, I guess. And if anything could go wrong, it did go wrong. We kept our first attorney. She was not the same as she was 10 years prior. The trial ensued, and my husband got 30 years with no evidence, no DNA, nothing but testimony. They said, your testimony is your evidence. And for a 57-year-old man, that's a life sentence. It was, that's death, basically. We lost our first appeal. It got kicked right back, and now we're working on the writ of habeas corpus. But I'm here to say if we would have known, if there had been some transparency, we could have maybe got ahead of that and fought, but we had no idea what was going on. So, thank you all.
Any questions for Ms. Moffitt? Thank you.
Thank you all very much.
Thank you for testifying.
Thank you for having me.
Next chair calls Jack Rohde. Mr. Rhodey, we show you registered as Jack Rhodey, Galveston County Criminal District Attorney, and testifying in opposition to this bill. Is that correct?
Yes, sir, that's correct.
You may proceed.
Thank you, Mr. Chair and members. Thank you all for hearing the testimony on this. This bill and the other bill that we'll be addressing later.
Make sure we only talk about this bill.
Yes, sir, thank you.
Thank you.
Does contain several different aspects, and I know some of my colleagues are going to testify too, so I'm going to focus my testimony on the discovery aspect of the bill. This is an area, you've heard the phrase that bad facts can make bad law. I think this is an area where we need to be careful that bad acts by some prosecutors doesn't end up making bad law. The concern about discovery in this process is that in some cases it would affect what has been considered a sacred confidentiality in the grand jury process, specifically when it comes to witness testimony. One of the very special things about grand jury testimony is that witnesses can be expected to come forth and testify candidly and truthfully without fear of retribution. It's helpful to look at cases in two different categories in terms of when they come to a grand jury. The large majority of cases are cases in which someone has already been arrested and charged by information, and that case is working its way through, and they have a constitutional right to have a grand jury consider the evidence as well. Those cases don't concern me with respect to discovery. It's the other cases that are when the grand jury is used as an investigative process and there are confidential investigations going on, that this discovery can create real issues. Disclosing discovery to a suspect who has not yet been charged in some of these very complicated cases runs an unreasonable risk of compromising the confidentiality of the investigation, compromising the integrity of the witness testimony, their truthfulness, in some cases compromising even their availability to show up and testify. It places an unreasonable risk on witnesses being able to come forward. We would ask that the committee vote not favorably on the bill, trying to abide by my time. Thank you.
Thank you for your testimony. Members, are there any questions for Mr. Rhodey? All right. Thank you for being here.
Thank you.
Next, Chair calls Philip Mack Furlow. Mr. Furlow, we show you registered as Philip Mack Furlow, testifying on behalf of yourself and the 106th Judicial District Attorney. Is that correct?
Yes.
And you're testifying in opposition to this bill?
Yes, thank you, Chair.
Yeah, please proceed.
Chairman Cook, members, I cover 4 counties in rural West Texas between Lubbock and Odessa, and believe that this bill would create a significant chilling effect on grand jurors' willingness to serve and their willingness to ask questions and inquire of witnesses. I always tell the new grand jury members when they come in, everybody in the county knows you're on the grand jury because your pickup's still at the courthouse. I have had grand jurors, I'm in my 3rd term, it's probably the 3rd session I've testified on some of these bills for grand jury reform. And I asked my grand jurors, would you feel differently knowing that your stuff is going to be recorded when you ask questions? And they're like, well, we're not going to ask questions if we're being recorded. Because I wanted their input on that. The oath of a grand juror says that they're going to keep it secret. The oath of a witness says that they're going to keep it secret. I've had grand jurors confronted at football games, grocery stores, asking, hey, why did you indict my nephew? The pat answer is always, by law, I cannot discuss that with you. Now it's going to be recorded and subject to review. And so I do think that would create a significant chilling effect. Oftentimes, I've had a number of officer-involved shootings. We've had sexual assault of child cases where grand jurors get to ask investigators questions about the case. If those are going to be used then later, I'll stop with that.
Yes, that's just a yellow light. Go ahead.
Oh, you know, it would create a significant chilling effect about how they inquire and converse back and forth with the investigating officer about the case.
Members, are there any questions? Mr. Money?
Thank you for testifying. I'm from probably not a county quite as small as the ones that you represent, knowing that you or take care of it since it's 4. But I have one of our fine district attorneys here today, and in smaller counties, it is a different environment for criminal law than what I think some of what we're talking about here. And I am torn between wanting to solve the problem that Mr. Little has brought and that we have heard, and also recognizing that in Sulphur Springs or in some of your counties, it is kind of like the 1600s where people just want to keep it private until we're sure. And where our DAs operate with a great sense of integrity, and none of them ran promising to take down some powerful political enemy as a part of their platform. And so, with that being said, is there a way, like I discussed earlier, that what happens in the grand jury could at least keep the grand jurors confident that their particular questions wouldn't be assigned to them? It could it be recorded in such a way, transcribed, so that they would know that there was a question asked, but they don't know Mrs. Jones or Mr. Johnson did it?
I don't know that you're ever going to get around that, especially in a rural community, because there's only 12. And I know Mr. Hayes, and he and I visited about this on occasion. You know, when you're in front of a large veneer panel for a regular jury, a petit jury, there's 120 folks, and they have a juror number and all of that stuff. And they're referenced to by juror number. When you've only got 12 in the room, I think I could do this. I think most of my local attorneys, if they know the 12 people that are on the grand jury, they can go back and they're probably going to figure out who's asking what question. And you're also probably going to have, I worry about the candor of the questions from the grand jurors if they know they're going to be recorded. Take a sexual assault of a child case. Okay, there's been an example of that. But if they're asking questions of the investigator, and you've got the CAC interview or whatever it is you're reviewing, and the grand jurors are asking questions about that, then that's going to be, part of the record for all practical effects later. And I do think it'll create a significant chilling effect on the grand jury's willingness to ask those questions and to consider those questions. And I don't know how you get around that. I just don't.
Thank you.
Ms. Jones.
Curious. And I'm not trying to do a committee substitute, but you're the prosecutor, I think you said, for 4 counties.
Yes.
Would you agree with me that the grand jury process as it is now is skewed in favor of the state?
I would not. The grand jury process is simply a confirmation of probable cause to proceed with an indictment. Again, we've seen bills like this presented before. If you want to turn the grand jury process into a mini trial, we're one of, 2 states that continue to use the grand jury process. If you want to turn it into a mini trial, do like they do in other states, charge it by information and then have a hearing in front of a judge.
So let me ask you this. Would you be opposed to defense lawyer being in the grand jury room when the grand jury?
I would.
And why is that?
So I've dealt with some really good defense attorneys over the course of my career, and I was in private practice before I became the DA. Anytime an attorney has brought a packet for me to present, I am more than happy to present that packet right alongside with the stuff from law enforcement. I've had cases result in no bills on occasion because of that. Here's the thing, I do not want to get stuck with a crappy case. And so when I say that, that basically means I want to make sure that when we have probable cause to proceed with an indictment, it's a case that I can go prove, okay? Beyond a reasonable doubt. The grand jury's only finding probable cause to proceed, but I really want more than that.
Right, but All I'll say is this, at least in Harris County, prior to the current DA, the DAs just was like trial by ambush. That's what they wanted, started in the grand jury, and my world's record for not guilty is 15 minutes. That should have never happened. I literally told the DA before, dude, you ain't got no case. And the system is so skewed in favor that she thought that it didn't matter. And so I just believe that it should be transparent. And you think it's just whether you have probable cause to proceed to continue in the case, but you're literally, somebody's got to go hire a lawyer, right? People some people can't afford bond, they can't afford bail. You literally destroy people's lives because they don't have access to information like early on rather than late. And I cannot tell you the number of cases that I've had. There's been just a masterful job of hiding evidence, and you have to give it to us like 10 days before trial. I mean, who can like adequately prepare for trial? But I mean, and I just think this is the beginning of the process. And if you are a prosecutor with integrity, that's great. Wish everybody was like you, but they're not. And I just think that the grand jury system is just too easy to manipulate and too easy to get people wrongfully charged, wrongfully prosecuted, wrongfully convicted, and it's super, 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 super important to undo it.
Okay. Thank you for being here, Mr. Furlong.
Thank you.
Chair calls Doug O'Connell. And Mr. O'Connell, showing you on your affirmation as representing yourself and you're in favor of the bill.
That's correct, Mr. Chairman. I'm a more than 30-year practicing criminal law attorney here in Central Texas. Half of that time was spent as a prosecutor, the other half as a defense attorney. Over the course of my career, I've seen the grand jury process be eroded, both in terms of due process and fundamental fairness. I'll give you a couple quick examples. In Travis County, there's a documented case where prosecutors ordered the chief homicide detective to withhold exculpatory evidence from the grand jury. There's another case that's also documented that the prosecutor's own expert witness that said my client was innocent, completely not guilty. The prosecutors refused to call their own expert witness into the grand jury room to testify. The perception in our community is very much that the grand jury can be manipulated to produce the result that the district attorney wants. That perception is so bad that we were able to convince a district court judge to do exactly what Mr. Little's bill calls for. We got an order from the district court judge ordering the district attorney's office to record the entire grand jury presentation, all of the questioning, and everything involved with the exception of the deliberations. It's my experience that that was not overly burdensome on the district attorney's office. You can tell from the transcript that grand jurors were not intimidated. They asked all the questions they wanted to, and it worked perfectly. I'm in support of this bill. I think it's very much needed, and I encourage you to take this step. I'm happy to answer any questions you have.
Any questions for Mr. O'Connell? Thank you for staying with us and being here. The chair calls Michael Bullock. Mr. Bullock, we show you as here on behalf of the Austin Police Association and yourself, and you're in favor of the bill, correct?
Correct. I am the second half of the law enforcement presence today that's probably taking an unusual stance here, but we have had unique experiences related to the grand jury process, both as we have tried to fulfill our law enforcement functions and also as officers who have indeed been targeted by a DA who, I'm going to steal your phrase, Representative Jones, it's indictment by ambush. And on the investigative side, what we have seen is investigators are trying to prevent complete information to a grand jury to make sure that they have all the information related to a case. That includes information that could potentially be favorable to the defendant, but also favorable to the state. And the detectives have been ordered that they will not present certain information. They were ordered to remove that. And the only reason we knew about that was because that detective had the courage, the wherewithal to stand up and to say that that was actually tampering with evidence and move forward in trying to bring that to light. Now, ultimately, he paid a hefty price for that because he was willing to stand up. And then on the flip side of that is where you've heard it mentioned today. We've had officers that, in Travis County, we've had the highest number of officers indicted here in Texas. And of that, the majority were dismissed. They were held under an indictment as hostages, as political hostages here in Travis County because it fit an agenda. And we've had other cases where an officer was involved in a use of force incident. The previous DA, had issued a declination letter saying that there was no criminal offense, there was nothing here, and then the subsequent DA, our current one now, Mr. Jose Garza, came in and decided he thought otherwise and took it to a grand jury and was able to obtain an indictment. Usually we don't see anything that's being talked about. We don't see what information is being presented to the grand jury. And like I said, it's occurring on both sides where detectives are being hampered from doing their job and officers are suffering the consequences when a secretive process is being weaponized effectively against them and others.
Thank you very much. Any questions for Mr. Bullock? Thank you for being here.
Thank you.
Is there anyone else here to testify for, against, or on House Bill 3362? If not, Mr. Little, you wish to close?
Thank you, Chairman Smithy, fellow members. I was struck by some of that testimony. Wrote a couple things down here I just want to note. The grand jury was earlier referred to as an investigative process, and I've been searching and searching through the Code of Criminal Procedure, and I've been unable to find where the grand jury process is an investigative one. I turned back, I took a look at, I listened to some of the testimony that was offered here, and I came away with the impression that the district attorneys wanted us to please think of the grand jurors. Please think of the process and how it might prevent them from asking the questions they want to ask, that they might be confronted at the grocery store. And my thought was, this is probably a thought that you would have if you were not the ham sandwich, if you were not the person being indicted with your freedom on the line. There was testimony that was offered about the oath that's required of the witnesses and the grand jurors, that they are going to maintain the secrecy of what they're doing. I want to read to you, this is Article 20A.256. This is the witness oath that's required to be taken. It says, you solemnly swear that you will not reveal by your words or conduct and will keep secret any matter about which you may be examined or that you have observed during the proceedings of the grand jury, and that you will answer truthfully the questions asked of you by the grand jury or under its direction, so help you God. It's a very important oath. The problem is that it just doesn't matter if they fulfill it or not, because we will never know unless someone records it and we have access to that testimony so someone can determine whether those prior statements upon which the indictment was based were actually, in fact, truthful. So I think generally this is a process that that needs to be the subject of some sunlight, and hopefully this bill will contribute some to it. And I close.
Thank you, Mr. Little. Any questions, comments? Okay, thank you. And if there's no objection, the chair will leave House Bill 3362 pending. Ms. Garcia Hernandez, you ready? And we apologize to you for being at such a late hour. I'm so sorry. We just had a lot of stuff. We didn't get started till late. So
No, that's okay. Thank you
the chair
so
leaves
much.
out House Bill 3358 and recognizes Representative Garcia Hernandez to explain it. And there's a committee substitute. And so, well, let's see. Mr. Cook will lay out the committee substitute.
Perfect. Thank you, Mr. Chairman and honorable committee members. I know it's late. Thank you so much for staying here and allowing me to lay out this bill. I appreciate this opportunity to present the committee substitute for House Bill 3358 today. Prosecutors are fighting crime in the courtroom, and in doing so must witness and expose themselves to evidence of violent and disturbing nature, while remaining objective in pursuit of justice and often serving as the only line of support for crime victims. However, unlike law enforcement officers, they cannot access critical mental health programs as outlined in Health and Safety Code Chapter 784, which allows for access to these programs without negatively impacting one's career. Lawyers are nearly 4 times as likely to suffer from depression from those who are non-lawyers, and also have tragically high rates of alcoholism and suicide. Access to this program would provide a critical lifeline for prosecutors. House Bill 3358 would expand the definition of emergency service providers to include attorneys, investigators, and other staff members of district attorney, criminal district attorney, and county attorney offices to this definition. Additionally, we added justices of the peace and their staff to participate in this program in the committee substitute upon receiving feedback that some rural JPs have to certify deaths in instances where other types of responders are unavailable. This is the sole change from the bill as filed in the committee substitute. The Justices of the Peace and Constables Association of Texas are in support of this bill. An expert witness from the Dallas County District Attorney's Office is present to testify for this bill, as well as Judge Mark Russo from Rockwall County and the Texas Association of Counties. With that, I'm happy to take any questions, and I reserve my right to close.
Okay, any questions? Yes, Ms. Jones?
Quick question, so the only lawyers that are prosecutors, or like people that prosecute, I guess first responders, sort of in the court system? Okay.
Yes, so as of right now, this is already a created program, and so what this bill will do is add an attorney, an investigator, or another staff member for the office of a district attorney, criminal district attorney, or county attorney, or a justice of the peace, or a staff member for a justice court. As of right now, the people who are enumerated under this particular bill are a law enforcement officer, a firefighter, an emergency medical services provider, a dispatcher, and a rescue service provider. So we're just, in our bill, want to include these individuals to have access to these particular services.
Thank you.
Absolutely. Thank you for your
Anything
question.
else? Yes, Mr. Riddell.
Is this your first bill to present?
It's not.
Oh, all right. Just want to say thanks for sticking it out with us. Appreciate it. I know what it's like to sit there and watch seniority take over. So
No, that's okay. Thank you so much.
She's an old veteran. Yeah, so, yeah.
Thank you, Chairman.
Thank you. Okay, and so we'll give you the right to close, and so we'll call our witnesses. Chair calls Judge Mark Russo. And Judge, I'm showing on here that you are Justice of the Peace in Rockwall, Texas, and you're here on behalf of the Justice of the Peace and Constables Association, and you're for the bill, correct?
Yes, sir. Thank you, Chairman Smithy, and fellow members. Thank you for sticking out tonight, and it's very important on this bill. I am representing JPCA. I am the judge advocate, and I have been a Justice of the Peace for 12 years. Oftentimes we talk about the first responder, but today I want to talk about the last responder. In many counties, 65 counties have only one JP. We act 24/7. We do magistrations. We are up at all hours of the night. We are there for our citizens. We make sure we are there to be there for our citizens to make the worst moment of their life as good as possible. But we often are so worried about our community, we don't take care of ourselves. Some lead to self-medication and maybe worse. But we think this is a great opportunity because a lot of people don't know that we are the ones at middle hours of the night with families who lost their children, fetal deaths, sometimes even rolling over their child. And we have to be there to hold that child. And then sometimes in cases like Wilson County and Waco, or actually in West Texas, when the fertilizer plant, it's impacting their neighborhood and maybe their own home. But they still have to put that face on to make sure that justice and families are taken care of. But in that, we forget ourselves. Thank you for this time today.
Thank you. Any questions, members? Thank you for sticking it out and being here today. Chair calls Jennifer Morse. And Ms. Morse, we're showing you with the Dallas County Criminal District Attorney. representing the county, representing the Dallas County Criminal District Attorney's Office, and you're for the bill, correct?
Yes, sir. Good evening, or is it almost morning? Pretty sure it's morning right now, but good evening, Chair Smithy and committee members. Thank you. My name is Jenny Morse, and I'm here representing, as you said, Dallas County District Attorney John Crusoe in support of House Bill 3358. A 12-year-old girl raped at knife point every morning before she goes to school by her father. A newly married woman kidnapped, forced to withdraw money from an ATM, and then raped by her two captors. A young man on his way to work at 5 a.m. T-boned by two street racers, his car exploding on a residential street as he was ejected across multiple lanes of traffic. These victims and their stories are ones that prosecutors across our great state deal with every single day. We pick up their stories, we study and replay the body-worn camera, listen to the 911 calls of the worst moments of their lives. We hold their grief during our trial prep meetings and during their testimony. We walk with them through their trauma, sometimes hand in hand into the courtroom where they sit 6 feet away from their abuser or sometimes their child's killer. Each of these actions is part of the job that we willingly take on a daily basis, but it comes with a heavy burden and secondary trauma. This trauma tends to show up in and outside of work. It may be an employee who takes their life, just as we've had in Dallas County. It may be a coworker who drinks too much, another one who can't sleep at night, or someone who needs countless hours of therapy just to manage the job. It's a reality of our job no one talks about. House Bill 3358 simply expands what this body did for first responders last session and simply adds secondary responders and JPs to the list of individuals eligible to create and have critical response and peer support teams within our offices under the protection of the Health and Safety Code. Thank you so much. We ask for your favorable vote.
Thank you for being here. Any questions, members? Thank you very much.
All right, thank you so much.
Is there anyone else here to testify for, against, or on House Bill 3358? There being no one, if you want to close.
Thank you again, Mr. Chairman and honorable members. We have a nationwide prosecutor shortage. Passage of this bill will help district attorneys, criminal district attorneys, county attorneys, JPs, and their employees all across Texas recruit and retain more staff. And it would help build upon an already proven lifeline for other types of responders to crime and public incidents. These public servants undertake a grave responsibility every day to keep Texans safe. Let's give them the support they deserve. Thank you, and I request your favorable consideration of this bill.
Okay, any questions from Ms. Garcia Hernandez? Okay, and we're going to let you go home and get some sleep.
Thank y'all so
You'll
much.
need it tomorrow, okay. Thanks. So if there's no objection, the chair will withdraw the substitute to House Bill 3358 and leave House Bill 3358 pending. Mr. Verdell, are you ready? I'm ready. Okay, the chair would recognize Representative Verdell to lay out and explain House Bill 2458. No substitute on this bill right now.
No substitute, no, sir. Thank you, Chairman. Thank you, members. Before I start this, I think this is my 8th or 9th bill to get to present, and I just want to say I'm extremely grateful to be on a committee with such a wealth of information and experience on here, so I appreciate that. And I'm not sucking up. But this bill is a really simple bill. We actually have a legal expert here that's going to testify on this more accurately. What this bill really is doing is, in the easiest way to say it is, if you have an attacker and you feel the need to brandish or draw your weapon from your holster, this bill is designed to help protect you from prosecution for that being taken out of context and punishing you. And so this is basically an improvement of the code. It's going to help self-defenders, and I really want to save it for our legal counsel because they're going to have a much better information on this. With that, I'll reserve to close. Thank you all.
Okay, certainly. And so the chair calls Richard Hayes. Mr. Hayes, we once again show you as representing Owners of America and yourself, and you're for the bill.
That's correct. So Richard Hayes, legal counsel for Gun Owners of America, testifying in favor of HB 2458. So what we're looking at here is the aggravated assault statute. There's a couple of different manners and means for aggravated assault, but the one that this bill touches is specifically has to do with the exhibition of a firearm. So aggravated assault is an assault plus some aggravating factor. So it could be a Class C assault, assault by threat. And we're talking about the exhibition of a firearm, not a use of a firearm. And so what we have and what we're seeing is this exhibition of a firearm. We're having this implied threat, this Class C assault, and then at the same time they're exhibiting. So we're saying, hey, guess what? The mere fact that you brandished a firearm is an aggravated assault. Now, and this is something that I hear all the time. We handle a lot of self-defense cases. You know, in Texas, if you pull your gun, you better use it, right? And why is that out there in the ethos? Well, it's because we treat brandishing a firearm, it's punishable as a second-degree felony, as an aggravated assault, as the same as if you shot the person and caused serious bodily injury. And so that seems to be misaligned. We want people to use the least amount of force necessary to stop the threat. We don't want to encourage people shooting people. If I can stop a threat by brandishing a firearm as opposed to shooting them, I think we should guide people towards that. This bill creates an affirmative defense that makes it clear, hey, guess what? If you are justified in acting in self-defense, if you're exhibiting the firearm as a threat under the aggravated, what would otherwise be an aggravated assault, you would have an affirmative defense to prosecution. So that's what this bill is, and we would urge your support.
Okay. Thank you, Mr. Hayes. Any questions for Mr. Hayes? We appreciate you being here.
Thank you.
Is there anyone else here to testify for or against or on House Bill 2458? If not, Mr. Burdell, you want to close?
Thank you all. I'm going to go with exactly what he said. And with that, I close for the sake of time. Thank you all. Appreciate it very much.
Any questions for Mr. Burdell? Okay. Thank you very much. If there's no objection, the chair will leave House Bill 2458 pending. There's no substitute.
Chair lays out House Bill 3664 and recognizes its author, Chairman Smithy, to explain the bill.
Thank you, Mr. Chairman, and I'll just briefly explain the highlights of the bill. First of all, it provides for a mandatory training for potential grand jurors. The training will cover the purpose, rules, selection process, and procedures of grand jury service. They will have the option for online training just to become familiar with the process. Number two, it prevents a grand jury from investigating an individual for the same offense that has been previously investigated without new evidence. Third, it clarifies that grand jury deliberations cannot be recorded. Fourth, it gives the accused or suspected person access to the state's documents, including exculpatory, impeaching, or mitigating documents in the possession of the state. And finally, number five, it allows a witness before a grand jury to be given an opportunity to retain legal counsel. So it is a significant change to the grand jury system, and we have several witnesses here, both for and against, who I think can adequately discuss the merits of the bill. So,
All right, members, are there any questions of Chairman Smithy at this time?
yes.
Ms. Jones?
If the witnesses have lawyers, are the lawyers allowed to go into the grand jury with them, or must they stay outside?
That's my understanding of the way the bills were, yeah.
Okay.
All right, any other questions for Chairman Smithy at this time? If not, we'll move to witnesses. Twice. All right, Chair calls Kyle Caruth. Mr. Caruth, we show that you registered twice. Do we have your permission to remove the second entry?
Absolutely.
All right, so we show you registered as Kyle Caruth, testifying on your own behalf, and you're testifying in support of HB 3664. Is that correct?
That is correct. I am testifying for the bill, and I would like to say thank you to Representative Smithy for bringing this forward. both of these bills, I think, are wonderful. And I'll keep this very brief. We've talked a lot about anonymity coming out of the grand jury system, and that was not at all my experience. The individual, the wife of the man that was involved in this, went in, testified in the grand jury, and immediately came out to the news and started saying whatever she wanted to about what was going on and what was being deliberated and who was testifying inside of that grand jury. I was never provided any of that information. She instead violated her oath of witness and did so with absolute impunity as well. She is also, and Representative Smithy, I appreciate this double jeopardy, or what I would consider a double jeopardy portion of your bill in particular, because one thing that this woman has maintained is that the moment that we have a new attorney general or even a new district attorney back in Lubbock, that she is going to pressure that district attorney or attorney general to bring murder charges on me again, even though I have already been through a full grand jury administered by the attorney general. She is still putting out false information about me, and I had never had any of the information coming out of that grand jury because I was not allowed in that grand jury. She heard much of this and took that information and spread it across Good Morning America, spread it across social media, did a 12-part miniseries on YouTube all about much of this information. All the while I was I was not allowed to have any of the information coming out of that grand jury and the culpability that she actually had in all of this situation.
Members, are there any questions for Mr. Caruth? All right, thank you for being here. Appreciate your testimony.
Thank you.
Next, chair calls Ross Jackson. Mr. Jackson, we show you're testifying on behalf of the Texas Public Policy Foundation in support of HB 3664. Is that correct?
Yes, sir, that's
Please
correct.
proceed.
Thank you. My name is Ross Jackson. I'm a policy analyst representing the Texas Public Policy Foundation, here to testify in support of HB 3664. Thank you, Chairman, for bringing forth this important legislation. I'll keep this brief. My comments are pretty much the same as Rep. Little's bill. Grand juries have been an integral part of our criminal justice system, but over time, their purpose as an ensuring of due process for the accused against frivolous prosecution has diminished. The Policy Foundation, in accordance with our values of freedom and liberty, support increased transparency, increased access to counsel, and proper checks on the power of the state. In addition to the provisions of Rep. Little's HB 3362, this bill requires jurors be properly trained, it bans the unjust practice of grand jury shopping, and lastly provides for the witness's right to counsel. We believe this is a great step toward promoting transparency, affording due process rights, and better ensuring the constitutional rights of the accused and witnesses. Thank you for listening to my testimony.
Members, are there any questions for Mr. Jackson? Thank you for your testimony. Next, we have Mr. David Botsford. Mr. Botsford, we show you testifying on your own behalf, and it shows you're testifying in support of HB 3664. Is that correct?
Yes.
All right, please
It
proceed.
is. Thank you. The grand jury system goes back to Athens. It was created back then, it was used back then, it's come through English to us. If the purpose of a grand jury is to provide a fair method for consideration of whether a person has committed a felony offense, then change is necessary. Understand that the Code of Criminal Procedure, the state of Texas, does not require a prosecutor to present any evidence to a grand jury. A prosecutor can get up and say, ladies and gentlemen, I've got an offense report. It shows that David Botsford is a drug dealer. I want you to indict him for a first-degree felony. End of story. Please deliberate on it. And he leaves the room. No recording. No record of what he said to the grand jury. No record of whether he has misrepresented to the grand jury. And the coercion of a grand jury by a federal prosecutor is what Rule 6 of the Federal Rules of Criminal Procedure was all about. That's why they transcribe everything in federal court, in a federal grand jury. Grand juror asks a question, it just says grand juror. It doesn't identify who she is. This bill is an excellent, excellent, transparent way to improve the fairness of the system. eliminate the predilections of prosecutors that want to get somebody when they don't have a real case. And understanding that in, yes, little, small counties, people talk, but you can't allow a prosecutor to take a case back to a grand jury a second or third or fourth time unless there's new evidence. It's fundamentally unfair to the person. And indictments destroy people's lives. And said enough. Unless there's any questions, I'll shut up and sit down.
Any questions for Mr. Botsford? Thank you for being here, sir.
Thank you very much. Appreciate it.
Next is Lisa Moffitt. Ms. Moffitt, we show you testifying on your own behalf and that you're testifying in support of HB 3664. Is that correct?
Correct.
Please proceed.
You guys heard from me already once. One more thing on my husband. He had no priors, no record, not even a speeding ticket. Second thing is I've been a critical care nurse for 25 years. I take care of open hearts, the sickest of the sick. I hold someone's life in my hands. Literally. The doctor's not there in the middle of the night or in the middle of the day. I am, and my team. You have to be transparent. You have to be honest. It's shocking to me as a layperson that in justice, transparency is not of the utmost in any subject, whether it be grand jury or anything. Why are there secrets in justice? We're holding people's lives in our hands just like these courts are holding lives in their hands. And that's all.
Thank you, Ms. Moffitt. We have Mr. Verdale.
I just want to say thank you for staying here and up to midnight to do that. I appreciate
You're
it.
welcome. Thank you all for being here. I know it's not easy work now that I've seen it.
Thank you.
Thank you.
All right, next we have Mr. Jack Rohde. Mr. Rohde, we show you registered to testify on behalf of the Galveston County Criminal District Attorney's Office, and you're testifying in opposition to HB 3664. Is that correct?
Yes, sir, that's correct. Jack
Please.
Rhodey, elected DA, Galveston County, respectfully testifying against the bill. The bill has many parts. I'm going to focus my testimony on the discovery portion of the bill, keeping in mind that the cases that come before a grand jury fall into two real categories. One of those categories is where a defendant has been identified, arrested, and charged, and he is pursuing his constitutional right to have a grand jury review the evidence. My focus would be on the other set of cases that come before a grand jury that are still in the investigation stage, where a defendant has not been arrested, and the concern over the effect of the discovery portion of this bill affecting the confidentiality of the grand jury proceedings and the willingness of witnesses to come forward and testify truthfully and candidly. Having to disclose information to an uncharged target of an investigation creates an unreasonable risk that subject would influence the testimony of potential witnesses, would affect the integrity of the investigation, would affect the truthfulness and the reliability of their testimony, and maybe even their availability to testify altogether. The targets of these complex investigations are often involved in organized crime, conspiracy, human trafficking, and gang violence. And the risks of the targets of those investigations using this discovery to turn around and intimidate or otherwise compromise the testimony of witnesses is too great. I understand that the purpose behind the discovery provisions is in response to bad acts by people within the justice system previously. The concern is that this is an overcorrection, that those bad acts don't justify this full swing to the opposite direction, and that too much unintended consequences would occur from it. So I respectfully ask that the committee vote against the bill.
Thank you, Mr. Rohde. Any questions? Ms. Jones?
I'd actually like to ask you a question. Would you agree with me that the Constitution gives an accused person certain inalienable rights, like the right to remain silent, those types of due process, those types of things?
The Constitution does grant rights, yes.
I mean, can you find a place for me in the Constitution where it says grand jury witnesses have constitutional rights?
I don't know that the Constitution addresses witnesses before grand juries.
I guess that's my question. Why, at least from the prosecutors here, have they somehow, it's like, ignored, I mean, and correct me if I'm wrong, ignored the Constitution and are trying to make the peace of mind of grand jurors more important than the right of an accused to have a fair trial and have and be able to confront witnesses against them, because the state has the burden. And so I guess that's why I'm conflicted.
Sure. Representative, I think I understand some of your concerns. The legislation actually creates more right to representation to counsel than the Constitution requires. Certainly, there is not a right to counsel of a witness who has been summoned before a grand jury, but this bill would create that.
Right, but I'm not focusing on that part of the bill. I'm focusing on the Constitution gives people who are accused of a crime by the government, because we gotta watch the government.
Agreed.
We cannot allow the government to just be unfettered against little old me or little old you. God forbid the government decided you did something even though you didn't. We gotta make the government follow the Constitution. And so what I keep hearing though is, oh, they're neighbors, the cars in the parking lot all day, we know you're a grand juror. And it's like we're giving grand jurors, I'm struggling with my words, which is unusual, because to me it just doesn't make sense that the Constitution says when you're accused of a crime, you get certain inalienable rights, and we're acting like it's the grand jurors whose rights are somehow more important than someone who have their life and liberty taken away. And so that's what I'm really struggling with. Help me understand that.
I sense your frustration, Representative, and I think part of the confusion may come from the fact that there are multiple aspects of the legislation that we have done our best to address in the 2 minutes that we have. And so because we've focused on some of those areas, it may appear that we're creating a preference for one aspect of this process over another. That's not true. Obviously, someone accused of a crime is entitled to all of the rights under the Constitution that they should be, and no prosecutor worth his or her salt would want to deny that. And I would add, there's been a consensus not a consensus, there's been concern over prior instances where prosecutors have used the grand jury process as a punitive means and have gone after someone. And I'll just tell you, that's wrong. Indictments are based on probable cause. And no prosecutor who's sworn to do justice is going to game the system to get probable cause, knowing, and I said if they're doing justice, knowing that they can't prove that case beyond a reasonable doubt. If you catch it, you clean it. Right? And if so, a prosecutor is going to go to all this trouble to indict someone, then they need to be prepared to take that case all the way to trial where they know they're going to have to prove it beyond a reasonable doubt.
Right,
Does that mean there haven't been abuses within the system? Absolutely not. But my concern is, and I think some of my colleagues' concerns, is that the way that these bills are drafted, the correction goes too far the other way and has the unintended consequences of leaving guilty people uncharged and putting public at risk and putting witnesses at risk. And so is there work that needs to be done? Absolutely. The concern is that this bill goes too far in some of those areas the other way.
So I'll end with this. You use the word preference. I mean, never will I say that a preference is more important than a right, than a constitutional right. I mean, that's why this country was founded, because the government lost its mind in England. I mean, we came over here and said, no, we don't want that. Right?
I agree.
We don't want that. We want this. And what I've heard is how uncomfortable it's making grand jurors, and discomfort for people who are charged with crimes is way worse than, why'd you indict my child? Right? So that's all I'm saying. I'm just struggling with putting something that's not a constitutional right more important than a constitutional right.
I understand.
Mr. Verdell.
Mr. Rohde, thanks for coming today. Appreciate you being here. So I'm the layman out of this group, but I have served on, I'm just honest, I have served on a grand jury, and my fear after participating in that grand jury is that if I ever were to be indicted or have let's say I were charged with something and it were brought to grand jury, my fear is that, just based on what I've seen, there's probably a 99.999% chance that I would be indicted for that. And so I would like, as a person who would be hopefully never, but would, be facing that, I would like to know that there is something in my power to be able to counter. I'm just, I'm assuming it's 99.9 or whatever. It's just what I saw was jurors on that particular grand jury didn't question anything and just went with whatever and billed everything. And so I'm trying to express as a person, a citizen, I would have some concern about if I were now having to have a case through grand jury to prove my innocence. I would, which I know the innocence part is in court, but I'm just trying to, for the record, state, I do think that there is something wrong when so many grand jurors just bow down and bill everything out without questioning it, and then there being no evidence for somebody to go back and see how that was handled. So. That's no question. I just wanted to make that public statement and put it to you. So
Yes, sir.
Yes, sir.
Did you want feedback or?
If you have feedback, I would love to hear it. Yes, sir.
Well, I guess, sir, a couple of things. One is that if grand jurors are blindly following the recommendation of a prosecutor, then they're not fulfilling their oath.
I agree.
Because the oath that they take says that you solemnly swear that you will diligently inquire into and true presentment make. And so it places the burden on each of these 12 ordinary citizens, just like all of us. And so to take part in this process, they have that responsibility. Can any process be abused? Certainly it can. So it takes everybody doing what they're supposed to do. That may be an area where grand juror training would help, to emphasize the fact that you are an independent investigative body. You have the right to summon evidence and witnesses and question them, and remind those grand jurors that, look, this is your oath and you have a responsibility to act. Maybe that will help address that concern.
Yes, sir. I appreciate it. I just like to state I'm trying to have a very open mind from
Yes,
all
sir.
sides of it so that I can get a good understanding of it. Thank you for your time, too. Appreciate you staying up here till midnight.
Thank you, sir.
Mr. Money?
I'd like to correct one thing. The Constitution doesn't give rights; it secures rights. Anyway, yeah, that's right. God gives us the rights, and the Constitution
Amen.
secures them for us. I appreciate you testifying here today, and I think I'm just troubled that a system that has generally worked for centuries. And still works, I think, in parts of the state of Texas quite well, has been so abused by a few in pursuit of getting their stats up, in pursuit of making a name for themselves, in pursuit of all of the horrible things that we've heard today. Or maybe trying to be overly compassionate to a victim and show that you've done something. I mean, it may not. But I would love to believe that there's still enough integrity in the profession, and just in, Texans in general, and that we have a fear of God and not going into a quiet, dark place, and not realize that the Lord is still watching and we need to be honest in what we do. But I also am confronted with the reality that is the world that we live in, right. and trying to balance all that. I think both Mr. Little and Mr. Smithy have given me a lot to think about between now and the time that we discuss this again. But I'm just, it really troubles me that we've been doing it this way for hundreds of years in order to protect the innocent, and now we have a problem within lawyers who are employed by the state. And who also take an oath, and are not providing justice to people, but are manipulating the system. And I think it's clear that is happening. Anyway, once again, that's a statement more than a
Yes, sir.
than a question. But I appreciate your testimony here today.
Any other questions for Mr. Rohde? Yeah, Ms. Jones?
Question for you. How long do your grand jurors sit together? How long is that?
3 months.
And so it's the same people that
But
come,
I should clarify, they meet once a week for 3 months.
right? So is it, because I've known people who are on grand juries, and for the most part, what I've heard from people, look, they wouldn't put me on a grand jury, but I don't know that I want to be on a grand jury, but where they're like end up being family, they talk, and they're like friends with the prosecutor, like the prosecutor that brings in the who is presenting evidence. They don't question them. It's like camaraderie, like there's pressure. And one grand juror in particular, and I don't know if you've seen this, said that when she first started asking questions, people were looking at her like she was crazy. Like, why are you asking questions? Why aren't you just believing the prosecutor? This particular grand jury, and she didn't go into detail, but she just said over time, she had to make them think. So I think training grand jurors would be good because they think they just have to listen to the prosecutor and basically, because she wasn't a lawyer, she just was retired from a government job, that they were intimidated by, I guess, what they thought was the intellect of the prosecutor, and they used them for guidance. And so then I guess if that's the case, which is what I've heard from people who I've known who've been on grand juries, how would you suggest we fix that problem when there's a camaraderie, and which means that they're closer to one side than the other. They're closer to the prosecution than the defense because there is no defense lawyer in there.
Well, I'll tell you one way that I address it in Galveston County. Whenever a new grand jury is impaneled, we have an orientation day, and we have different aspects of the process that we explain to them. And the first thing that I do is meet with them, and I have them go through this oath with me again, because they all took it, but probably none of them remember it. And
how do you pick the grand jurors?
Our judges do. And so grand juries are impaneled under the authority of a district court judge. So
it's got to be, see, and I'm like, what if you don't know a judge? Like, how would a regular person who doesn't have access and connections even be on a grand jury, which I think necessarily implies
that used
you're
to be a
not
problem.
being grand juror.
We're getting pretty far outside the bill, so
Okay.
just
To address that real quick, grand juries now in Texas are impaneled the same way that petit juries are. There's a general summons sent out to everyone based on voter rolls and driver's license rolls, I believe. And so everybody's called down, and you have to show up. And then the district court judge conducts basically a voir dire. And in Galveston County, it's everyone who's willing to serve and is legally qualified, then they're on the grand jury. The commissioner system has gone by the wayside, so it's no longer pick-a-pal. It's the same way that we impanel our petit juries.
Remember any other questions? I'll just give you one last chance. Are there any other specific recommendations that you would make to the bill?
I don't have any further recommendations at this point, sir, because there's so much.
Thank you.
But we're certainly welcome to work with anyone who would want our input on it.
We want your input, so yeah, send it to us. Thank you for
sir.
being here.
Thank you.
Next, chair calls Eric Carcerano. Mr. Carcerano, we show you registered as a Chambers County District Attorney's Office and testifying on the office and on your own behalf as an assistant district attorney, and you're testifying against HB 3664. Is that correct?
That is correct.
Please
That is
proceed.
correct, Representative Cook. And I know it's getting late, so I want to just
is
focus
late.
on a very specific portion of the bill, and that's what's labeled as Article 20A.257 in the examination of witnesses. And the particular language that we're
Mr.
concerned about.
Could I interrupt you one
Yes,
second?
sir.
I need to correct what I told Ms. Jones a moment ago from this section about the lawyer. There's nothing in the bill that specifically allows the lawyer to be in the grand jury room. In fact, it implies you can't. It just says before you have to testify, you have the right to retain and talk to a counsel before you go into the grand jury. So I need to correct that.
So to be clear, your lawyer can be outside of the grand jury room. So if you need to go out and talk with your lawyer, you can.
The bill doesn't speak to that. It just says that before you are compelled to testify as a witness, you should have a reasonable opportunity to retain counsel and consult with counsel before the person's appearance. So I think reading that literally, probably no. can visit with a lawyer perhaps in his or her office, and then you go testify to the grand jury. That's the way I would probably read that. So I apologize for the misstatement.
No worries.
All right, Mr. Carsano, go ahead.
I'm sorry.
No worries.
Thank you. So the particular language that I'm going to focus on, a person who is subpoenaed to appear as a witness before a grand jury shall be given a reasonable opportunity to retain counsel and to consult with counsel before the person's appearance. There are a load of issues with that language for prosecutors. There's some room for manipulation there, and there's no clarity on what the remedy would be. You have situations where if a witness is given a reasonable time to hire counsel and does not, what does the state do? What is a reasonable time? If we're getting down to the end of a term, or if we have a situation where we're coming up on a person's 90-day time limit for them to be indicted, you have these individuals that a magistrate has already set a high bond on for public safety reasons, and then we have this situation where sometimes it takes us, these offense reports don't just show up on our desk overnight. It takes law enforcement time to get these things to us. It takes time for us to develop our grand jury presentations. And we're having situations where we could run into situations where we have this witness and they say, I need time to hire counsel. Then we're bumping up against our 90 days. What do we do when we're bumping up against the end of a term? I guess at that point, we just have to start over. As I said, there's room for manipulation here. There's no clarity as to what the remedy would be. If a person said they wanted time to hire counsel and they didn't hire counsel, and we called them as a witness anyway, would that have some effect on our indictments? Like I said, this particular language, I think, causes more problems than it solves. And for that reason, that's my particular reason why we're against the bill, and I'll be happy to answer any questions.
Any questions, Mr. Carsano? Or if you would just would love to have any suggestions that you have to, if you'll get those to Mr. Smithy's office, and the chair recognizes Mr. Riddell.
Thank
Yes,
you,
sir.
Chair. I just want to say thanks for staying so late and testifying. Appreciate that. So.
We appreciate y'all staying here also. Thank you.
Thank you, sir. Next, we have Philip McFurlow, 106th Judicial District Attorney, testifying on behalf of that office and yourself in opposition to HB 3664. Is that correct?
Yes, thank you, Chairman.
Please proceed.
Again, I'm focusing on the recording aspect of the grand jury proceedings, and I am Philip McFurlow, 106th Judicial District Attorney, cover 4 counties in rural West Texas, and am against the bill. Again, many of the things that I've already discussed, we do think it would create a chilling effect on grand jurors conducting their obligations under their oath, which has already been read aloud and made a part of this record. Also just want to bring out that under the Code of Criminal Procedure, the current edition 20A-205, there is a right of a defendant for petition for disclosure. The defendant may petition the court to order disclosure of all information made secret under Article 20A-202, 20A-203A, or 20A-204. And so, there is that right in cases now if there is some reason or any particularized need that a defendant wants to bring to the court's attention. Again, I mentioned earlier, there's 2 different ways to proceed with a felony case in America. Some states utilize an information system where basically the DA just goes ahead and charges the case, and there is not a group of 12 citizens that reviews the case to make sure there's probable cause. In that, you result in a felony prosecution, period. Okay? That's just on the DA's call and law enforcement. In the state of Texas, we have preserved the grand jury proceeding to have a group of grand jurors oversee that process and make sure that there is probable cause.
Any questions for Mr. Furlow?
Thank you.
Thank you for your testimony. Next chair calls Will Ramsey. Is it Ramsey or Ramsey? Ramsey, okay.
Yes, sir.
Mr. Ramsey, we have you registered as 8th Judicial District Attorney's Office and testifying on your own behalf as well?
That's correct, Judge.
All right, and you're testifying against HB 3664?
That's right. Yes, sir. And the middle child in
Give
me
one
feels,
second,
yeah.
sorry. Okay, yeah, just testifying on behalf of the 8th Judicial District Attorney's Office?
That's right.
Please proceed.
I am testifying against the bill, and what I was about to say is the middle child in me feels the need very much to apologize to the chairman for testifying against his bill. But that is what I'm here to do today. I want to focus on a specific, y'all have seen how we've been dividing this up, hopefully not to repeat ourselves. I want to focus on this provision in the bill that says if a case is no billed, then it will never be presented again, absent new evidence that wasn't known to the state at the time. I want to tell you that a carte blanche rule like that could have overreaching effects. And I want to give you an example. We had a case that I had a few years ago that was an injury to a disabled person. And everyone, as those of you in criminal law can understand, and you know what I'm talking about, nobody in this case taught Sunday school. I mean, the victim, the alleged defendant, everybody was kind of, and the case got no billed. The case got no billed, and I went back, was having conversations with the victim after the case got no billed, and the victim was who the victim was, but the victim was also very sincere, and it got me to the point where I thought, you know what, I'm going to have you come in and talk to the grand jury if you want to. That victim did that, and that same grand jury that no billed the case, true billed the case. There was no new evidence. It was just presented in a different way. We wouldn't have been able to do that under this bill. I've had a grand jury that I've recommended no bill on a sex assault. They've talked to me about it, and I said, well, you know what, I am going to go sit down with this victim because y'all have problems with this. Went down and talked to the victim, came back to the grand jury, and I said, y'all are right. When you sit down and you talk to this person, this is a case that should move forward. My grand jurors have been, in my experience, very serious about their job, but there are also cases and situations where you do have crusaders that are not against necessarily facts, but a certain law, and that can convince people that no matter what the legislature has said about a law, you should not follow that. And I don't believe that's correct either. I think there ought to be room in the law for us to go back to the grand jury in the appropriate case. And so that's the issue I was going to address. Thank you.
Thank you. Any questions, Mr. Money?
I'd like to say that this is a great DA from Hopkins County, which is one of my counties, and he has talked to me about this bill before. And thank you for driving all this way, Mr. Ramsey.
Yes, sir.
I'd like to ask you a lot of the conversation, as you know, I mean, you've been sitting here all day, has been about the recording of the grand jury proceedings, and I just want to give a chance for you to explain why you're particularly concerned about that in a small town like Sulphur Springs.
I've discussed this earlier with other prosecutors, and I said, you know, you're in a difficult position to come in front of legislatures, in front of anyone, and say, I don't necessarily want there to be more transparency. That's a tough place to be. I understand the basis for what is being put forward in these bills. I can tell you, and I actually said this, I believe, to my grand jury last week in Hopkins County, this is what is being proposed. What do you all think about that? And I think one of them said, I don't want to put words, I believe one of them said something to the nature of, well, it's going to be a lot quieter. And I can tell you, when you do the training on the first day of grand jury and you tell them that what you say will be recorded, that is the portion that you're going to get some wide eyes of folks thinking everything I say in here could be recorded and then turned over to the defense. I do see that as a chilling effect on the grand juries. I can just see that adding to the reticence to be involved as they should be in the process.
Ms. Jones?
Did I open myself up there?
I don't know, did you? Why is a jury's reticence more important than truth?
It's not.
why should not a grand juror be able to be confronted, challenged, questioned about what they say, because their decision ultimately will decide whether a criminal case proceeds against someone. Why should, because they happen to fall in line where the grand jury falls, that they're above reproach? And that really was a question. It wasn't
No, yes,
rhetorical.
ma'am. Absolutely. And I believe that a grand juror's reticence is less likely to lead to the truth. In other words, I believe the grand jury feeling free, not worrying about, is what I say going to end up in the hands of this person and their attorney, is what I don't want a grand jury thinking a year, 18 months down the road to when they're on the witness stand. Because if we do this in every single case, as I know good defense attorneys will do, those statements will become an issue in the trial.
It's almost like the grand jury is like social media. I mean, like on social media, you have like the cloak of anonymity. People are like super brave when they can't be challenged. They think nobody knows who they are. And I don't think that fosters truth. I think that what's done in the dark should come to the light. And if what they do has integrity, then they shouldn't worry about it. Because even if you have to do something difficult, you should be courageous enough to do it. So
I completely understand what you're saying, Representative Jones. That has not been my experience with my grand jurors. The grand jurors that I've seen in the 3 counties that I represent are thoughtful, sometimes nervous, but thoughtful people about making the right decision. And we deal in this world all the time. You and I do. We're used to it. They are not. They really did not ask to be there. But I believe that the current system we have in place is a proper system to get to the question of probable cause moving forward, to get the case into court. But I understand what you're saying. Yes, ma'am.
reasonable minds can disagree.
Yes, ma'am.
But thanks for staying here this late.
Yes, ma'am.
Any other questions, Mr. Ramsey, Mr. Verdell?
Just me with my commentary. Now, I just want to say, I appreciate you staying. I'd like to point out, in my world, this is like 10 truckers asking a CMV inspector why he's giving tickets all the time. So I am enjoying this, but not in your, you know what I'm saying. But
yes,
I just wanted to point out the similarity here. So, yes, sir. Thanks for your testimony.
Appreciate it.
Thank you for your testimony.
Thank you.
Next chair calls Doug O'Connell. We'll show Doug O'Connell testifying on his own behalf. Sorry?
He had to step away.
Okay. Yeah, we'll show him as not testifying, but in favor of HB 3664. And last but not least, we have Michael Bullock. Mr. Bullock, we show you registered as the president of the Austin Police Association, and you're testifying in favor and support of HB 3664. Is that correct?
Yes, sir.
Please proceed.
No pressure, just the last one here, so I will keep it as brief as possible. But one of the things that I've heard is a lot about there's a select few that are causing a problem. But unfortunately, the reality is that the select few in 4 particular counties happen to represent over 30% of the population of Texas, and that represents a significant issue. And a secondary issue extremely important to law enforcement is a lot of what we are seeing with the grand jury process. And as officers are getting looped into this targeting system as well, is that we have people that don't want to join our profession. It makes it increasingly difficult to police. It makes it increasingly difficult to actually keep our communities safe. And I also find myself in a position similar to what you expressed, Representative Money, which is that you're trying to reconcile two differences. We're trying to work within the grand jury process because that is our sworn duty to uphold it, but then it's also a system that, though we are sworn to support and uphold, it is being turned against us, and it is one that is targeting officers now as well. A couple of the differences in the bills specific to this one that I do like as well is including training for grand jurors to make sure that they are educated on the system and providing representation to witnesses. From my perspective, our job as an association is to help provide legal representation to officers. And as they are becoming targeted, as they are being forced to do things at times that they do not believe is legal, them having the right to make sure they can consult with representation as well, I believe is something that is important. So I appreciate y'all's time in deliberating a very difficult topic, and certainly understand the differences that everyone can have, as well as the challenges in reconciling the needs versus the goals. So,
Speaker Moody.
You said the 4 DAs comprise how much of the population of Texas?
30%. Roughly 30%.
Is it 30%?
Yes, sir.
I'll just put this to you. This construct will be across the entire state.
Understand.
And of the 30% in these 4 DAs districts, the subset of cases that you're concerned about are not the entirety of what's done in those offices. 70% of the state, a construct like this that creates essentially a second trial is going to be used to undermine your colleagues in law enforcement across the state of Texas. That is the net result. And I think y'all should think about that.
With respect, it already is undermining our work at the moment right now. In particular, and I certainly recognize that this is here in Travis County, but it already is undermining our work here as we are trying to do our job.
You just said 4 counties, 251 other counties. This second trial process, which is essentially what this is, will be utilized by defendants of means to undermine your investigations in all those other jurisdictions. That will be the net result. I'm just telling you that's what will happen. So I get. I'm not challenging what's happening in the 4 counties. That's fine. I'm not challenging that. I'm saying that will be the net result everywhere else.
Any other questions for Mr. Bullock? Thank you for what you do on a daily basis, and thanks for being here tonight.
Thank you, sir.
Appreciate your testimony. Is there anyone else who would like to testify on, for, or against HB 3664? Hearing none, Chair recognizes Chairman Smithy to close.
Okay, and I close.
All right. I'll give it back to you.
Okay. And members, that, no. And so you will leave the bill pending, right?
Yes, and we'll leave House Bill 3664 pending.
Okay. And so members, thank you. That brings us to the end of the proceeding. So the committee will stand adjourned. We'll try to have a vote tomorrow, but we'll announce a formal meeting. So thank you. Thank you. Committee stands adjourned.